researchers, practitioners, students, and others. It's our honor and privilege to welcome you to the inaugural ceremony of International Symposium on Legal Mechanisms for Enforcing Sustainability Standards in Cross-Border Trade. We held from 23rd to 25th of January. This symposium is a result of a robust academic collaboration jointly organized by four prestigious institutions. First, the National University of Advanced Legal Studies, Kochi, established under Act 25 of 2005, NUALS stands at the intersection of academic engagement and judicial discourse. Situated here in Kochi, the seat of High Court of Kerala, the university is a UGC-recognized center of excellence, consistently working towards advancing legal education, research, and law reform. Joining hands with us is the Department of Studies in Law, University of Mysore. Founded in 1916 by the visionary Maharaja Nalpadi Krishnaraja Variyar IV and Sir M. Vishweswaraya, it is the sixth oldest university and the first in Karnataka. With a NAC A+ accreditation and a legacy spanning over a century, it remains a beacon of academic excellence in the cultural capital of Mysore. Its partners include UC Leuven, Saint Louis, Brussels, Belgium. Originally established in 1857, Saint Louis is a premier autonomous campus specializing in the social and human sciences. Located in the heart of Europe, it is an integral part of the University of Leuven, fostering critical research and interdisciplinary learning. We also have IEEE Saint Louis, Brussels, the Institute of European Studies, dedicated to the rigorous analysis of European integration and international regulatory frameworks. And finally, JSS Law College, Mysuru, operating under the aegis of JSS Mahavidyapita, established in 1954 by His Holiness Dr. Sri Shivaratri Rajendra Mahaswamiji. Spanning over 300 institutions worldwide, the institution is driven by the philosophy that the gift of knowledge is supreme to create a free and civilized society. Over the next 3 days, this platform will host rigorous dialogue on how law responds to one of the most pressing challenges of our time, aligning global trade with sustainability, accountability, and justice. At the outset, we begin the symposium with a shared commitment to knowledge, responsibility, and cooperation, values that guide both law and sustainability. To formally welcome the gathering, I now invite Dr. Minius, Professor at the University of Advanced Legal Studies, Kochi, to deliver the welcome address.
On the dais, colleagues, fellow delegates, and my dear students, a warm good evening to one another. It's my distinct honor and privilege to extend a warm welcome to you all to the National University of Advanced Legal Studies for the inauguration of this International Symposium on Legal Mechanisms for Enforcing Sustainability Standards in Cross-Border Trade. Today we gather to bridge the gap between commerce and conscience, exploring how law can ensure a sustainable future for global trade. This event is the fruit of a robust collaboration between NUALS Kochi, University of Mysore, JSS Law College, and our esteemed international partners, University of St. Louis University and Institute for European Studies. It's my pleasure to welcome our distinguished guests. First and foremost, I respectfully welcome our chief guest, Honorable Justice at High Court of Kerala. Sir, your vast experience in maritime and commercial law makes your presence highly significant to the theme of this symposium. We are grateful to I'm honored to welcome the president of this function, respected Registrar Leonard Kamathi ma'am, is always very supportive to all our academic and non-academic activities. Welcome you. Yeah, Chair. I also welcome our Honorable Vice Chancellor. Since assuming his office in May 2025, his dynamic leadership and academic vision have steered NUALS towards greater heights in legal research and education. So I also welcome Honorable Vice Chancellor, Professor D.P. Reddy sir. We are also equally delighted to welcome our guest of honor, Advocate Sri Vikrant Rana, managing partner of SS Rana and Company, New Delhi. As a leading authority in intellectual property and corporate strategy, the industry perspective will undoubtedly enrich our deliberations. I warm welcome to you, sir. Joining online. We are privileged to host a globally renowned scholar as our speaker. Very special welcome to Professor Dr. Nicholas De Sadele from University of St. Louis, Brussels. We are looking forward to your insights on EU environmental law and risk regulation. We also welcome our distinguished panelists for the symposium, Dr. M.K. Ramesh, Professor Vishwanath M., Dr. Sanjit Kumar, Dr. Sai Girmala, Professor T.N. Venkata Reddy, Professor Dr. Vasanta Kumar Timmakapura, Professor James Nedambara, and Professor Girish Kumar. They are going to deliver the lecture. So I welcome one of you. I also wish to extend a warm welcome to the coordinator of this symposium, Dr. Saeed Khatrat Hashimi, whose tireless efforts have brought this international platform to fruition. We extend a hearty welcome to the students joining us from once again on behalf of us and other collaborators. Thank you.
Thank you, ma'am. Dr. Minius is a distinguished academic with over 2 decades of experience in legal teaching and research. Her areas of expertise include competition law, constitutional rights, and social justice. She has served as a faculty at institutions such as CUSAT, the National Judicial Academy Bhopal, and Christ University Bengaluru before joining NUALS, where she has served as associate professor and professor. At NUALS, she currently holds key academic and administrative roles, including Director of the Center for Postgraduate Legal Studies, Director of Center for Competition Law and Policy, and Chairperson of the Board of Studies. Her extensive research and publications, particularly in the areas of governance, labor rights, public health, and access to justice, reflect a deep commitment to socially responsive legal scholarship. Thank you, ma'am. It's now my privilege to invite the President of today's inaugural ceremony, Dr. Leena Akka Matthew, ma'am, Registrar, NUALS. Ma'am has more than 16 years of teaching experience as a law faculty. She has graduated in law from Government Law College, Thiruvananthapuram. She had her post-graduation from National Law School of India, University, Bengaluru, and PhD from the Faculty of Law, Queensland University of Technology, Australia. She had, to her credit, many publications in the area of legal education, information technology law, and laws relating to women and children. She has assumed charge as registrar since 2023. May I now request Dr. Leena Akka Matthew to kindly deliver the presidential address.
Yes, the Honorable Mr. Justice Shyam Kumar here, Judge High Court of Kerala. Our guest of honor, Mr. Vikrant Rana, Advocate on Record, Supreme Court of India. Keynote speaker, Professor Dr. Nicholas De Sadele, full professor of the John Monet Chair, University Catholic Dinova, Brussels, Belgium, Professor Dr. Mini S. and Dr. Sandeep Hemed, Dr. Said Kudrat Hashimi, Dr. Bindu S., staff, guests, and students. I am very proud and happy that the National University of Advanced Legal Studies, Kochi, has joined hands with the Department of Studies in Law, University of Mysore, and GSS Law College, Mysore, to organize this international symposium on legal mechanisms for enforcing sustainability standards in cross-border trade. For decades, international law and international trade has operated on the premise of efficiency and cost reduction. Today, however, we can no longer ignore the environmental, social, and human rights costs embedded in the global supply chains. And we are transitioning from a world of voluntary corporate social responsibility to one of mandatory regulatory compliances. We need to ensure that the modern free trade agreements do not focus on lowering tariffs, but include compliance with international agreements on environmental law and environmental protection and the labor standards. Also, the legal framework should shift the burden of due diligence on companies by making it mandatory for companies to map the supply chains, identify risks, and foresee risks like deforestation or forced labor, and they should take active steps to mitigate these risks. So now there are mechanisms that are being discussed in our symposium, like the carbon border adjustment mechanism, which seeks to level the playing field by putting a price on carbon for imported goods, and harmonized international standards such as the ISO 14001, the Environment Management System Standard, which allow the formal recognition of green products across jurisdictions. Now, envisaging such standards in developing countries like India, where there are a number of small producers, is a matter that needs careful discussion. I congratulate the organizing secretary, Professor Dr. Vinius, along with Dr. Sandeep Hemed, for their great efforts to expose our students to think about the future of trade law, which lies in cooperative, transparent, and harmonized legal frameworks that balance our urgent need to protect the planet with the imperative of equitable economic development. Special congratulations to Dr. Said Kudrat Hashimi and Professor Dr. M.S. Benjamin, Dean Faculty of Law, University of Mysore, for their efforts that have culminated in this symposium. We understand that sustainability is no longer an option. It is the new foundation of the global trading system. So now let us enrich ourselves with the insights from our chief guest, Honorable Mr. Justice Shyam Kumar VM, our guest of honor, Mr. Rana, and the keynote speaker, Professor Dr. Nicola Sedelier. Thank you.
Now, we would like to invite Ms. Sarah Benjamin to introduce the chief guest. She will be joining through online.
It is my distinct pleasure and privilege to introduce our chief guest, Honorable Justice Shyam Kumar VM, Judge of the High Court of Kerala, whose presence today greatly honors this august gathering.
Reflects academic depth, legal excellence, and an enduring engagement with public law. We are honored to have with us the Honorable Justice Shyam Kumar VM, Judge of the High Court of Kerala. Born in 1973, his lordship obtained his law degree from the Government Law College, Ernakulam, and enrolled as a 1996. He began his practice under Advocate Sri T. Gopakumar in Thrissur, later training under Senior Advocate Sri S. Venkateswaran at the High Court of Bombay. Justice Shyam Kumar holds an LLM in Maritime Law from the School of Legal Studies, CUSAT, and has had a distinguished career spanning admiralty, commercial, and constitutional law. Formerly a partner at the Southern Law Chambers, he also served as an adjunct associate professor at NUALS, teaching maritime law and the law of the sea. He was sworn in as an additional judge of the High Court of Kerala on 22nd March 2024. I invite you, sir, for your speech.
Thank you, Gauri Parvati, for that introduction. Good evening to you all. President of this event and my good friend, Dr. Leena Akka Matthew, Dr. Saeed Khadrat Ashmi, who is a friend from Afghanistan. The main speaker whom we have today with us, Professor Nicola De Sagli. Ladies and gentlemen, my dear friends. Few days back, when Dr. Mini came to my chamber and invited me to be here with you all today to inaugurate this function, he had shared with me this pamphlet. I immediately said, after looking through it, that I shall be very happy to be here, in spite of the fact that Friday evenings are heavy days for a judge, for the reason that we get to sign all those documents and all those orders that we have rendered through the week. And to add on to it, we have some special day celebrations since the judge is retiring. But an invitation from NUALS is always a pleasure, especially for the reason that I understood law in my association with NUALS for the last around 10 to 12 years. I say I understood law for the reason that I studied law for 5 years somewhere else and also had a postgraduate degree in law from another university. But my experience as a teacher here, spanning around 12 years, opened to me the enchanting world of law. And I have some of my students here who would say that the association that I had with them was so enriching and it was a mutual learning experience. And I strongly believe that we tend to learn law more when we proceed to teach it to the students. Another reason as to why I said that I would be so happy to be here is the reason that I could find the JSS School of Mysore involved in this event. If my association with NUALS spans back to 12 years, my association with JSS is just since the last 2 years, because I had the occasion to be there and also get to know very well Professor K.S. Suresh and Dr. Vani Shri of JSS Law College. I had the privilege of being there a few times and I found the environment and the academic curriculum that they have there in the Law College to be very fruitful and informative and also knowledgeable. That would mean that the reason I'm here is mainly personal in nature. The topic of discussion that you have chosen here, though Professor Mini was kind enough to say that I will be able to contribute to it much, I should say that legal mechanisms for enforcing sustainability standards in cross-border trade, well, is known to me from the limited purview or sphere of maritime law, which is my subject. As a lawyer appearing for shipping companies over the last around 25 years, and as a faculty member teaching maritime law to different universities and law schools, I have had occasion to deal with certain facets of maritime law, which tend to be relevant to the area that is being discussed here in this symposium. I understand, as was pointed out by Dr. Mini, that now we live in an era where international trade coupled with sustainability seems to be the main point of focus, for the reason that we have reached a stage where climate change, pollution, and also other myriads of problems stare at our face, where rather than leaving it to the corporate goodwill to decide on sustainability, a legal mechanism has to be put in place so as to ensure that there is strict compliance when it comes to sustainability. I remember, as a maritime lawyer, I had an occasion to deal with the issue of ballast water management. Ballast water management is one of those areas where the ballast water, I don't know any maritime law students here except for my student who was there already. Any new maritime law students? Nobody here. So, online maybe. All right, okay. So, the ballast water management is, I personally find, a classic instance where the question of sustainability comes to the fore in a big way. Ballast, for your information, is that part of the vessel which is used for the purpose of giving the vessel stability and buoyancy. Formerly, during the times of sailing ships, we had huge logs or stones as ballast. These logs and stones would be positioned on the vessel in such a way that if the vessel carries its cargo, it tends to be light, and so the ballast would be arranged in such a way. And if once the cargo is in, then there's no need for ballast, so the ballast has to be arranged outside the vessel, hanging or in some other manner, so that the buoyancy and the stability is maintained. Now, in the present 20th century, 21st century, we have ballast of a different kind where impacts the vessel, positioned either in the aft or in the back of the vessel, whereby water would be pumped in and ballast would be maintained. If the vessel is here, for example, in Kochi, so as to take in cargo, the vessel might come in ballast. That would mean that the vessel would have the ballast tank full or as per the requirements. And once cargo is loaded in, the ballast would be pumped out of the vessel so as to ensure the stability. Now, where does sustainability come in? And where does marine environment and marine pollution come in all this is? When a vessel that comes to Kochi that takes in ballast, switches on its pump and takes in water from the Cochin backwaters. And it takes within itself, along with the water, the flora and fauna that is very endemic and peculiar to Cochin. So the small sea urchins, the crabs, the small brackish water octopus that we find here, and small fishes find themselves within the ballast water tank. And when the vessel completes its journey somewhere else, in some far off distant places, let's assume in New York, the ballast will be pumped out or whatever is left of it. So these organisms, which are peculiar to this part of the world, enter into a different environment. And over the period, the ballast water pollution that has created across the world is so substantial that we have now international conventions that deal with ballast water management, which would insist that if you are taking in ballast water from a particular area, you are supposed to disinfect it or neutralize it before you pump it out. My first instance or example where I encountered ballast was nearly 20 years back, when I had to defend a vessel that had deballasted. The operation of pumping out the ballast water is known as deballasting operation. So a vessel had come to Cochin so as to take in the cargo of naphtha, and it had deballasted. Earlier, the vessel was carrying a cargo of diesel. And so, since the valves that are there on the vessel and the pipes that connect these valves, they are the same. Many a times, the earlier cargo, which is the diesel, would end up in the ballast tank. And when the deballasting operation happens, it's pumped out into the backwaters. And then, this diesel being a highly inflammable thing, if at all there is a cigarette butt that is thrown into it, because the fishermen would be fishing there in country boats, it goes up in flames. And I still remember when I was a student in the government law college, sometimes during 1991-92, we had situations where the backwaters that you could see from the marine drive would be up in flames, nearly 2 or 3 story building high. Because this ballast, that is the diesel as the ballast waste, has escaped into the backwaters. Now, what is the remedy so as to prevent the pollution from ballast water? The remedy suggested, as I said, is to neutralize the ballast water. Now there is a problem. How do you neutralize it? One suggestion is you warm it up, heat it, and if you are not able to do that, and if all the organisms that are there are not neutralized, rather carry the ballast back to where you had collected it and discharge it there. These operations have substantial financial outputs. It would mean substantial amount so as to meet these requirements. So in spite of the fact that there has been an international convention on ballast management, water management, in India, we are still mulling over as to whether we should accept it into our local law. There I find something that is relevant for your discussion. This discussion on cross-border trade and sustainability standards. When on the one side, the international legal precepts would say that ballast water has to be dealt with responsibly, we find situations where a number of countries, many of them flag of convenience countries like Panama, Honduras, Liberia, St. Kitts, and others, struggling so as to insist as part of their local law this requirement, international requirement regarding ballast water management. Because if it is insisted as a part of the local law where the ship is registered, it would mean a substantial financial commitment for the ship owner. So that is why one instance which I would point out where personally I have come across this conundrum of how to meet these international standards which envisage sustainability in cross-border trade with the felt realities of the countries where this is to be implemented. I can give you 2 or 3 more instances from maritime law because that is the only area where I can claim to have some kind of a knowledge or expertise. Another instance I was just pointing out to Dr. Hashmi that there is a convention called Maritime Labour Convention, MLC. It is known as the Code of Rights of Seamen, which after maybe decades or rather centuries of struggle, the seafarers managed to put in place and insist as a condition which should be incorporated into their service contract when they enter for service on board ships. Formerly, I'm speaking of times when Vasco da Gama came here, or later during the 17th and 18th centuries when ship owners would take in only the convicts or those people who are on the wrong side of law as seafarers, because they somehow wanted to escape from their native place and they would not insist on any rights. They would work for some food or maybe a small share of money that would be ultimately realized when the vessel completes its voyage. So we used to have a saying in maritime labor law, which would go something like this. That is, freight is the mother of wages. We used to live in such an era where freight is the mother of wages, whereby it would mean that unless the shipowner earns the freight, the seafarer will not get any wage. The idea was that this will ensure that the seafarers work, and they would even risk their neck to see to it that the vessel completes its journey, for the reason that their wage would depend on the shipowner earning the freight. Freight means the carriage money that is realized by the shipowner as the consideration for carrying the cargo. So during those times, the rights of the laborers or the rights of the seafarers were even not heard of. You just have to read through the classics like Moby Dick or maybe Robinson Crusoe to understand the life of seafarers during the 17th and 18th centuries. Now, where does sustainability come in? Because we are here discussing about sustainability. This is a symposium on sustainability and cross-border trade. If I am a shipowner and I have a vessel, if I follow the mandates of Maritime Labour Convention, I have to ensure that all the seafarers on board gets, you would find it strange, hot water, clean water, good food, medical facilities on board, recreational facilities on board for seafarers. As a ship owner, I want my vessel essentially to carry cargo to its hilt, to the limit the safety would permit. And any reduction on any of these facilities would mean that I would be able to carry larger amounts of cargo, or maybe cut on my, or rather put some limits on the expenses that I may have to incur for the purpose of complying with the mandates of MLC. So from the profitability point of view, many a times it would be more attractive for a ship owner to decide to cut down on these facilities that are provided to a seafarer on board my vessel. Many countries insist that MLC, that is the Maritime Labour Convention, which elaborately provides for the rights of the laborers, should be an integral part of the service conditions or service contracts with respect to everybody working on board the vessel. Like, for example, we have a professor from Belgium. I understand that most of the continent, the countries insist that labor standards should be given very high respect. But in the peculiar way in which maritime world works, we have this, as I mentioned earlier, the flag of convenience situations where the Panama, Honduras, Liberia, we call it as the Pan-Hon-Lib countries, would rather choose not to be part of this international convention so that they will be kept out from the requirement of insisting on MLC. Thereby, ship owners would rather flock into these countries rather than registering their vessels in countries where MLC is a mandatory requirement. That is where sustainability and cross-border trade comes in. Now, where does sustainability lie in this issue? Should we be relaxing the norms so as to facilitate that? Like, for example, I can again go back to the ballast water management. Why is it that India has not yet insisted? We are in the process of doing it. I understand that our Merchant Shipping Act would soon incorporate this convention on the ballast water management. But why do you think that it is still not being done? Anybody? You are students of international trade, as I understand. Why do you think that countries dilute such requirements regarding sustainability? or carbon emission. Well, another area is MARPO from the field of maritime law, Marine Pollution Conventions. You have a bouquet of marine pollution conventions. Many of these conventions still remain, maybe complied with by the countries in the continent or in the Western Hemisphere, and others are still not able to do it for some compelling reasons. It's not as if they don't want to do it, but there are economic factors which prevent them from doing it, implementing it in their own country as part of their national law, for the reason that it might tend to have some kind of an impact on the feasibility or the profitability of the commercial venture. How do you get over such conundrums? Is something that I guess you will be discussing in the course of the next 2 days. We have the privilege of having Professor Nicola here, Dr. Hashmi is here, and of course we have Dr. Bindu. I'm sure that you will be engaging in a very meaningful and serious discussion in the course of the next 2 days. Let me tell you that after practicing as a lawyer for nearly 25 years, and now since for the last 2 years I'm a judge, I realize that many a times judges are confronted with questions for which we don't find answers from regular textbooks. Many a times, when confronted with such novel issues, we look for materials discussed in these kinds of symposiums, which are held by educational institutions like NUALS of JSS and the Mysore University. Because the essential aspects that we may require for the purpose of deciding the cases before us, we might find them in the discussions that you do. So please discuss and deliberate with seriousness, because what you discuss here today, what you deliberate here today, would give judges like me concepts and propositions which we may be able to put to good use when we confront with real life situations. As they would say, that the realist jurisprudence is again back. Who are the realists? Anybody? You have the Scandinavian realism and the American realism. Who understands realism? Who can tell me about realism? Anybody from here? I guess that you have all left your jurisprudence lessons way back, isn't it? So now you are in the postgraduate studies, so jurisprudence seems to be far back. Realists are those, is that school of thought who would say that the law in a statute book is just a dead letter word, and it's just a skeleton. And only when a judge applies it to a fact situation would the law be revealed in its all hues and colors. So statute law essentially is a skeleton, and the facts that are added on to it from a particular case, it adds the skill, the muscle and the flesh and the skin.
ठीक है, आप वाला इसमें लगा हुआ है,
What the laws.
ठीक है, ओरिजिनल। और बुकिंग के टाइम पे ये ले आना, बहुत जरूरी रहता है ये,
in the form of
और इसके अंदर बहुत सारी डिटेलें भरी जाएगी और ये शास्त्री की भी भरी जाएगी।
And I look forward to having a copy. And I would
डॉक्यूमेंट भी इसमें लगा के देंगे
to ensure that you send
आप ले जाओ अभी
a
फिलहाल
copy
किसी
of what we have
आपको व्हाट्सएप पे
deliberated
दे
in the
टाइम का लिखा
print,
टाइम का लिखा है कब तक गाड़ी
in the
टाइम
print,
में लिखा
not in
एज सून
online.
एज पॉसिबल लिखो,
Because many a times
ऐसा बहुत ही है
कब चाहिए आपको, हमको जल्दी से जल्दी देने की करेंगे कोशिश। आप बताओ आपने कब लिखो,
मई जून
we have an excellent library.
जून में लेनी है,
We
मई
have
जून मिलेंगे,
बड़ी आराम से मिल जाएगी तब तक तो।
as early as from the
जो तेजी है ना अभी गाड़ी की, वो अभी है 2 महीने की,
हाँ वो तो है।
deliberation,
फरवरी और मार्च,
the
उसके बाद
records
तो
of
ठंडा हो
your
जाएगा,
symposium,
फिर तो गाड़ियां हमारे पास इतनी बड़ी होगी, हमें ढूंढना पड़ेगी कस्टमर।
and at some point of time, some judge would find
मैं लिख
it
देता हूँ
relevant.
इस पे, as soon as
Something, some paper that you have produced and you have deliberated. I declare this symposium inaugurated. I wish you all a fruitful and
नवी नवी ये वाला कागज चाहिए आपको?
नहीं कुछ देखा है कहीं तो अच्छा
ठीक है सर,
ठीक है जी
आपके पास नंबर आ गई, कोई
We
इन्फॉर्मेशन
now
चाहिए मुझे कॉल करते
respectfully
रहना।
invite
ठीक है
the Honorable
थैंक यू
Mr. Justice to kindly light the ceremonial lamp. We are inaugurating our 3-day International Symposium on legal mechanisms for enforcing sustainability standards in cross-border trade.
लाइटा ए भाई
Now, I invite Ms. Sarah Benjamin to introduce our guest of honor.
It is my great pleasure and privilege to introduce our guest of honor, Advocate Shri Vikrant Rana, Advocate on Record, Supreme Court of India, Managing Partner of SS Rana and Co. New Delhi, one of India's most respected full-service intellectual property law firms. Mr. Vikrant Rana has been in active legal practice since 1996 and brings with him nearly 3 decades of rich experience in the field of intellectual property law. He holds the distinguished status of an advocate on record before the Honorable Supreme Court of India and is also a registered patent agent since 1998. His litigation and advisory practice span the Supreme Court, various high courts, and all major intellectual property offices and tribunals across the country. Mr. Rana has successfully represented clients from a wide range of industries, including pharmaceuticals, electronics, information technology, e commerce, and emerging technology services. Beyond practice, Mr. Rana is deeply committed to capacity building and awareness of intellectual property rights in India. He is closely associated with prestigious national and international institutions such as the WIPO, FICCI, TERI, and IAM Ahmedabad, and regularly delivers lectures and conducts training programs for government bodies, academic institutions, industry forums, and professional audiences. He is also a prolific writer and thought leader with publications in reputed journals including Legal Era, World Intellectual Property Review, and Managing Intellectual Property. His contribution to the book, A Practical Approach to Intellectual Property Law, has been widely appreciated by practitioners and students alike. In recognition of his outstanding contributions, Mr. Rana has received several accolades, including a nomination for the ILO Client Choice Awards and consistent listing in the WTR 1000 as a leading intellectual property professional. We are indeed privileged to have with us today, both physically and online, a practitioner who exemplifies professional excellence, thought leadership, and mentorship in intellectual property law. Please join me in warmly welcoming Advocate Shri Vikrant Rana, our guest of honor. Thank you.
Sir,
Yes.
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 Can you hear
Thank
me,
you.
sir?
Yes, yes, it's perfect.
Yes,
Thank
we
you.
will, sir, just 1 minute. We
Sure.
trying to share the projector. Here is some technical issue.
Sure, sure.
Yes. Yes. See. You want to see him? Yeah. Sir, you may proceed. Start.
Right. First of all, thank you so much for that kind introduction. It's always a pleasure and a privilege to address such an august gathering here. And heartiest congratulations to the organizers for a very apt topic, a very timely topic, which is of concern all around the world. And I would thank you to the organizers, Professor Nicholas, Honorable Justice Shyam Kumar, Mini Ma'am, Professor. Am I audible? Hello? Is it
Yes, sir,
audible?
yes, sir, you're
Yeah. Professor Mini and Professor Ashmi for inviting me to this conference here. And I think as Justice Shivakumar Shyamkumar mentioned, the reports from such congresses are indeed referred by judges when they're looking at setting precedents, and that is why I say this is very timely and urgent
Can you
need.
pause for 1 second?
Sure.
Yes. Can you speak again, sir?
Hello, is it okay?
Yes,
Yes,
sir.
sir.
Yes, you're
Okay,
right.
you can start.
Right. So, like I said, this is a very not only timely but also an urgent requirement there to look at legal mechanisms for enforcing sustainability standards in cross-border trade. With diminishing boundaries, global trade has emerged as the lifeblood of modern economies, but it also carries the burden of environmental and social externalities. When we talk about sustainability, then whether in forestry, fisheries, textiles, or technology, sustainability standards are increasingly shaping trade governance. Yet enforcement across borders remains a critical concern. So in today's cross-border trade, sustainability standards are enforced through multiple international frameworks and measures. ESG standards, for instance, are now an integral part of global trade as de facto regulatory guide with mandatory disclosures, due diligence, and compliance requirements that determine market access. In fact, at the G20 Summit 2024, the member states adopted voluntary principles as measures like favorable trade environment, right to regulate, coherence, multiple solutions, international cooperation. Further, the USTR promotes sustainability in trade by implementing environmental and labor standards into the trade agreements. Complementing these measures, the UN Forum on Sustainability Standards (UNFSS) also aims to enhance the growth of voluntary sustainability standards in global value chains through international cooperation. Some of the challenges we face are diverse regulatory regimes across jurisdictions, as ESG compliances varies widely across jurisdictions and creates an uncertainty for businesses. Additionally, at this point of time, many developing countries still lack the institutional infrastructure to monitor and enforce sustainability standards effectively. Uh, so the way forward, I would believe, would be harmonization of standards for aligning sustainability benchmarks across jurisdictions. We need to have them, more standardized and harmonized. Second would be courts and tribunals shall recognize sustainability violations as trade infractions and not merely as an environmental concern. So they have to go beyond just the environmental concerns, but as trade infractions. Third would be that technological innovations can be used for tracking supply chains for ensuring sustainability and ESG compliances. So technology, like in any other domain, it's also instrumental here in tracking supply chain for ensuring sustainability and compliances there. So I would say it's commendable to mention that the European Union incorporates sustainability standards and compliances in its trade agreements, and the modern EU agreements contain rules on trade and sustainable development. For instance, according to the rules in the EU's trade agreements, the EU and its trade partners must effectively implement environmental agreements, including implementation of the Paris Agreement on climate change, effectively enforce their environmental laws, combat illegal trade in threatened and endangered species of fauna and flora. So I believe this is a very important conference there, and I wish the conference all the success. Thank you so much.
Thank you, sir, so much for joining us.
Thank you. Thank you.
Thank you, sir, for your words. Now, I would like to invite Sarah Benjamin for inviting our international keynote speaker.
It is a great privilege and honor to introduce our keynote speaker, an internationally acclaimed scholar whose work has profoundly shaped contemporary thinking in environmental law, European Union law, and comparative legal studies, Professor Nicholas D. Sudlier. Professor D. Sudlier is a professor ordinaire and the holder of the prestigious Jean Monnet Chair in European Union Law at UC Louvain, St. Louis, Brussels, Belgium. He is also associated with the Université Catholique de Louvain, where his scholarship continues to enrich interdisciplinary legal education and research. A scholar of exceptional global standing, Professor D. Sudlier has served as a visiting and guest professor across continents, including Europe, Australia, China, Peru, South Africa, and the United States. His teaching and research span European Union law, international environmental law, comparative tort law, risk regulation, and public health and consumer protection within the European Union legal framework, areas that are increasingly central to global governance and sustainable development. He is a prolific author and a highly respected voice in legal scholarship, and he serves on the editorial boards of leading international journals such as the European Journal of Risk Regulation and the Journal for European Environmental and Planning Law. Beyond academia, Professor D. Sudlier has made significant contributions to law and policy making, advising institutions such as the European Commission and engaging with influential expert networks, including the Avesta and Client Earth, which are dedicated to advancing the enforcement and evolution of environmental law in Europe. Equally noteworthy is his role as a mentor and academic leader, having supervised doctoral research and contributed extensively to legal education at multiple levels. Fluent in several languages and deeply engaged with global legal discourse, Professor D. Sadlier exemplifies the ideal of a scholar who bridges academic rigor, policy relevance, and international collaboration. We are truly honored to have him with us today across borders and platforms, and we greatly look forward to his insights. Please join me in extending a very warm welcome to our keynote speaker, Professor Nicholas D. Sadlier. Thank you.
Thank you, sir. Sir, would you like to speak from here? Would you like to go to in the podium?
Gentlemen, my first day in India, already one lecture, and secondly, I have to be up to the standards after this dithyrambic speech from Missouri University. First and foremost, I would like to thank the Honorable Justice Sham Kumar from the High Court of Kerala and Shri Vikrant Rama, Advocate at the Supreme Court of India, the Vice Chancellor of your university, Mr. Reddy, whom I met earlier today, Mrs. Registrar Dr. Lina Akka Matu, Professor Mimi, who already introduced me to the students earlier today, Professor Benjamin from the University of Mysore, Professor Suarez, and last but not least, Dr. Syed Akwes Hashim, who contacted me 14 months ago to invite me to a conference, online conference he organized in Mysore regarding investment law. And it was a bit somewhat a domino effect, because that conference led us to co-organize a teaching program that was attended by Indian scholars from Fiji Islands to Oxford and across whole India. And I hope that we could build something with years upon that. And we engage in different conferences on the common agricultural policy here in the agricultural policy in India last December. So I feel honored to be invited here, and I feel particularly honored about your appointment as adjunct professor in this university. So I was really not expecting this. And so, given that I will hold two speech in the 2 coming days on more procedural and substantive legal arrangements, my introductory speech will be more touching upon policy issues. Firstly, I will emphasize the challenges faced by the European Union and uncanny constructions that unfolded after the Second World War, but that's a bit somewhat soul-searching today. Second, I will emphasize the strengths and perhaps also the weakness of India, and the synthesis will to explore the ways in which the EU and India could cooperate to a greater extent. So I won't delve into legal issues. I will be somewhat provocative, borderline, because as a lawyer, we are not supposed to talk politics. Europe is facing significant geopolitical tensions, beginning with the war waged in Russia in February 2022, and seems to be an endless war that's reminding us, in particular, the Battle of Kursk that took place last year, of battles that took place in Eastern Europe from 1941 to 1945. In addition, Europe has been paying somewhat a hefty price regarding the divisions of our communities with respect to the conflicts in the Middle East, from Gaza, Cisjordania, Lebanon, and Syria, given that European countries host important Muslim populations, and just a matter of the recognition of Palestine as a state in its own right has been extremely divisive. As you're aware, Ireland, Portugal, and Norway took the lead in recognizing Palestine, and that gave rise to much controversies in the other member states of the European Union to assess whether it was adequate, suitable, legally salient to recognize Palestine as a state in its own right. A conflict that's perhaps escaping many observers, but to which I'm more familiar because I've been working in the region even lately. It's the ISIS role in the Sahelian region, which is really not far away from the European continent, and the three coups d'etat in Mali, Burkina Faso, and finally Niger, that led to the ostracization of France, which has been the main actor in the former French colonies. And the importance of that conflict is clearly underestimated from a European point of view. The paroxysm was reached in April 2024 with the Liberation Day announced with fanfare by President Trump, that led to the tariff wars against the rest of the world, and in particular India. And although there has been a peace settlement that took place in England in July 2024 with a truce, of a gentleman agreement between the European Union and the USA in order to grant concessions to the American business interests. The vision of the President of the United States over Greenland, whether it's a question to purchase Greenland or to annex Greenland, as leading the European nations to oppose strenuously this unfounded vision. That being said, European elites are aware of a number of weaknesses. So, juris non calculat, as the saying goes, but it seems to me that number matters. If I look at the numbers of the 70s, the GDP of the 6 member states of the former European Economic Communities, Germany, Italy, France, and the 3 Benelux countries, amounted to 18% of the world GDP. Today, the EU reckons upon 27 member states, and the GDP, the part of the European GDP into the global GDP is still around the same levels. It means that globally, European economic activities have been somewhat declining. To make matters worse, we are facing a declining and aging population. And as qualified labor force contracts and retirees ranks swell, a growth in Europe is projected to decline. To make matters even worse, the conflict taking place in Ukraine has been highlighting our dependency upon Russian petroleum products. But that dependency has been replaced rather quickly by a new type of dependency to LGP gas imported from the USA. And this dependency is becoming critical whenever our relationship with the USA is under strain. The growth, in contrast to India or Indonesia, is somewhat slow, slow to barely 1% lately. We've been facing for 30, 40 years disindustrialization. So just 2 days news on Belgian TV is laying off 200 workers in steel mills in Charleroi, just 50 kilometers from my hometown, Brussels. There's growth in the service economy, but without the ability of the European companies to be the leaders in new technologies, in particular in artificial intelligence. And there we are suffering a very significant brain drain as India to the USA. The issue of defense, so if one looks again at numbers, the member states army did 27 members, 26 because Ireland is neutral. The Republic of Ireland is neutral. 27 member states armies are more important than the US army, but there is not yet any cooperation, substantial cooperation to operate efficiently the different troops as a matter of different technologies, different military equipment, also different languages, and in addition, different defense cultures. So it means that the absence of a unified European armies is weakening European defense. Europe is also the continent that's warming faster than other continents. In 2025, about 1 million hectares of forest were burnt. So one can imagine the strenuous ecological but also human consequences resulting from these wildfires. Northern Europe is not escaping, is actually subject to a significant rise of temperatures, translating into the melting of the permafrost. But perhaps above all is this constant soul searching. The European Union is not a country, is neither a confederation nor a federation. It's a sui generis association of 27 member states that succeed in achieving significant results as a matter of legal regulatory harmonization, but which is at pains in defining its integration. And as a result, Europe is more ever divided today than 20, 30 years ago, between poor and wealthy countries, between the West and the center, between the North and the South. And so the strenuous geopolitical tensions tend to exacerbate this quest for a new unity. But as you're aware, lawyers love to counter-argue, so I will play the devil's attorney's role. The EU has also a knack for rebounding whenever it's crossing significant tensions. Be it the financial crisis, the financial 2008 crisis led to the setting up of the banking union. The fiscal 2009, 2010, 2011 crisis led to a new approach regarding fiscal constraints, leading to the improvement as the member states' ability to avoid significant deficits and reaching budgetary equilibrium. The war in Ukraine and the tensions around the annexions by the USA of Greenland is obliging the European nations to envision a new defense line that will perhaps be separate from NATO. And so it seems to me that the response is both an internal response and an external response. Regarding internal measures, I would like to place the emphasis upon the willingness of the EU institutions to improve the functioning of the internal market. So the strength of the European Union is this freedom to transfer services, persons, consumers, goods, capitals, this freedom for companies to establish themselves wherever within the Union. And there is nothing similar, be it in Africa, be it in ASEAN, be it in Mercosur. And these other international organizations envy the success of a functioning. And in the aftermath of the Draghi report and the later report on the functioning of the internal market, there are many proposals of the European Commission on the tables with respect to the improvement of the functioning of the internal market, which entails the digitalization of the economy and the decarbonization of the economy. And so in the coming days, I will mention time and again, perhaps, the European Green Deal that led to the adoption of 170 directives and regulations encompassing conservation of ecosystems, zero pollutions, energy efficiency, as well as carbon markets. Improvement of competition rules with the Digital Market Act and the Digital Service Act, leading to penalize some American companies, like the ones of Elon Musk X, for breaching the European rules on the European market. The new migration deal that's decreasing the number of illegal immigrants. And that's just a few illustrations. But all in all, it seems to me that the European institution had always, at least so far, this ability to bounce back whenever the crises they face are becoming too significant. But Europe is just a continent, a small peninsula, comprising different sub-peninsula, that it's aging, that it's getting disindustrialized. And so what matters is also our relationship with the rest of the world. And again, when it comes to the breach of basic principles of public international law, or illegal invasion of Ukraine, a serious breach of international law with respect to human rights that are actually prosecuted by the Attorney General in Den Haag, the International Court, Criminal Court. The EU has been using its economic devices in sanctioning economically Russian leaders, Russian business, in freezing the 185 billion euros of the Russian bank in Brussels next to my university in Europe. So the funds are frozen. So clearly we, thanks to these economic instruments, one can understand the strength of the European Union in sanctioning a significant breach of international law. But that being said, we saw clearly these last 2 or 3 years the weakness of the European diplomacy with respect to the conflict of Gaza, where the US diplomacy has been prevailing, and also in the former Belgian colony, Congo, with conflicts with former British colony, Uganda. There's a significant Indian community, by the way, until 1974, until Ali Amin Dada threw away the Indian minority out of Uganda. And Rwanda was a former Belgian protectorate conferred by the Société des Nations in 1918. And so we have somewhat been excluded from the solution regarding these 2 significant conflicts. When it comes to climate change, that has already been mentioned tonight, it seems to me that the EU has, the main messages have been losing also their leadership. Thanks to the leadership in the mid of 2010, the Paris Agreement was concluded in Paris, and the European diplomacy as well as the French diplomacies have been key players in achieving that success. And so the position, at least of the European Commission, is to enhance the European position through international trade. Given that multilateralism has been fading away, and even more this since April 2025 Liberation Day, the vision of the European Commission under Leyen II is to enhance the trade cooperation with third nations. And the list of FTAs that have been concluded these last 10 years is somewhat impressive. South Korea, Japan, Vietnam, Singapore, Ecuador, Peru, New Zealand, new economic agreement, partnership agreement with Mexico, the signature of the EU-Mercosur trade deal that took place on the 9th of January in Brussels, and ongoing negotiations with Thailand, Indonesia, let alone India, which will be the topics that we shall discuss in the 2 coming days. But if you look at the picture, one clearly understands that there is no interest whatsoever for the Pacific and for African countries, which might seem to be somewhat bizarre. But just in case you are interested in history and geography, just look at a map on internet, 1910 or 1920 map of Africa, and we clearly see that with the exceptions of Ethiopia. Africa was a European colony. And so let's go to India. It's much more touchy because, as I stressed, it's my first day in India. India is the world's most populous country, with a workforce projected to grow into 2040, whereas the population everywhere else except USA is declining. India seems just to be partially shielded from demographic decline, raising its hopes to become the next rising power. Yet, India suffers a dearth of skilled workers. This problem is drained by a massive brain drain. India sends more skilled work migrants to advanced economies than any other countries on network. The India economy amplifies these weaknesses. Firstly, labor and industry remain constrained, in particular given the extent of the informal economic sectors that are not subject accordingly to taxation. Secondly, India's busiest harbors harbors only 1/7 of the volume of products that are traded in the Chinese harbor. So it means that China is still the bulk of the world economy when it comes to products, to export of products, and it belittles the position of the Indian economy. Thirdly, IT firms cannot absorb a vast labor force. And so the question is how to integrate into the economy the forthcoming generations of work. So, that being said, India will remain consequential for Europe for the influence of its diaspora. Just look at London, just look at the British economy, although the UK seceded from the European Union, but under Keir Starmer leadership, there are many attempts for reconciliation. Its strategic position between Africa, Eastern Asia, its vast market and its economic opportunities, a common history with Europe, or the British colonization of the continent, its level of growth, last but not least, its culture. And so, to conclude with, the question is how to cooperate. Is trade the only vehicle to improve our relationship? Is trade above all? Or is trade a vehicle to achieve common goals, be it sustainability, be it security, be it political partnership? And these are the questions that we shall address in the 2 coming days. And that's the ambiguities of these free trade agreements, because as the Honorable Justice stressed an hour ago, they encapsulate also sustainable development chapters, consumer protection chapters, labor protection chapters, environmental protection chapters. So it's much more than custom duties elimination, but it's how to strike the salient balance between public procurements, competition, working force migrations, and sustainability. And the question I shall approach will be twofold. I will address firstly quite technical issues, placing the focus on the institution EU arrangements when it will come to the negotiation between the ongoing negotiation between EU and India. So I will address this issue tomorrow. I will explain the respective powers of the European Commission leading the negotiation under the control of the Council of Ministers, the Council of Ministers that must take the decisions regarding the signature and the conclusions of the deal, and the role of the European Parliament. And I've been quite involved at parliamentary level this last month regarding the EU-Mercosur trade deal. 2 days ago, the Parliament decided a very narrow majority to request an opinion from the Court of Justice of the European Union regarding the compatibility of this trade deal and different sustainable mechanism and principle of precaution with the superior legal obligation enshrined in the treaty. So in about 15 months, 16 months, the General Assembly of the Court of Justice, or 27 judges, will have to render an opinion. In case this opinion is negative, the deal cannot be concluded. And for the second session, I will address more substantive issues regarding the inclusions of these free trade agreements, of these different sustainability clauses when it comes to climate, forest workers. But also I will address the different unilateral measures such as CBAM that have been criticized time and again by Indian businesses. And so let's look carefully at this. This is for lecturers, assistants, students in this university, a fantastic opportunity because the conclusion of such a treaty will surely impact the ways in which Europeans and Indians will interact, will cooperate in the forthcoming decades. And I wish again to thank NUALS universities for the organization of this conference and giving me the opportunities to share my thoughts on the subject matter.
Thank you, Professor, for the profound address. We'd like to hear more from you in coming days. Before we proceed further, I'd like to acknowledge the efforts of Dr. Syed Kudrat Hashemi, coordinator of this International Symposium, whose academic vision and organizational leadership have been central to its success. Dr. Hashemi, his distinguished career includes a pivotal tenure serving as a legal advisor to the lower house of the Parliament of Afghanistan. During this significant period from 2017 to 2019, he shouldered the solemn responsibility of guiding the legislative discourse, providing expert counsel to members of Parliament, and ensuring that the machinery of lawmaking adhered strictly to the tenets of the legality, fairness, and natural justice. Complementing this extensive experience in public law and governance is his stellar academic record. He is a profound alumnus of one of India's premier centers of legal excellence, the BA LLB at JSS Law College, Mysore, with first rank in 2017, LLM in international law with 3 gold medals with cash prizes from University of Mysore in 2021, LLM in IPR at the National Academy of Legal Studies and Research, University of Law, Hyderabad. It was within these hallowed halls that he secured his Master of Laws with first-class honors, specializing in the complex and evolving domain of intellectual property law. PhD in Law of IPR and International Investment Law from the University of Mysore in 2025 is also added to his credits. And Sir has coordinated 21 international conferences like this before coming to this institution. And with his jurisprudential command, which covers constitutional law, international investment law, and intellectual property rights, he stands as a testament to the power of combined legislative praxis with advanced legal research. We are indeed honored by his presence and his coordination to the symposium. Thank you, sir.
Thank you so much.
It's now time to formally conclude this session. I invite Dr. Sandeep Medanandakumar, Assistant Professor in NUALS, to propose the vote of thanks.
A very good evening to everyone who have gathered here. Let me start with a statement of a very famous, impactful statement of Mr. Peter Sutherland. He has said in his own words, society thrives because business thrives. Business thrives in turn because society thrives. And both thrive because human rights are valued and protected. They are mutually dependent. Borrowing his exact words, he has said, so that's how I see businesses. Not as faceless entities whose relationship to human rights consists of an episode here and an incident there. He has said, they are progressive wealth creators whose core activity underpins human rights. Honorable Vice Chancellor, Professor Dr. G.B. Relisa, respected Registrar in their absence, obviously, Dr. Vinayaka Matthew Ma'am, Chief Guest of the inaugural session, Honorable Judge of the High Court of Kerala, Justice Shyam Kumar Sir, Guest of Honor, Advocate on Record, Shri Vikrant Rana Sir, our distinguished keynote speaker, Professor Dr. Nicolas Sadler, Show on a Chair, Professor at St. Louis University, Belgium, Convener, Dr. Vanishri Ma'am, Principal of JSS Law College, Coordinator, Dr. Saeed Hashmi Sir, the Organizing Secretary, Professor Dr. Mini Ma'am, Professor of NUALS, other chief patrons and other patrons of this International Symposium, jointly organized by NUALS, Department of Law, University of Mysore, JSS Law College, and St. Louis University, members of the faculty who could be online, student participants from across the country, throughout the country. At the outset itself, let me thank both our Honorable Vice Chancellor and respected Registrar for motivating and facilitating all the faculty members of NUALS to have symposiums like these in addition to our regular teaching sessions, and ensuring the fact that through these symposiums and other conferences and seminars, NUALS is becoming visible not just at the national platform, but at the international arena too. I really want to say this thing in the Lordship's presence, but I couldn't because Sir left. Our chief guest, Honorable Justice Shyam Kumar Sir. See, though we generally say that it is very difficult, or rather, though we generally say that we do not get a redo option in life, primarily because we do not have an undo option in life. Rarely do people like me get opportunities to listen to the best teachers in the business. Like, for example, Shyam Sir. I still remember a particular point in my student life where I was literally stuck with regard to one of the important issues in maritime law. I was finding it a little difficult to kind of really understand what exactly was a peril. We talk about marine insurance, what exactly was a peril. And if X or Y is a peril, what exactly do we mean by hazard? Then comes Shyam Sir, a couple of days later, walking to the class, neatly, simply, without even realizing the impact that such lectures made to my life or to the lives of similarly placed students. He casually explained that, even without being asked, with the help of an example. In the context of marine insurance or anything else for that particular matter, if flood is a peril, your house being proximate to a river is the hazard. Days of confusion got over. Such a huge relief it was. But I am pretty much sure that Sir hasn't yet realized how easy the academic journey for us became, probably during and after Sir's lectures. And I'm pretty much sure that he hasn't realized how easy it has become only because of his exceptional teaching quality. In his absence, I also take this particular opportunity to thank him, thank your Lordship for graciously consenting to inaugurate this International Symposium and for setting the tone with the thought-provoking remarks. I also express my deep appreciation to our guest of honor advocate on record, Vikrant Ranasa, for kindly gracing this occasion. Your observations have added great value and distinction to this inaugural session. We are deeply grateful to our keynote speaker, Professor Dr. Nicholas Adelasa, for an erudite and engaging keynote address that illuminated the evolving interface between trade law and sustainability. The entire group here who have listened to your lecture or the keynote address is sure that this will undoubtedly enrich the discussions that are going to be followed tomorrow and day after. Thank you so much, sir. Dr. Saeed Hashmi, sir, I think I should be very genuine here. I think a substantial majority of the people in NUALS, not the students, know you by name. And thanks to Dr. Mini ma'am, because the credits that are due to you have reached you. The whole population, the majority of the population in NUALS actually know the entire tons of tireless contributions that you've actually made for ensuring the fact that this symposium is actually being conducted in this such a grand way. Thank you so much, sir. Thanks a lot. Thank you. Although thanking Professor Dr. Mini ma'am on her home turf might seem superfluous, but I would be miserably failing in my duty if I do not recognize, not me per se, the institution does not recognize the extraordinary effort and vision of the person who I can genuinely say is the brain and the backbone of this international symposium. I also take this opportunity to thank the management team of JSS Lokovich and Dr. Vanishri ma'am, the distinguished speakers and panelists for tomorrow and day after for their willingness to share their expertise and contribute to this important global discourse. I also extend our gratitude to Department of Law, University of Mysore and other management team from St. Louis University, Brussels, Belgium as well. Finally, I thank all the participants and delegates who are online for joining us and contributing to the vibrancy of the symposium. I hope the sessions ahead foster meaningful dialogue, collaborative thinking on strengthening sustainability standards in cross-border trade. To conclude, I extend our best wishes for the grand success of the International Symposium on legal mechanisms for enforcing sustainability standards in cross-border trade. May the deliberations foster meaningful dialogue, advance scholarly insight, and contribute significantly to ensure sustainability standards in cross-border trade. Let us all remember, when it comes to trade, an entity without responsibilities. I repeat, when it comes to trade, an entity without any responsibilities is no more sacred or accurate than the idea of unfettered state sovereignty. Thank you so much and all the best.
Honorable Vice Chancellor, Professor Dr. G.B. Reddy, Professor Nicholas Desenalier, Professor M.K. Ramesh, Jobin Thomas from JSS Law College, Dr. Hashmi, and other respected resource persons and dear participants. It's my honor and privilege to extend a warm welcome to you all to the National University of Advanced Legal Studies, Kochi, for the second day of the International Symposium on legal mechanisms for enforcing sustainability standards in cross-border trade. Today we are going to discuss and explain how to reduce the gap between commerce and conscience, exploring and how law can ensure a sustainable future for global trade. In the first session, we have Professor Dr. M.K. Ramesh, former professor at National Law School of India University, Bangalore. The second session will be handled by Professor Vishwanath M., senior professor and chairman of PG Department of Studies in Law, Karnataka University, and Professor Dr. Sanjit Kumar from West Bengal National Law University of Juridical Science will continue in the afternoon. And Professor Dr. Sai Repni Garimala from South Asian University will handle the last session. And in between, Professor Nicholas Deselel also will talk to us on this topic. So it's my honor and privilege to welcome all of you to this, all the resource persons to this program. Especially I welcome the speaker of the first session, Professor Dr. N.K. Ramesh sir.
They want to see this.
Over to you.
For the Zoom?
Yeah.
Not this.
So thank you.
Good morning.
Okay, we have to change it right now.
Good morning.
Go hit this 7 seconds. Go to the
Hello. Good morning to all our distinguished guests, respected speakers, faculty members, researchers, practitioners, and dear participants. After a thought-provoking inaugural day that set the intellectual tone for our symposium, we now have arrived at the day 2, where our discussions deepen into the institutional, environmental, and human rights dimension of sustainability governance, especially in the context of cross-border trade and regulatory enforcement. Today's sessions invite us to reflect not only on legal frameworks and treaty obligations, but also on how environmental justice, resource governance, and human rights intersect with trade regimes, an area where theory, policy, and practice must speak to each other with clarity and responsibility. Today, we are also joined by Professor Jocelyn Thomas, a representative from JSS Law College. He hails from Kannur in Kerala and serves as an assistant professor at JSS Law College in Mysuru. Professor Thomas holds a master's degree from the University of Westminster in London and has also practiced law at the Kerala High Court. It's therefore most fitting that we begin today with a scholar whose life work has shaped the environmental law and governance in India and beyond. It's my honor and privilege to introduce our first speaker of the day, Professor Dr. N.K. Ramesh. Professor Ramesh is a former professor of law at the National Law School of India University, Bangalore, where he served with distinction for over 3 decades and also briefly held office as Vice Chancellor of NLSI. With over 40 years of teaching, research, and public service experience, he stands as one of India's most respected voices in international law, human rights law, environmental law, and natural resources management. He holds a doctorate in law, a master's of laws, and a bachelor of science from University of Mysore, reflecting a rare interdisciplinary grounding that has deeply informed his scholarship on land, waters, forests, biodiversity, wildlife, and agriculture. Professor Ramesh is the founder of 3 pioneering centers of excellence at NLSIU, the Center for Environmental Law Education, Research and Advocacy, the Common Cell, and the Environmental Law Clinic, institutions that have shaped generations of environmental lawyers and policy thinkers. Internationally, he has served as a senior Fulbright Fellow in the United States, an environmental law fellow at the Environmental Law Institute, Washington, D.C., and as a visiting or adjunct professor at leading universities include Pace Law School, Warsaw, Zurich, Stockholm, Dalhousie, and IIT Kharagpur. Beyond academia, Professor Ramesh has played a critical advisory role in environmental governance, serving on expert committees of the Ministry of Environment, Forest and Climate Change, the National Biodiversity Authority, the Planning Commission, and the United Nations Environment Programme, including contributing to India's preparation for the Paris Agreement on Climate Change. He is also the founder editor of Indian Journal of Environmental Law, author of several books, and has published extensively on environmental justice, biodiversity law, waste management, and sustainability governance. Today, as we deliberate on enforcing sustainability standards in cross-border trade, we are privileged to hear from a scholar whose work bridges law, policy, institutions, and lived environmental realities. Now I invite Professor Dr. N.K. Ramesh to kindly take the floor and deliver his address.
Thank you. Very good morning to all of you. Very early morning for those in Belgium. It's a delight for me to be part of this 3-day International Symposium on legal mechanisms for enforcing sustainability standards in cross-border trade. Standards sustainable to trade through the lens of international trade law regime. That's the focus. And I'm very happy that 4 institutions are co-hosting it, 3 from India and 1 from Belgium. And since the focus is essentially on the trade law regime and the enforcement of the standards in 2 of the aspects of sustainability, that's what has been given to me here, of the 3, the environmental, social, and economic. I'm confining to the environmental and social ones, as has been assigned to me for the session. Standards for sustainability is what has been put together here. And what exactly is the kind of role of the World Trade Organization is in this regard is the issue before me. And I have put it as the gatekeeper's role of WTO in the enforcement of environmental and social standards. Since it's a very huge area, I just have picked one strand. And what exactly is this gatekeeper's role is what I'm just trying to elucidate in the limited time that I have at my command. I think I just have about some 8 slides I have put together to come within the confines of this time, in which I will come up with an opening remark followed by its adoption of the environmental standards, the way the trade regime has come up with, about some 2-3 slides on that. Then I move on to the social standards aspect, about a couple of slides, and what exactly you get out of this kind of an arrangement that you have. Are they really enforcing environmental standards and social standards? Or is it quite different from what has been perceived as those gold standards of environmental standards and social standards? So the takeaway from this kind of a deliberation, and then of course I will reflect upon certain contemporary developments after having drawn those conclusions and open myself available for questioning by each one of you. Let me try to share my slides. I trust the slides are visible to you. WTO as gatekeeper of environmental and social standards. Gatekeeper, an arbiter of what suits trade in relation to environment. Gatekeeper of the one who determine as to what exactly is the social standard according to through the lens of trade. That's essentially the gist of what I'm going to discuss with you now. I think at the very outset, let's be very clear about the kind of role that WTO is playing. It's not the architect of environmental and social standards. It's already there. And what it does is the role of an arbiter of their legitimacy in trade. The gatekeeping role is very subtle, but very decisive. It legitimizes the environmental and social standards when states can show that those standards that they have picked up for enforcement within them are genuine, very necessary, and are non-discriminatory. That's the sum and substance of the WTO's role as far as enforcing environmental and social standards are concerned. Unlike international environmental and social arrangements that we know of, the trade arrangements, this is a standard feature. The trade arrangements have very clear legal stipulations, a wonderful institutional arrangement, and a conflict resolution mechanism to boot to consider and deal with any activity, including those concerning environment and communities of people that has a bearing on international trade. It's a very unique institutional arrangement. You do not find the like of it or a parallel to that in the environmental legal regime. You don't have an institutional arrangement. You do have legal prescriptions, but in terms of their formulation and the structure and the way in which they are put into application, they appear more like soft law, a little vague. Unlike that, you have great degree of clarity in the trade arrangements, in the legal prescriptions, and the way they're enforced. Now, let me just get started as to what the trade regime thinks of environmental standards and how does it enforce them? How does it legitimize them? Let's just go to the legal prescription, and you have the GATT regime, the exceptions under Article 20, as you know of. And what does Article 20B in specific terms provide for? It allows measures necessary to protect human, animal, or plant life or health. And to move on, Article 20G permits measures relating to the conservation of exhaustible natural resources. But there is a proviso. You call it as the chapeau, provided that they are applied in a non-discriminatory manner. So you are at perfect liberty in bringing in these environmental standards. What standards? Those measures which are very necessary to protect human, animal, plant life or health. So it's more to do with protection and nothing to do with development or anything like that. It's to protect them, to which you are going to, for which end you are going to bring in certain regulations for conservation of exhaustible resources. It's only confined to that, but they are applied in a non-discriminatory manner. So you cannot pick and choose. You either apply to all or you don't apply at all. So states must provide measures are genuinely aimed at environmental protection, and they are not used as a disguised trade barriers. That means measures that are applied in an arbitrary or an unjustifiable way. So if you fulfill this condition, well, these standards can be enforced. Now, how has this particular legal prescription evolved over time? And the best way of looking into is about the practice of states and also the way in which the dispute resolution mechanism has worked it. So the jurisprudence that has developed, if I can just pick one or two examples, you have the US shrimp turtle case. And as you know, I'm not going into the facts of the case. I'm not going to all the details. I just pick on the ratio that has come out of it. What did the dispute resolution mechanism do? It upheld the restrictions imposed by United States on shrimp imports. The restriction imposed is to protect a particular variety of turtles, and all that the dispute resolution mechanism insisted was it should be applied across board to everyone in a non-discriminatory manner. So that was all what you gain out of this particular kind of a development as to how you are going to apply these standards. To take another example, you had the Brazil retraded tires case. What happened? Brazil imposed bans on retraded tires. Okay. So what was the problem? Well, there was no problem. In fact, the dispute resolution mechanism said that it comes within the purview of this particular provision. The ban was upheld for public health grounds and for environmental reasons. So public health and environmental reasons do get factored in when you take certain measures, which is not a trade barrier in a discriminatory manner. You are applying it to everyone. Public health is important, and environmental degradation is another problem. And so to take care of that, we are imposing ban on the retraded tires. So this is all what you have. And if you just look into the development that occurred through the dispute resolution panel that came much later, the norms applied and factors considered the following. They did balancing and calibration. How do they really decide on its non-discriminatory? They assess the proportionality between the environmental objective and trade restrictiveness. Is it on balance? Or does it in any way, it tilts either this way or that way? So that's one way of ensuring that there is no imbalance there. And second, there has to be a clear evidence and coherence, clarity. You should have things as a fact, and you should have clarity of the measure. Scrutinize internal consistency of domestic regulation to avoid accusation of protectionism. See, you have problems of unreasonable, disproportionate trade barrier imposition on account of this, or you have a problem with regard to discriminating between the domestic industry as against that which comes from elsewhere. And if you have overcome that, then fine. So there has to be a clear evidence to that effect. And for that, they will definitely look into what does your domestic regulations provide for? Do they really discriminate between a domestic industry and something which is operative transborder? Then the third thing that they look into is the cross-agreement analysis. It's a very interesting thing, and it's very fairly comprehensive. It combines GATT and DBT disciplines to weigh non-discrimination against legitimate objectives. So what you do see is a development which really considers something as discriminatory if these conditions are not conformed to. And as you could see, over a period of time in the last 30 odd years about 30 years, the jurisprudence has gradually expanded the scope of environmental measures, showing sensitivity to ecological concerns while maintaining discipline against protectionism. So to say that the trade arrangements are out and out only everything, focusing only on trade at any cost, is not acceptable. If you look into the development of the jurisprudence on the subject, what you do see is a real struggle, a struggle of balancing the level of protection and whether it is discriminatory, whether it is rational, and whether it balances things out, and then only they take action. Otherwise, it's considered as a discriminatory measure, and such a kind of a thing, even if it is a very important environmental standard, not applied. So, in sum, if you look at the development, the jurisprudence emerging out of this particular arrangement, all that you do see is, sorry, let me just go a little up. Yeah. We have seen what the provision provides for, the legal frame, and we have also seen as to how this legal frame has been interpreted through adjudicatory mechanisms. And now we look into the institutional arrangement. Is there any kind of a thing which is trying to bring in the coordination of the environmental imperatives with the trade compulsions. Yes, there is an institutional arrangement, and this institutional arrangement is what is referred to as the Committee on Trade and Environment, CTE for short. It was established in 1994 to examine the relationship between trade and environment. This is very important, to ensure environmental policies do not become disguised trade restrictions. Please remember and recall the chapeau. That's exactly what has been put together here. So you have a forum or a facility or a platform for a dialogue. No binding decisions here, but there's a scope for deliberation to look into the arrangements that are there in relation to environment and the requirements of trade. Do they clash? Do they harmonize? Is it discriminatory? Is it a disguised trade restriction? And if this litmus test is followed, well, the committee would definitely be very happy if at all there is going to be any confusion or apprehension to iron out whatever confusions that are there and clarify. So it comes up with its positions, and these are not binding on the parties, but certainly it is just to enable within the trade arrangement that we are looking into the all other requirements before we really push for trade. And what does it really imply? It's an encouragement for the national environmental measures to remain transparent. That means when you come up with environmental measures at the domestic level, make sure that these environmental imperatives that you have in your legal system do not become a kind of a hindrance for trade per se. And it also promotes coherence between multilateral environmental arrangements and WTO rules. I think this is a very salutary feature, as you could see in the WTO arrangement, which is conspicuous by its absence in multilateral environmental arrangements. You can pick any of those environmental arrangements, whether it's climate change, biodiversity, you name it. On each one of them, you have environmental imperatives. It does not really come up with any kind of a mediator, any kind of a coordinator, any kind of an institutional arrangement which would actually accommodate the other interest. And there, environment is paramount and nothing else would matter. And all others need have to come. So it's a kind of a hierarchical structure, that these are the things that need have to be really done. And there are no questions asked. It does not really factor in the trade thing. And trade is a very clever arrangement. And it does not suffer from that weakness in that other legal system, the legal regime. And it comes up with, yes, we have a provision to iron out differences. There have been misunderstanding, there have been some problems, either in understanding certain provisions or in the application of it. And so here we provide you an opportunity for a freeing, frank, open, transparent deliberation, and then sorting out the differences. All that we require is the chapeau. What's the limitation? The limitation is it comes up with recommendations. Either you take it or leave it. They are not enforceable. And so the function of CTE is more of a deliberative body than a regulatory one. So it's a very clever move. If you are thinking of international politics, I think the WTO regime has perfected it, making it very clear that we have everything with us. We have considered all other demands and requirements, and we have allowed them to have a say here, but we take the call. Quite unlike the other legal arrangement, the labor, the environment, or anything which has imposed social standards or anything like that does not really look for anything in relation to trade, but they have a bit of a tunnel vision as they claim. These are not my words, but this is the way in which the argument for the trade organization is being put forth. Now, let me just move on to look to the social standards and its status as far as the World Trade Arrangement is concerned. Sorry. Social standards and the WTO. And when we refer to social standards, we refer to the labor rights and social clauses. Quite unlike the environmental concerns, where there is a very specific reference to environmental standards and how far, to what extent do they operate within the trade regime, you do not have any clear, explicit mention or embedding of the labor rights in the WTO agreements. In fact, there were attempts made to introduce a social clause linking trade benefits to labor standards. But they have been very stoutly and very strongly resisted, especially by the developing countries. Because they had this fear that this is a handle that could be used as a disguised protectionism. And as you know, as students of international institutions, the International Labour Organization, or ILO for short, remains the primary forum for labor standards, and WTO discussions in their COPs and other meetings, those discussions occasionally touch or overlap. And I'm only picking some of them. Even the Committee on Trade and Environment had on certain occasions considered social dimensions. But once again, its primary mandate is to deal with environmental issues in trade and not social standards. Broader debates on trade and labor standards have taken place in WTO ministerial conferences. But as you know, in the hierarchical structure of international legal arrangements, the ministerial conferences are more deliberative. And they actually come up with an outline as to how we need to proceed, how we need to go about things. And they may introduce certain new things, including those labor standards that they have discussed quite often. But there is neither a time limit fixed, nor goalpost laid, or any binding mechanisms to really give voice and effect to whatever deliberations that have taken place in the ministerial conferences. So, in sum, the social standards, as far as WTO is concerned, forget about enforcement, even to really figure somewhere in the whole scheme of things, other than in the deliberations and huge discussions over which there have been a lot of more of resistance than acceptance, there is nothing much. So it's wafer thin. And I was mentioning about there's mention of something in relation to the social clause. If you look into the dispute settlement mechanism, there, although the WTO dispute settlement panel have not directly adjudicated cases on labor rights, nevertheless, disputes involving public morals look to Article 20, Clause A of GATT, they show the potential for social concerns to be justified, as it happened in the EC seal products case, where animal welfare was recognized under public morals. I mean, immediately, offhandedly, I can only think of this particular case. There has been something which has a bearing on social morals, more to do with public morals, where animal welfare was made a subset of public morals. So, as I did mention earlier, enforcement of social standards and reflections on that, either in law, policy prescriptions, or deliberations, are occasional and not reflected on what the legal prescriptions are, the institutional arrangements are, how things are being put into application, and how the interpretation have come out through the dispute resolution mechanisms. The following are the takeaways. One, WTO law legitimizes environmental measures through exceptions and the evolving jurisprudence. I have been very careful in using this expression, legitimizing environmental measures. So, not all environmental measures are wholesale considered and applied. Let's be very clear about that. And whatever that has been taken into consideration and whatever that has been considered, applied, and endorsed is only subject to that requirement that there is no disproportionality, there is no discrimination, and there is no disguised trade barrier. If that is so, your environmental measures are welcome. The red carpet is unrolled. Otherwise, sorry, it cannot go into that core of that. And this is what we are going to administer, and you shall not enter here. That's why I said gatekeeper's role. As I did mention, the social standards, marginal, very peripheral, and a very indirect reference to that, and a recognition of public morals, a subset of public morals. Not even public morals is a huge thing. Animal welfare as one subset. That's what I did see in that. I did not see many other occasion, or I'm not very conversant with any other development which the social standards were considered as very prominent and very much required to be made and integrated with the trade arrangement part. And if you look at the institutional design, the design is very clear. See, we are mandated to facilitate international trade, cross-border trade, and to remove any hurdles for that. This is our primary mandate. And so as an institution, the entire institutional structure and the arrangements within, the practices adopted, they all are oriented towards that trade first orientation. But as you could see, that you cannot have such a kind of a tunnel vision. And so when I say that it has legitimized environmental measures, there is also an effort in seeking legitimacy and legitimizing your trade claims, trade interests, that we are also looking into those other aspects as well. And don't think that we have only one focus. We also have considered all your compulsions and constraints and difficulties, and we have this answer for you. So it's almost like being a little bit more democratic. than what you think. We are not dictatorial. When we really set our task of facilitating trade, easing any kind of restrictions or any barriers that are there for trade, we definitely factor in the health factor, the environmental factor, the morality aspects as well, but as determined by us. And this is what we have determined. We have provided, see, look into our provisions, we have the provision for that. Look into our institutional arrangement, we do work it, and look into our dispute resolution mechanism, we have accommodated that. It's a nuanced role. The WTO law plays a nuanced role in balancing trade liberalization with environmental and social standards. Its institutional arrangements, like the Committee on Trade and Environment, the exceptions under the GATT Article 20, and the jurisprudence of dispute settlement, all demonstrate in very clear terms. They show how environmental concerns are integrated very, very cautiously into the trade regime. So that's the sum and substance of the facilitation, accommodation, making provision for, and even enforcing of environmental standards. On that, it's very clear. As far as social standards is concerned, more as a subset of public morals, certain aspects are taken into account. And that's what I'm very conversant as far as the social standards are concerned. And my take, if you ask me, there is very little. There is very little as far as social standards are concerned in the trade arrangement. They have profuse instances and incidents involving environmental issues, but by and large, they gravitate towards one single theme, that if you really come within that chapeau, then there is no other restriction that we have. We just allow environmental standards to apply. So this is how they enforce it. And I'm just looking into the developments in the last 4-5 years. Has there been any significant shift? The position that was given to you was still around 2020. But between 2020 and 24, 25, a lot has emerged. And if I can just reflect a little bit out of the syllabus that has been given to me here, if you look at the developments since 2020, there has been a lot of weakening of environmental arrangements. The climate arrangement is nowhere to be seen. It's more of a hot air now, more of voluntary standards that are being followed by states now and enforcing it by themselves internally. And only thing is they need to come up with those voluntary measures that we are putting it under our domestic purview. Are we enforcing it? Is it coming anywhere near the goal that has been set? And that's the kind of development. And even with regard to the biodiversity regime, there has been a lot of shake-up. That there is a lot of effort that is going on in integrating the law of the sea with biodiversity law. And so there is a lot of churning that's occurring in the environmental field. As far as labor is concerned, it remains stationary, not much as for social standards or anything like that. But there is a lot of noise coming from the civil society, questioning every trade move, every trade measure, every kind of a tariff restriction that's being imposed and things like that, unilaterally, bilaterally, or multilaterally, or whatever. So given that kind of a mix that we are in, it's in a state of flux. If you just look at some 3 developments, one is the fisheries subsidies agreement of 2022. in my reckoning, the Fisheries Subsidies Agreement of 2022 is the first WTO agreement, primarily environmental, targeting harmful subsidies linked to overfishing, reflecting the organization's sustainable development objective. This is amazing. If you closely get into the details of the subsidies agreement, very salutary. See, when we talk of sustainable development, we factor in the social, environmental, and economic. And it's not a competing claim, but accommodation of each one of them, or integration of all the three, so as to ensure the development is perennial, sustainable. And for that, WTO has committed itself that we really go by the Sustainable Development Objective. And all our actions and measures concerning trade, either under Article 20 or through the institutional arrangement or through the dispute resolution mechanisms, they're all aimed towards that. There is absolutely no change in our stance. And it's all aimed towards sustainable development, and we are wedded to that. And in doing so, I had already discussed with you in detail, the tilt is more towards trade, and anything that's going to affect the trade, even if it is an environmental standard, is not acceptable. Thereby, it brought a bit of an instability in the equations, where you have a hierarchy whereby the trade takes the top position and all others are subsidiary to it. That's the scheme. And now you have almost like, as in the cricketing language, it's almost like throwing a googly to a batsman to unsettle him. And it's a wonderful arrangement that has come here, where you find conservation as one of the markers whereby you are going to measure sustainable development. Conservation. Conservation of fishes are possible only when you have sufficient stock available for harvesting and you do not exceed that particular limit. And so there is a limit, as they say in environmental terms, and it's also an economic term, that there's something called as a carrying capacity. The resource can produce so much, and your ability to exhaust that should be such that the ecological surplus alone you can use, and you shall not go to the core or the corpus. And if you really dabble with the corpus, in any way tinker with it, then it becomes unsustainable. It cannot carry the weight of that kind of a pressure. And that's exactly what you find in the Fisheries Subsidies Agreement, targeting harmful subsidies linked to overfishing. So much is the fish catch, and you shall not exceed that production in exhaustion. And it's indeed a very salutary measure. But the real problem is the year is 2026 now, almost 3 years since this agreement has come about. I'm yet to see any single instance when this particular agreement having been enforced. The real implementation of it and the fallout following that would definitely test its bite. So if the WTO regime really believes in whatever that has been set as a goal under the Fisheries Subsidies Agreement, we need to really see in action. And it's only in action, not inaction, in action, we will be able to see whether WTO means by what it says. Organization's sustainable development objective. So this is the first development. The second one that I just would like to reflect upon is a very interesting development, a lot of churning within the trade body, within the institutional arrangement. There has been a lot of renewal of initiatives on trade and environmental sustainability. There has been a lot of discussion over plastics. Microplastics is another huge issue. On circular economy, recycle, reuse, carbon measurement. So I think the trade arrangement is opening up to this particular stark reality of the adverse impact of climate change and the need for carbon neutrality in all our activities. And sooner we do it, it's better for humanity, better for the earth. And that is actually bringing them to a different kind of a discussion than the usual trade arrangement discussion, to bring in the issues of circular economy, the carbon measurements, and the limitations of production of carbon in all these such trade activities, the plastics and all that. But they're more deliberative. And whatever conclusions that they draw in their discussions, they have by and large remained non-binding. They are either directory or they are actually reserved for future discussion to work out the nuts and bolts aspect over a period of time. But at least they are at the discussion table and these are on the agenda. So that way the winds of change are blowing. May not be with that force and speed with which one is looking for, but it's happening. And then CTE, a very interesting arrangement that you have, the CTE. People thought that it is only a deliberative body and nothing more. But if you just look at its working, although it's a trade body, there is no doubt about that, and it's been created under the trade arrangement. It has to really prioritize trade, but at the same time factor in the environmental considerations at all as well. If you really look to the way in which the CTE is working, it is not really a body which is very much drowned in trade arrangements. It is looking elsewhere also. What's happening all around? What's happening in the environmental field? There has been some arrangements in the multilateral environmental arrangements, like in the Biodiversity Convention. You have a biosafety arrangement, a protocol. And in that protocol, there has been the movement of those technologies and those organisms that are being transported from one country to another, traded from one country to another, which may have a harmful effect upon the bioresources as well. And for that you have a protocol that there are certain do's and don'ts when you engage in such a kind of an activity. And the CTE is very conscious of it. It's keeping a tab on that. And it's keeping its discussions quite transparent there on environmental measures and looking into the best practices for impact assessment. So it is not an out and out trade outfit. Although the design and the working is essentially that, it's also opening up its mind and looking at it this way as well. But once again, you have a problem. It's only a committee on trade and environment. It's not an organization. And there's a world of difference between a committee and an organization, legally speaking. A deliberative forum. It is not an adjudicatory body. It is not a decision-making body. It is a recommendatory body. It's a deliberative body. But at least thinking is there. It facilitates dialogues on trade and environmental coherence, transparency, and national practices. And this is very important because national practices, some of the influential national practices, which can be a role model, that such trade practices exist, but they are environmentally clean. Good. We should really consider making it part of it. So becomes part of the recommendation here to get into the working of the system itself. So it cannot issue binding decisions. You have interfaces. It encourages complementarity rather than hierarchy between trade rules and environmental treaties. So it is more a kind of a buffer zone that has been created within the trade arrangement, a deliberative body to take all kinds of pressures, to get into a lot of discussion, filter them to see how much of it could be taken in the trade arrangement, put into application there, and that's it. And they just do not really go beyond that. So very briefly, this is what I just want to place before you. And let me open myself for any kind of a question on the presentation that I have made so far. Please don't ask me questions outside whatever that has been presented here, because to get into them, I need a lot of time to deliberate. So in the 10 minutes that's available at our command now, if there are any questions on any of those aspects that I have placed before you, we can refer to the slides again and then go to the questions, or feel free to pose any question. Thank you.
Sir, just a question, but it may be a bit, going a bit divergent from your slides, but it's really connected to WTO. So, given the existing asymmetries in the global power sharing among the states, how far do the geopolitical alignments and economic dependencies influence trade and environmental decision making at the international level? And in this context, how can global institutions realistically balance the competing interests of states, particularly where some countries, due to strategic alliances or trade dependencies, prioritize this economic survival over environmental protection, as is evident from the divergent voting patterns on emission reduction commitments? So, what will be the role of WTO in facilitating these deliberations to remove such a deadlock?
Okay. This is a very interesting question. May I know who is the one who has posed the question?
Sir, my name is Gauri Parvati. I'm a second year BLLB student at NUALS.
Yeah, I'm very happy that you brought in something which is a little sticky subject. It takes a lot of time to deliberate over that, but let me just put it in one or two bullet points. Agriculture has always been a contentious issue. And if you look into the agreement on agriculture and the kind of debates that have occurred around that, you have a lot of difficulty here because this is something that I have been telling our friends in the government, that they do not go with enough preparation when they go to the international deliberation, especially for negotiations. They have plan A, plan B, plan C before they finally come up with an arrangement. And we just do not go with any plan, and we just get trapped in one plan or the other of the others, and then ultimately agree to everything. And if you look into that entire arrangement itself, there is a bit of a lopsided development. They created certain boxes, the blue box, like that. whereby they have already certain kinds of protection that has been already allowed for their kind of trade practice or agriculture practices, which countries like India cannot impose because these have been factored already in the stipulations. Either you take it or leave it. So, given the kind of the institutional arrangement and the statutory, the legislative prescription that you have there, you have a lot of difficulty in making it a very balanced one and non-discriminatory or anything like that. I think it's a trade arrangement where there's a lot of protection for the kind of agriculture and agricultural practices that are followed elsewhere than what is being practiced in this part of the world. And so you can only debate over that. But when it comes to the crux, the difficulty remains for you to really making your position acceptable to everyone there, because the arrangements come in the way. So, if I can put it in one single sentence, the trade arrangements have been so structured that any deliberation need have to be within that four corners of that. We accommodate all of the claims and considerations, but subject to the promotion of trade and nothing more. That's the sum and substance of it. I know that I just have only touched the issue. I have not gone deeper into it. Once again, to provide opportunities for others, I have to confine myself to only this much of a statement, because illustrative examples would take me for, I think, at least another half an hour. So that is not advisable. So next question.
Thank you, sir. Thank you so much. Any more questions?
Yeah, we may see online if anyone is there.
Anybody who's joining on online have any questions? Please unmute yourself.
Meeting is.
Sorry, I couldn't hear you.
Yes.
Or no questions or?
Yes,
Yes.
Professor Nicholas.
Okay.
Going to that.
Yeah, perhaps more a remark than a question from Nicolas Sadler, speaker at this conference. It seems to me that all in all, in somewhat 35 years, there are very few talent decisions, and even fewer appellate body decisions regarding the different sustainable development aspects, in contrast to other areas such as anti-dumping, subsidies, topics that arrive with litigations. And accordingly, there might be somewhat a paradox between the high tensions regarding the green box issues related to the implementation of WTO agricultural agreements, tensions regarding the labeling of hazardous products and substances under the TBT agreement, the tensions related to the application of the SPS agreement to different genetically modified technologies. And so I'm just wondering whether the case law, generally speaking, really reflects the level of tensions between the parties regarding the abilities to achieve sustainable development. So that's more remarked on the question, but perhaps I would like to have your point of view on the matter.
I'm sorry, I did not hear you completely. Maybe there is a problem with the audio.
Yes,
Can you succinctly
yes.
put if there is an observation or is it a question?
No, it's more an observation than a question. It seems to me
And
that
what's
there
the
is.
question?
No, it's more an observation that there is a contradiction between very few WTO cases. And you mentioned also there are no specific cases regarding labor standards. And on the other hand, there are significant tensions regarding the implementation of agriculture, SPS, TBT, World Trade Organization agreements on different sustainability aspects.
As you could see in the developments in the last 4 years, there has been a little bit more opening up to the environmental ones. But when it comes to labor and social ones, I had already given you reasons as to why there has been a lot of resistance there. I don't think there is any headway on the labor or the social front in the trade arrangement till now, at least to my knowledge. Yeah.
So do you have any more comments? Now your camera is visible.
Okay.
Sir, want to have more remarks? Yes. Okay, is there any questions from audience or online? Is there anyone? We have more 3 minutes for questions and answers. So do you want to add any more? Professor Desailly? Yeah, right.
Okay.
Right. Okay, right. Thank you so much, sir. Thank you so much for joining us.
Thank you very much for nice opportunity to interact with many of you. I hope this could be a takeoff point for far more serious deliberation over a very interesting subject that you have before us. And thanks to the organizers for having facilitated this kind of a dialogue. Thank you.
It's a pleasure.
Extent of sincere gratitude to Professor N.K. Ramesh on his illuminating lecture on environmental and social sustainability within the WTO framework. His clear analysis of the gatekeeping role of WTO, the operation of GATT framework, environmental exceptions, and the balance between environmental protection and trade liberalization, supported by key jurisprudence such as the US Turtle case, etc., provided valuable insights into how international trade cautiously integrates environmental concerns. We are particularly thankful for his discussion on the Committee of Trade and Environment, his deliberative role, and his critical perspective on the marginal position of social and labor standards within the WTO regime. The lecture encouraged us to reflect deeply on the institutional design and jurisprudential balancing of trade, environment, and social interests. We are grateful for Professor Ramesh for sharing his expertise and enriching our understanding. Thank you, sir.
Next. Please request Professor Vishwan. Yeah. Sure. Dr. Shruti, right? Yeah.
It is my honor and privilege to introduce our distinguished speaker for this session, Professor Vishwanath N. Professor Vishwanath N. is a senior professor of law, the chairman of the Postgraduate Department of Studies in Law, and the dean of the Faculty of Law. He is also a Dr. T.C. Pavate Fellow at the University of Cambridge, United Kingdom, prestigious fellowship that reflects his academic excellence and global scholarly engagement. With a doctoral degree and decades of experience in legal education and research, Professor Vishwanath M. has made significant contributions to the development of legal scholarship, institutional leadership, and the postgraduate legal studies in India. His work bridges rigorous academic inquiry with practical insights, which makes him a respected figure among scholars, students, and practitioners alike. We are deeply privileged to have him with us today. and we look forward to gaining from his vast experience, scholarly depth, and thoughtful perspectives. I now invite Professor Vishwanath N. to kindly address the gallery.
Sir, you can unmute yourself.
Sir, you can unmute yourself. Start the session.
No, it is fine from here.
Hello.
Yes, sir.
Yes,
You are
sir.
audible.
Yeah, okay. Thank you. Good morning, all. Thank you, organizers, especially University of Mysore, NUALS, for giving me an opportunity to share a few of my thoughts as to the prevailing global context of how do we trade and who probably bears the burden of the trade or who benefits from the trade, or it is globally everybody benefits from the global trade. So I'll just share my PowerPoint. Okay, fine. I believe the screen is on, the slides are on.
Yes, sir.
Okay, thank you. So I would try to look for maybe an half an hour or 40 minutes into how from soft loss to hard liability, we are moving for a sustainable standards in cross-border trade. So every one of us know that it's a globe, one Earth, and none of us know is there one more Earth or a junior Earth or a duplicate Earth. Knowing all these things, also we have made the environment, the climate, not so sustainable to our future generations. And that is where I think we are a huge challenge to just see that we have a sustainable practice in all our activities. So for this sustainable practice, we need a global cooperation. It doesn't mean that only somebody sitting in Sri Lanka or somebody sitting in India or in US or in Europe, they tend to act or don't tend to act. It does not work like that. So we need a global understanding uh, to minimum context. So because of the geopolitical context, we understand that it is not possible to us to have a uniformity, but minimum context we can try to bring. So this is how we look into how today's trade has been taking place, especially when it comes into sustainability standards. So the entire idea of my presentation or my discussions, my thoughts is revolving around how probably we can force on certain things, because we cannot tend to move only in the name of sustainability and the practices until you tell that we need something more in a stricter form of implementation. If not, we are forced to use certain penalties or provisions which may deter, because it may be detrimental to nation states. So based upon that, we are moving from the soft laws to the hard laws or the hard liability. So partner is one of the main component, and I always believe that without remembering him, we can move ahead. As important as globe, he is also important for us to feed us. So my first slide is always a tribute to the farm. Uh, why from soft to hard? Professor Ramesh sir is a known personality in environmental context. So he has wonderfully explained why we should sustain these things. So from soft to hard, you take up maybe we can split in from the 28th century to the 21st century, 50 years across. The earlier context of environmental context among cross borders was US and Canada. It happened long back. So where they respected that yes, certain things polluted which crossed the borders, and they were compensated for the same. A small example that shows that if we are concerned and positive, it can work. So it has moved from there quite fast into voluntary attitudes that yes, I stand for certain ethics, certain norms, certain standards. So that is how it has moved. But in this competitive world, morely driven by economic parameters, it becomes really tough for us to sustain this voluntariness. So now we should move to it because I believe that voluntary standards have failed to live up to the expectations. That we are not volunteering to do something. It is until we are forced to mandatorily do. Maybe environmental context. Of course, we are in this crisis of climate change. Every country feels that yes, there is a climate change. And we should also see that how we try to minimize this changes that is happening, and either it is science or it is economics. We understand in common that we are bearing this burden of climate change. We understand that environment has definitely tuned up, or it is tuning up more negatively rather than positively. It is a global phenomenon. Human rights since 19 the second post Second World War, the UDHR, then so many covenants, there's so many continental arrangements, treaties. Still today, we find that we are into this human rights crisis, especially into the southern region of the globe. So we are supposed to look more sharper, deeper to apprehend this kind of human rights violation. Labor standards is one wherein we are not pushing hard to benefit the labor and also his working conditions. So we see from last maybe 25 years, maybe post 2000, especially in India, post LPG, how things have been pushed that now we are pushing so hard into make in India or made in India. So we want to be a manufacturing unit. So labor is one of the context that is very essential. So whether we have maintained the standards of giving him better conditions, better working conditions, so this voluntariness has probably failed. So we have moved from CSR to ESG, environment, social, and governance. So corporate social responsibility was as good as you tend to pollute, then pay for it in the name of CSR. Actually, it was for environment. Now the CSR fundings have been channelized for so many other reasons, which basically is not serving the purpose. And I strongly believe that there is no proper audit as to how CSR have been funded or used, or actually as per the law, or whether the sharing of the CSR is has been done as per the laws. So we have been moving from CSR to ESG. So the UN guiding principles for this human rights and environmental context from 2011 to the present context from 2026 January, it has started with the CSDDD. That is where we are trying to look into how it can help us. Now, companies must now demonstrate a clear understanding of the impact they're having on people and the planet. Exactly. Because my actions are not confined to my factory, my premises, my industry, my state, my nation. No, because the product that goes out is what we are economically benefited. The product that goes out has an impact, whatever it is. So we are supposed to have this supply chain due diligence that from the process to the product and its usage, it has an impact. So we believe that we should be concerned with that context. I strongly believe the Dono versus Stevenson case, where it brought in the liability to the manufacturer, which was only confined to somebody who was to sell. So that particular thing that changed, that the liability of the manufacturer can go up to that extent, has changed so many propositions. So today we realize that it's not only the liability, it is the role that what I play, which has an impact on the people and the planet. And the purpose of supply chain due diligence is to foster sustainable and responsible corporate behavior, which anchors human rights and environmental considerations into a company's operations and corporate governance. So now it is not an option, it is mandated. We stand for it. So otherwise, it was earlier. It is as good as in a labor law. The people tell that the trade unions go and bargain with the management for a bonus. So it was the discretion of the management to decide whether they should be given bonus, or if given, what percentage of the bonus, all those things. So now it is not so. It is mandated that if you're going to earn so much of profit, you are supposed to share that among the people who have worked for you. So this is nothing but it has definitely gone into that. It has been part of your governance rather than being an optional context. So, like in Australia, they brought Modern Slave Act. Canada's Bill of S-211. It is also speaking about the labor. Germans LSG, LKSG, Norway's Transparency Act, India's BRSR, aligned with the NGRCB. The EU's that is the European Union's corporate sustainability due diligence directives. All these things are framing up in the global platform. It has, especially from last 5 years, it has come into very relevant context and pushing harder. That's why from soft to hard, it is pushing harder and making people responsible, especially in the commercial context, which may impact the businesses. So it is better to fall in line instead of losing their business or dropping out their profit margins. So it is trying to navigate mandatory due diligence, civil liability, and trade link penalties. So these three things, that is mandatory diligence. There is no question of excusing something. You fall into that line. You may be sued. Oh, that's a bigger context. Where I think we are moving ahead. And trade link penalties. That is, I told, process to product. That where you are trying to put across. So it profoundly alters the context, turning voluntary, ethical, and market-induced efforts into legally prescribed obligation. So that is where these legal foundations, wherein it shows that as per this particular law, you will be penalized. So now it was earlier it was something more soft like principles. Now it has become mandating. So that's where I think we are moving. So the basis for this is this four context. The corporate law, that is where the company is supposed to govern itself, that it makes inbuilt systems and mandates certain things. The trade law, that is the imports, exports, the border adjustments. The treaty laws, that is made between the counterparts, and the private laws that has been done among the parties, especially green clauses in the commercial context. These four stands as a pillars of making or moving from soft to hard laws or hard liability when we talk about cross-border trade. So what is this mandatory due diligence that we are looking into? See, the context is that identifying and mitigating adverse impact across the entire chain of activities. So it tells identifying and mitigating. Okay. So that means you're bound to definitely have a forethought that you are going to have this process and the end result would be this. It is as good as from Rayland versus Fletcher's case to the Indian context where we brought in from strict liability to absolute liability. So now we are, the companies are forcing, even though in the Rio Declaration they are pushed hardly for environmental context, there should be absolute liability. Now they are pushing it harder in making it to law, telling that you cannot have an excuse. So you cannot tell that no, I didn't expect that this is going to go wrong. So there is no question of that when you're trying to handle that. So you're making them to be very diligent, that is due diligent, to look into this kind of change. Administrative oversights and the power to levy fines. So this is quite interesting, and implementation part becomes, maybe we will discuss that how it is. So we are trying to bring in liability on the people who administer. So somebody like in our corporate laws, the company law, we of course we have certain liabilities, but we all understand how legally is a company binding. Maybe its particular administrators are binding, and that of a firm, how the partners are binding, and the firm is binding. So this extends, trying to extend to some extent where individually you're going to make the persons responsible who are at the helm of the affairs for certain of the context. So that is where I think this mandatory due diligence is pushing harder to make them personally liable for certain activities. So civil liability and access to justice. So this is where I told that it gives a right to the people to sue. So victims of environmental or labor violations in third countries can now sue in European courts. If this is definitely on board, I think we would have the southern countries of the globe have a very bigger relief in that context. But one thing is we don't know how it is going to work out. India has a very bitter experience of, you go back to 1985, 83, 84, when we had the Bhopal disaster. We planned to sue them, or we went to sue them in the Court of America. The American courts did not entertain that. They told that Indian courts are much competent to deal with this kind of matters, and we came back to the Indian courts. So everybody knows the story of the Bhopal disaster. If this was the case back then, where India tried its best to maybe sue in American courts, we were not successful to be so. But today it provides an opportunity that there exists a civil liability. That means it's a good move from 1980s to 2026 that we are pushing. But still, again, it may end up as what is today the International Criminal Court, how it is pursued. Everybody knows that. Maybe it may not end up in that context, but we expect that civil liability gives an opportunity for us to claim compensation for labor violations or environmental violations. So we hope that this is one of the major ticks that can be considered to boost the morale and also to fall in line with the standards that has been fixed. Now, proving intentional or negligent failure to comply. So that is where I told this strict liability and absolute liability. Intentional or negligent failure to comply. So your compliance sheet that you go to tick mark all these things, you cannot tell that it was negligent or it was a mistake. So the line between negligent and a genuine oversight is not taken into consideration on this context. And we are seriously looking into the carbon emissions, mining, maybe intense labor activities wherever the industries are involved. So all this environmental context and the labor rights violations are seriously taken up with this due diligence. Trade link border measures is CBAM. Is this a new climate border? So carbon border adjustment mechanism is quite delicate, I believe, because of this gap that what we have between the north and the south. Uh, India and China in the south are the bigger countries which are brought into the red line of polluters, major polluters. And we own industries in iron, steel, mining, fertilizers, and other major industries which they consider is highly polluting. But if that are our resources, which helps us to develop. Now, how are we going to match this is a bigger question. Maybe Paris Convention that India is, as Sir was trying to tell that our politicians don't prepare and go listen half, then ultimately they sign and come. Probably we are into that situation right now also when it comes into it. So this we are supposed to look in how far this buying this certificates of CBMA will help us, and because there are a lot of apprehensions as to it. So it imposes a carbon price on carbon intensive imports, like as I told, steel, aluminum, cement. These are all so relevant for any infrastructural development, physical infrastructure development across the globe. And the major countries are India and China, maybe even to certain extent Russia also exports this iron, steel, aluminum, cement, and fertilizers to the globe. So I think I'm not telling that we should get a leeway, but we should standardize it to some extent as to the sustainability. But if you can compare it to on a global standard, it becomes very difficult because what is there in Europe or what is there in US cannot be matched across, especially in India or in China. We live in a different world of in the context as to the developmental issues when it comes into that. So that is where I think we are supposed to allenge to minimize these effects and try to improvise because we own a responsibility to the globe wherever we are. Okay. So then to prevent business from shifting production to countries with looser environmental standards, ensuring global carbon costs are concerned. So this is where the people tend to move from one country to other country depending upon the ease of business. Now, for example, in India, when it comes into FDIs, people want to invest. So they choose those states which definitely have a ease mechanism or which is the industry friendly or investment friendly states. So we see that, and of course, physical infrastructure and other things also counts, but definitely it wants something. Now, for an example, it happened that the Tata Nano, which was supposed to start in Bengal, due to the force that what they had opposing it, shifted immediately to Gujarat. Now, Gujarat is a ready state which tells that any industry is welcome. Maybe the same thing may not be applicable to the other states in India for various reasons. So if that is pushed without maintaining the standards, then each nation state, especially from Europe, now it has been already done, but still it may keep moving to where there are looser environmental standards and you tend to profit at their cost because they don't look into the context as what would be the environmental damage or the labor issues, but they think only of the financial concepts. So that probably becomes much difficult, I believe. So there are import bans uh, uh, and traceability. That is, they emphasize enforcing multilateral arrangements like, as I told, Paris Agreement, ILO Convention, so many things, lowering the standards to attract trade and address climate change. So you want to prevent that because money flows in and my particular directions when I put into money that I need so much of standards I need so much of outputs, but at what cost? So now you're going to have a global standard is what the picture actually is showing for us. But let us hope that this global standard sustain to a certain extent, taking this gap into consideration. Then deforestation, that is geolocation requirements for agricultural products. That's why we are more worried into that. I think we had a session on this agricultural context also, maybe last month. Then the forced labor ban, rebuttal permission, legal burden shifting proof of sustainability from the regulator to the importer. So this is where the context moves from what we tell in our Indian context when consumers come into picture, consumer king. Now again we are moving back in this context that buyer beware. It's not the seller. So we are bringing back the sustainability on the regulator to the importer. Okay, so we clearly tell the person who imports, the person who wants to buy should be aware that how this product has been manufactured, what standards have been taken care of. So it is shifting. Otherwise, if you buy something where it has not been done, he may be penalized or he may be barred from using those materials. So that is how it is moving. So this context is what we discussed, whether these are compatible with the international standards. So that is where sir also tried to put across these points. I also made the same points, especially when is it compatible with WTO and Article 20 of GATT. So there is an exception telling that for the WTO standards where you're eased of trading, whether you can bring in certain norms, certain rules to make it more stringent, not ease, make it more stringent based upon environment or human health. So it tells Article 20 acts as a crucial exception clause to WTO rules, allowing members to bypass standard trade obligations like non-discrimination to pursue essential public policies, including environmental protection and human health, provided the measures are not arbitrary or disguised restrictions on trade. So this last two lines provide that measures are not arbitrary. So this is where the difference, I think, probably lies. That we are trying that the European countries are trying to protect their interests rather than looking at the global context by bringing across these kind of stringent measures, which limits the opportunities of the developing countries, especially maybe India and Africa, to make use of their resources. This is an argument sake that they're trying to do, but definitely I believe it holds a very positive note. So it justifies reason to bypass trade rules such as protecting public morals, humans, animals, or plant life health, or to conserving exhaustible natural resources. So this is where I think it goes with the compatibility of what. Then even if measures fit as exception, it must comply with the chapter which mandates that measure is not applied in a manner that is an arbitrary and unjustifiable discrimination or disguised restriction on international trade. Now, this disguised restriction on international trade is one thing I think we should try to look in, because now the BRICS nation, that is Brazil, Russia, India, China, has put out their apprehensions that these are certain restrictions that are put by the developed countries on the developing countries. Okay, so there is an apprehension that it may not yield us maybe better inputs at what the nation state expects. It is as good as it is my resources I want to use. Even my resource I want to use, I am supposed to follow certain conditions. Maybe mining. So in mining, what are you supposed to do? So this is where the sustainability point comes into thing. And we may tell that we have got our own regulatory mechanism to control all these things, manage, and it is also mandated. Now, when you raise the bar, is it possible for us to meet or try to match that bar is a bigger question that what we all probably wants to discuss and know whether it is possible for us. That do these measures constitute disguised protectionism? So that is where it tells no these especially major countries are trying to protect their interests. So maybe yes or no, we should try to look into the present context. So the regional trade agreements play a major role because it tells now FTAs. India was trying to put across yesterday as to the FTAs yesterday and into the trade. So that particular context we are trying to look in. So moving behind aspirational language to enforceable chapters. We aspire to be certain things, but the point is, are we able to convert that into actions, not just being aspirational? Sorry. Not just being aspirational. Can we force into uh, certain actions that can be enforced? I think we should definitely take one step at a time and to move closer into our understandings as of the global standards. The US, Mexico, Canada model, NFTF, that rapid response labor mechanism, they are more into abuse of labor than the bonded labor system, what is there across the globe, forced labor, all those things it addresses where they entered in 2000. So it is 2.0 that they are into. So this is also one mechanism that tells that the rapid response labor mechanism as a template for factory level enforcement. So it shows that even at the factory levels also this is enforced so that the trade in that context becomes sustainable. So that is what they are looking into. Now, practical implication and challenges. So all these things are fine, but is it so easy as what it has been drafted by the EU or even in the trade agreements? Can we do that things? So contractualizing sustainability. So that is where it tells that when whether the sustainability can be contractualized in on that base of supply chain context, incorporating sustainability as a material breach. So how are we able to manage this context? Then how tier one suppliers pass legal liability down to SMEs in developing nations. So this is one of the major points, especially country like India or China. China, we know much less because the policies in China, we don't know how it works. But in India, it is definitely one of the contexts that we're in. India has given so much of push to SMEs through SEZs also. So the small scale, medium scale entrepreneurs, all these people, if they fall in line, the cost factor is one thing where it enhances and it has a cycling effect on all those things. So the cascading effect that what it has can we sustain, or it should be phase wise. Now, as so many environmental challenges has been phase wise. So can it be like that is one of the issue. The green gap between developed and developing nation is definitely visually we can make up the gap that what we have in the European continent or US to some extent and that of the South. How what difference it makes. Then you need data of all this thing to be pushed because you tend to have it on a global platform. The data sovereignty challenges in tracking and reporting supply chain in real time. So how are we going to do all these things is a bigger challenge for the nation states. How do we do? Oh, I have a small illustrations. It is not directly connected to what we are trying to look in, but everybody knows what happened in Bangladesh. I take an example of Bangladesh because the Rana Plaza incidents where more than 1,000 garment industrial laborers died in that incidents. And because why? Because Bangladesh is one country which has the largest apparel exporter after China. Okay, so I don't know the shirt what I'm wearing or the trousers or whatever things it would have come from Bangladesh, and most of the leading brands have definitely set up their units in Bangladesh because Bangladesh is known for that. So if you see the Bangladesh example, which has USD of 42.6 billion industry that accounted for 82% of country's total export revenue. Just imagine means the entire major chunk of Bangladesh is export oriented is their textile industry, that is the garment industry, apparel industry. So there are more than 4 million garment workers representing a sizable part of country's 69 million total labor force. And it is estimated that more than 60% are women. And it is true also. Oh, okay. Especially people in South, maybe in Chennai, maybe in Tamil Nadu, state of Karnataka, especially South Karnataka, we see a lot of huge garment industries across all these things, and we know the issues. So the post Rana Plaza incidents, ILO also played a major role in trying to re-establish that and trying to give compensate those people. And things became rather more positive after that incident. It is very sad that incidents happened, but things have changed from 2010 to 13 to 2026. So it tells now 450 factories enrolled with Better Work Bangladesh 48 international brands and retail partners are there in Bangladesh. 1.26 million workers supported. 5,000 managers and workers received training. So this one example I put is how the positives that are there that we can always take up. Okay, so let us not shy away because it has been done by Germany or EU or US and call them developed countries. What we need is a better world. So better working conditions. Why not? Maybe the cost factor may be one of the things to consider, but still we should try to not compromise only on that cost factor to look into all these changes that we expect for sustainability. So this Bangladesh from 1970 to 22, look at this last one, 152 trade union registered between 70s and 22. Okay, so it's growing, means it is becoming more formal and accountable. So this one picture of Bangladesh shows us that if you mind, if you can change, you can fall into line, we can try to do things. This is one, this apparel industry, garment industry, but if you take it to major industries like India, what India does with the cement or mining, I think we need a lot of improvements to be done to standardize and do sustainable progress into that particular context. So the way forward, I believe that harmonization of global standards. Yes, that is one way of looking forward, looking ahead, that we tend to harmonization of the global standards. AI and blockchain as legal tools for evidently proof in trade disputes. Fine. Of course, AI and the technological concepts may help us to monitor continuously and also fixing the accountability and also upgrade the standards that we are into. The north and south balance, that is what I think it should be coming much closer in bridging the gap what we have in the north and the south. One thing I can tell that it's not only that, it is also the cultural way that I think we should get move into these norms. We should, a law is a law to be followed, yes. Uh, I think in India we are more used to break the laws. We enjoy probably having more releasing, telling that I broke a law today. I did not follow it. That culture should definitely come down. It should, for example, mm, I am from Bangalore. So in Bangalore, in Bidadi, we have this Toyota industry. One of my friend works there. He showed me an incident. One of his colleague was suspended for 1 week from the company because asked him why. He showed me the video. He is in the with helmet, all safety guards. He's walking down the stairs. He just walked in and he's suspended. I told, what is wrong? He has just walked up the stairs. No, 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 sir. He is supposed to use the safeguard, that is the railing that has been put. He should use that in one hand and then start coming down. This is a practice, safety standards. So it tells that if you don't follow it, that means you have been suspended without any compensation for a week. You lose 1 week of salary. That means it mandates, it's a culture that I think we should draw inside to see that, yes, this is the law that I should try to follow it. Probably if this comes, maybe we can bring this gap between the north and south and try to harmonize much better. And I believe that the mm, soft laws may work out better than the hard one if we are trying to change it. But still, I think we should move ahead with the changes that is required because it is good for the globe. Okay. So with this, I end and I thank you for your kind attention. Any questions? This open. Thank you all.
Thank you, sir. The floor is open for question. Any questions? Sir, if I may ask.
Yeah, please, please go ahead.
Sir, thank you, sir. So given India's present tax framework, where there is no explicit carbon tax, but several de facto green fiscal measures such as the cost as which is now subsumed with GST. So the state level green cesses are there and environmental compensation charges. So do you think it is feasible for India to rationalize these fragmented instruments into a coherent, maybe volume-based or emissions-linked green tax regime, which is applicable to trading and manufacturing companies? Like from a economic and trade law perspective, how can such a regime be structured so that it aligns with global practices, which remain consistent with India's development practices, as well as avoiding any disguised protections?
Yeah, very pertinent. That's what I told. That I think we can try to emphasize. This is what I believe. I don't know how it probably works, but I believe that uh, your paying capacity uh, should depend upon the earnings, right? So I believe that the context is we tend to look into what are his revenues and his failures. Failures in the context, as you tell, environmental context. Okay. The more the revenue, more the fines. Okay. The lesser the revenue, maybe lesser the fines. We can try to standardize on certain things that the more the money you earn, the more standards that you are supposed to follow, so that you can minimize it. You put a uniform blanket telling that these are the standards everybody should follow. I don't think it will work normally. Okay. So if we are in the Indian context, as you're telling of the carbon taxes that you are trying to put it across, we are trying to align with the global standards, no doubt about it. But as you know, as a country like India with such a huge population and the needs that we are into the developmental context, it becomes a pressure context for us. Okay, at both globally and at locally. Maybe in locally we have so much of resistance. Globally, we have so much of push to bring in. I think we should try to, like, for example, we brought this Euro norms, which was into Bharat 1, Bharat 2, Bharat 3, Bharat 4, something like that. Phase wise, you can standardize. I think we can go with it. Maybe next Viksit Bharat of 2047, we can try to put certain things telling that this can be achieved within next 5 years. This can be achieved in next 5 years. Now, if we can standardize that and try to put your goals, I think we can minimize the environmental pollutant context that is happening in this country. And India should definitely stand to the global standard. This is what we wish. Thank you.
Thank you, sir. Thank you so much. So one more question.
Yeah, please.
I'm just somewhat puzzled. Thank you very much indeed for your different comments and your valuable comments. It seems to me that Asian companies exporting to the USA and to the EU have a competitive edge, and this competitive edge is related to the access of natural resources. That would be the case in particular of Chinese companies having a greater access to critical minerals and rare earths, access to cheaper labor forces, and for me it's much more difficult to assess, but perhaps less complicated environmental product standards and fewer labor protection standards. But all in promoting sustainability through free trade agreements and the importance afforded to the ESG standards are likely to reduce to undermine the competitive advantage on the main grounds that in order to comply with a number of regulatory requirements, increase in production costs, and as a consequence, increase price of products exported to the Western nations. Could this have long-term consequences, negative consequences, but perhaps also positive consequences? Is that in many economic reports stress that exporting nations do not specialize well enough in end quality and products. And so the fact of obliging trading nations to comply with the same labor, environmental, consumer protection standards could force producers based in China, in India, or in Bangladesh to achieve perhaps a higher quality. I would like to know your views on the matter.
Sir, thank you. Sir, as I stated, I strongly believe that we cannot run away from this fact or truth that environmental degradation, labor standards are to be maintained. And I also believe strongly that the European or the American context with that of the North and the South divide exists. But still, looking into the sustainability to the future generations, I think as a nation state, everyone owes a duty to see that they minimize this, use their resources, build their nation states, maximize their revenues with the standards. So I believe, sir, maybe all this context of that one nation trying to harp upon the other, trying to force upon the other, may not go in for a longer period because we are dependent. So if the nation state fails to produce with that standards, and if it is falling short or failing to export the goods, the receiving country which is in need of it may also fall into trouble. So because there is a global dependency, I believe it will work. But maybe there is always the exception facts that the drilling context is a bit troubled. There are certain hard surfaces that when you tend to drill with these activities. So I believe that maybe next 25 years we can have more smoother rides when it comes into the north and south context. Thank you, sir. Hello.
Hello, sir. We are waiting for some more questions. Is there any questions?
Yeah, please.
So there are no more questions. On behalf of the organizers and all present here today, I extend our heartfelt gratitude to our distinguished speaker for an address that was both insightful and timely. Sir's reflections on a journey from aspirational commitments to enforceable legal frameworks set the tone for today's discourse. He reminded us that sustainability cannot remain confined to soft law ideals, but must gradually translate to actionable and accountable mechanisms. We are particularly thankful for your emphasis on labor and farmers, whose realities often remain at the margins of global trade and sustainability discussions. By foregrounding their concerns, you highlighted the true sustainability lies not only in policy design but in protecting the livelihoods and human dignity. And your discussion on evolving global trade practices, including factory level enforcement mechanisms, illustrated how sustainability and labor standards are increasingly shaping modern trade relations. At the same time, your caution regarding implementation, especially for SMEs and developing economies like India, was both practical and necessary. The approach you presented regarding the integration of AI technology to meet global standards was insightful. Sir, your address reminded us that the shift from soft law to hard law must be balanced, phased, and just, aligning global standards with national developmental priorities. And quoting your words in the beginning, we have yet to find another year, and until then, we shall have a duty to preserve our resources. We thank you once again for your valuable insights
and for enriching this symposium with your wisdom. Thank you, sir. Thank you so much.
Thank you. I once again thank my senior friend and also the Honorable Vice Chancellor of NUALS, Dr. GB Reddy sir, and also Professor Nicholas, who has come all down from Belgium to Kerala, and all the other co-hosts. Thank you. Thank you so much.
Thank you, sir.
Thank you.
Good morning, respected dignitaries, distinguished speakers, esteemed scholars, dear participants, Dr. Vasant Kumar Timakapura, Professor Mini. On behalf of the organizing committee and partner institutions, it is my honor and privilege to welcome you to the third day of International Symposium on the legal mechanism for enforcing sustainability standards in cross-border trades, being jointly organized by National University of Advanced Legal Studies, NUALS, Kochi, St. Louis University, Department of Studies in Law, University of Mysore, GSS Law College, Autonomous Mysore. This symposium brings together scholars, practitioners, and legal academicians and policymakers from the different jurisdictions from Belgium to Mysore and Kochi, because of the shared interest which involve the sustainability standards between the trade and environment. We are particularly pleased to have Dr. Vasant Kumar Timakapura, agri-scientist, to be here part of the program, which reflects a relevance of the today's discussions. In recent years, the sustainability standards has been evolved around the environmental protections, labor rights, and the governance norms, which have a central roles in shaping the cross-border trade and in investment. In the context of Europe and India and this symposium, Europe offers particularly an importance lens through their investment leaderships and Green Deal and border adjustment mechanism. And India sees their position as one of the major trading partners and emerging economies. So over today's last day, we continue to talk on the agriculture role, on the investments and environmental protections. And we have Professor Venkata Reddy, who will be talking role of WTO and trade from India and protection of the environment in the domestic market. So I would like to extend my deepest gratitude to our distinguished speakers and participants. And our speaker today, we start first with Professor Dr. T.N. Venkata Reddy, retired professor, University of Agriculture Science, Bangalore, GKVK. And after the session, we have a questions and answer sessions, followed by the presentation by Dr. Vasant Timakapura, Managing Director and Chief Scientific Officer, Green Life Private Limited, Vijayanagar, Mysuru. And so we have a questions and answer session with participants who are present here and online. Then it is followed by Professor James Nidambura, Professor and Head of the Center for International Trade and Investment Law, that is Indian Institute of Foreign Trade, IIFT, New Delhi. Then we are privileged to have Professor Nicholas Desadler, the chairman of the Jean Monnet and professor at St. Louis University, Brussels, Belgium. Then followed by the last speaker, Dr. Giresh Kumar, associate professor, Department of Studies in Law, Central University of Kerala. Once again, I extend a warm welcome to all our speakers, participants, and my colleagues who are working behind the scene. Thank you.
Thank you, sir.
Thank you, Hasmi. Can you hear?
To introduce Professor Dr. T.N. Venkata Reddy, retired professor, University of Agricultural Sciences, Bangalore. Professor Reddy is a distinguished academician and policy expert who has made significant contributions to agricultural marketing, agribusiness management, and farmer institutional development over several decades. He has served on important national bodies, including the 12th Plan Evaluation Team of the Indian Coffee Board, Government of India, and has been closely involved in policy research, curriculum development, and institutional reform. He is the founder, mentor, and advisor of The Srinivasapura Mango Farmers Producer Company, a widely recognized model for farmer producer organizations in India. Professor Reddy has also contributed to major initiatives such as Raitara Sante Feasibility Study, ATMA evaluations, and the restructuring of agriculture extension systems, and has assisted NIA in drafting rules related to the Farm Laws 2020. As a mentor and teacher, he has guided PhD scholars and postgraduate students, delivered over 800 lectures, published more than 40 research and popular articles, and visited 27 countries across 4 continents. His work reflects a deep and sustained commitment to farmer-centric markets and sustainable agri-business systems. We are privileged to have his insights with us today. May I now invite Professor T.N. Venkatareddy to kindly deliver his address. Thank you.
Thank you, madam. Thank you very much to the organizers.
Sir, we cannot hear you.
Can you hear me, Asmi?
No.
Can you hear me? Okay. You can hear me, is it not? Hello? You're hearing me?
Sir, we cannot hear you. I think there's a technical issue. We sort it out in 2 minutes.
So you're hearing me, is it not, madam? You can hear me?
Yes, we can hear you, sir.
Okay,
yes,
thank you.
Yes. You may proceed,
Good morning, everybody. And I would like to dedicate today's my talk to the departed soul and ex-vice chancellor. In his memory, I will share some information for the benefit of participants. As you are aware, sustainable growth and development is the buzzword across the world, though we are greedy for growth and development. I will be sharing some information with special reference to food and agriculture and sustainability for international trade between the countries. So, global food security with environmental protection and social equity is need of the hour. Global food security, out of 800 crores population, we need to feed them by growing somewhere in the globe, but it has its own challenges. Approximately 1.2 billion people, or about 1/5 of the world's population, lives below the poverty line, defined as living on less than $1 a day. So legal mechanisms for enforcing sustainability standards, on one side, there are hunger and poverty. The other side, balancing the growth and development and export of food products and agri-related products is biggest challenge. And WTO has addressed to certain issues, but still lot of problems are there. Many miles to go. So legal mechanisms for enforcing sustainability standards in international trades are undergoing a major shift in 2026, moving from voluntary guidelines towards binding domestic regulations. No doubt many countries have evolved their own standards in the interest of the sustainable growth. But regulations enforceable as per mandate is also emerging with the extractional reach and integrated trade agreements. So international trade drives environmental degradation through various mechanisms, including physical transportation of goods, relocation of high polluting industries, and intensification of resource extraction to meet global demand. So deforestation is one, and habitat loss from cash crops in the guise of earning dollars, foreign exchange from developing countries, underdeveloped countries to the developed countries is a common phenomenon. So deforestation and habitat loss is a common phenomena even in developed countries. Example, soybean cultivation in Brazil and Argentina, vast areas of Amazon and Cerrado biomass have been cleared to produce soybean primarily for animal feed in international markets. You can see how they have denuded the forests to grow soybean to earn foreign exchange. And there is a need for balancing the need for exports and also environmental issues. Cattle ranching, illegal deforestation in Amazon is frequently driven by expansion of ranching of operations to export beef from Brazil. Who will monitor? And what is the fate of Brazil if it stops not growing coffee or not exporting beef? There is a need for balancing these issues. And Brazil is destroying almost 50 million to worth, just we cannot say express in terms of money, but this ranching of cattle resulting in denudation of forests just to get foreign exchange and supply the beef, where animal cattle ranching is very phenomenal in Brazil. Vietnam, a newfound industrialized and agriculture revolution country, is exporting to many countries several products. Out of that, coffee is very significant. But at what cost? Forest denudation, particularly in the central highlands, which produces 95% of Vietnam's coffee. Rapid expansion in 2005 and 15, growth of 29% in coffee, and equivalent amount of forests are destroyed in Vietnam. And what regulation, what domestic regulation, what international regulation, rules, acts can be passed in, agreements can be signed to avoid this denudation of forests to grow coffee in Vietnam. And moreover, the biggest challenge in Vietnam coffee is it is not shade grown coffee. They cut the trees, grow Robusta coffee facing 100% of the sunlight, and our evergreen forests are just going out of sight, out of mind. Whereas come to India, here is a solution where the international community, trade bodies, including WTO, can find a solution for this problem, taking a leaf out of India's experience, where coffee in India is grown under shade without removing the trees. Indian coffee plantation with shade trees. 100% of Indian coffee is grown under shade, utilizing well-defined two-tier mixed canopy and different types of trees. So we are not damaging forest species, whether it is Kerala, Karnataka, Northeast, and other states. 100% of Indian coffee is shade grown without damaging these trees, unlike that of what they do in Vietnam. So what is the legal framework that is required is encourage importing of coffee that is grown under shade, a self-imposed regulation. Of course, the international bodies can also think of legal solution to import coffee only grown in shade. And further, biodiversity, flora and fauna is damaged, but in coffee, if it is not grown properly, unlike that of Karnataka or India, like Vietnam, we are damaging the biodiversity. These forums support over 100 bird species and act as corridors for wildlife like elephants and endangered lion-tailed mosquitoes. Soil health, tree roots prevent erosion by up to 30%. And leaf litter enriches the soil with organic nutrients. So soil health, biodiversity is the need of the hour. Even climate resilience, shade trees sequester up to 20% more than carbon, sun-grown forums, and regulate micro limits. So it also adds additional income to the farmers by growing uh, crops like pepper, cardamom, vanilla, and other fruits like orange and banana. So international standards that needs to be evolved is to encourage shade-grown coffee and other mixed cropping pattern, encourage more soil protection. Another important industrial pollution in the world is textile dyeing and leather tanning. Most developed countries are pushing their activities to either underdeveloped or developing countries like Bangladesh and India. We call it as pollution heavens, India and Bangladesh, particularly in terms of textile and leather tanning, textile dyeing and leather tanning. Pollution have hypothesis suggest that. So textile dyeing, export-oriented textile hubs in countries like India and Bangladesh often discharge untreated toxic chemicals. So those who are importing leather products, definitely leather looks good, but at what cost needs to be known. Look at this textile dyeing unit in Bangladesh, polluting the water and contaminating even drinking water. So chemicals or effluents are left to the rivers, and there is a need for stringent this tannery where pollution is exorbitant. A town in Bangladesh and South India, Tamil Nadu, this tanneries is polluting, including Agra in Uttar Pradesh. There is a need for coming out with the standards, global standards for particularly this leather and textile dyeing without pollution, and standards needs to be accepted. Yet another biggest challenge is resource extraction and toxic waste, cobalt mining, oil extraction, and even when the whole world is looking for renewable source of energies, still we are heavily depending on fossil fuel like petroleum, and there is a need for long-term oil extraction for international exports has resulted in chronic pollution, devastating local ecological system and livelihoods. Even mining too, vital for global battery production. Cobalt mining is must in this era of to reduce the pollution, going for electric vehicles, EVs, smartphones. Cobalt mining has caused, on the one side we are reducing the pollution, other side we are also increasing the pollution. We need to draw the somewhere balancing act. In cobalt mining, a lot of pollution is taking place. Oil extraction in Nigeria, unchecked pollution, even drinking water is polluted. Even their food is polluted, water is polluted. So there is a urgent felt need for coming out with a regulatory mechanism across the world, particularly through WTO or ENO or UNCTAD, United Nations Conference on Trade and Development, trade without damaging our nature, and how to do it is left to the legal experts to come out with strategies, provisions to avoid this pollution in different aspects of economic activity across the world. So emissions and invasive species from transportation, logistics, moving goods across the globe also contributes to the atmosphere and biological degradation. Greenhouse gas emissions is a common, and invasive species may move from one part of the globe to another part, totally disturbing the ecological system that exists in one country because of its invasion of. The best example we can quote is Parthenium weed that was entered India while supplying wheat from USA is the biggest menace for crop production in India, and it is a threat, health hazard. So, how to address to this? Obnoxious weeds, diseases, plant diseases are being, no doubt there is sanitary and phytosanitary provisions, but still a standard procedures needs to be evolved, and there is a scope for legal experts and scientific experts sit together and save this globe from dangers of this pollution in different parts of the world. In greenhouse gas emissions from agriculture is also a big culprit, though agriculture is very part of natural environment. Still, agriculture and forestry contributes 22% of the greenhouse gas emissions, and biggest culprits are European Union, where this greenhouse gases release is more than developing countries. So industry, energy supply 34%, transport 15%, greenhouse gases is another area where a standard procedures needs to be evolved and accepted by all countries in the international or global forum. Electronic and hazards, no doubt, electronics software and is developed so much. At the same time, it is creating a e-waste in Western of Africa. Large quantities of old electronics are exported to regions like West Africa. The developed countries will dump this e-waste elsewhere to save their country, but finally one world, one human beings. We are forgetting this. It is moving to dirty technology and waste from developed to developing nations should be stopped, and uniform standard procedures needs to be adopted. Say, look at this thrown in West Asia, West Africa, and recycling or avoiding some standards needs to be adopted across the globe. Yet another major disaster, I can say, in Southeast Asian nation. No doubt, edible oil adds to the taste and culinary needs of Asian food habits. Palm oil is widely grown in Indonesia and Malaysia. Tropical landscapes have been transferred into palm oil plantations. Perennial rainforests are damaged. To satisfy global food and cosmetic industries, leading to significant biodiversity loss. So in Southeast Asians, particularly Indonesia and Malaysia, palm oil cultivation has been significant driver of deforestation, which are the world's largest producers of palm oil. India is the largest importer of palm oil. So this needs to be stopped. How? Not by discouraging import of palm oil from Indonesia and Malaysia, but putting restrictions on those countries to certify the origin of the product without damaging the rainforests, perennial forests, to grow palm oil. And you can see from this picture, they're cutting the forests to grow palm oil, to export, to earn foreign exchange, and cheapest edible oil in the world too. But at what cost is the biggest question? How to draw the say some kind of balancing act is before the legal luminaries in the world to come out with a global standards to avoid this denuding of natural forests. The process of cleaning land for palm oil plantations often involves removal of vast areas of tropical rainforest, leading to adverse impact. And they have defined deforestation, loss of biodiversity, including habitats of endangered species such as argonauts, tigers, and elephants too are becoming endangered. You can see oil palm and forest in peninsular Malaysia, where they're damaging the rainforests and going for palm oil. Loss of biodiversity is common sight in both these countries, threatening the survival of many other species, habitats, even animals. Palm oil impacts on biodiversity is common in these two major countries. How to address to this issue? How to frame the legal framework to avoid this denudation of forests and protect the ecology and environment, protect the endangered species is our responsibility to the next generation, younger generation in the world. In carbon emissions, clearing forests, especially peatlands, release significant amounts of carbon dioxide into the atmosphere, contributing to the climate change. Peatlands are the virgin natural lands formed due to the organic matter of plants undecomposed. Now it is being damaged, and carbon emissions are alarmingly increasing in several parts of the world. So soil degradation is another biggest challenge where sustainable development, growth, food production, and at the same time feed 800 crores of population in the globe is the biggest challenge. It has taken several centuries to form the present soil, which is fit for crop production. But due to so many reasons, the soil degradation is fast happening and leads to soil erosion and degradation, reducing the land's fertility and its ability to support diverse plant and animal life. So avoiding this soil erosion by various means, which should be made mandatory across the globe by international organization, is need of the hour. Water pollution. Many of the developing countries forget about pure water. Even they don't get polluted water. The responsibility of WHO, World Health Organization, is to see that at least drinking water is not polluted. How to arrive this? Lot many schemes have been introduced, and best among them in India is Jal Jeevan Mission, providing drinking water through pipe to the extreme rural areas of India is one where drinking water is being provided to the poorest of the poor, even in rural India. Use of fertilizers and pesticides. And as you are aware, the chemicals that are pesticides banned in developed countries are indiscriminately used in developing countries, polluting our water, polluting our soil, polluting our rivers. Hence, water pollution needs to be stopped. How to do this is the biggest challenge. You can see Bangalore, called Silicon Valley of India, next to California. You see, this is the hub of electronic city where the pollution by chemicals and polluted water uh, is there in Bellandur area of Bangalore city, the capital of Karnataka and pride of India. And until and unwise, we addressed this, stop this kind of pollution by standard legislations in spite of Environmental Protection Act 1986 and so many other legislations. In practice, we failed. The public are not sensitive to these issues. So it is time to protect protect our waters, natural waters, and avoid pollution of water. So in this direction, efforts are being applied in different parts of the world to mitigate, to reduce this kind of pollution through voluntary sustainability standards. Voluntary sustainability standards, such as the Roundtable on Sustainable Palm Oil, promotes sustainable practices in oil production, palm oil production. So voluntary sustainability standards play a significant role in market access regulation. Say, for example, if palm oil importing country stipulates that we don't import palm oil if it is until and unwise they give certificate that it is not grown by destroying the forests, will have a long term impact on protecting the forests in Malaysia or Indonesia. So market access regulations. Say, example, India is the biggest importer of palm oil from Malaysia. If India bans palm oil import from Malaysia from the sources unknown where it is not certified for not denuding the forest, will go a long way. And legal luminaries across the world needs to think about this, frame the roles, protect the globe. So VSS are increasingly recognized regulations that determine whether products can access specific markets, like I quoted the example of India and palm oil. Compliance with VSS becomes mandatory for market entry. That will go a long way. Come to Republic of Korea, they have enacted the act on the sustainability use of timbers, recognizes VSS as certification like FSC and PEFC as proof of legality for timber imports. So until and unwise these certificates are enclosed, they don't allow timber to be imported into South Korea or exporting. European Union's Renewable Energy Directive, RED, Renewable Energy Directive, requires biofuels to meet sustainability criteria and VSS certification. For example, Roundtable on Responsible Soya and Roundtable on Sustainable Biomaterials are used as proof of compliance. European Union is leading in this direction. Republic of Korea Act on the Sustainable Use of Timbers and Forest Stewardship Council, FSC, Forest Stewardship Council, and Program for Endorsement of Forest Certification are the important decisions taken by them. This needs to be replicated elsewhere, particularly in African countries, where in the guise of development growth, they're denuding the forests and having a long-term negative impact on ecology, environment, and sustainability, very survival of human beings on this earth. So the sustainable standards products adversely affects, ensures that environmental, social, and economic sustainability standards. It is time that legal experts, crop production experts, agriculture economists sit together and come out with the standards for environmental, social, and economic sustainability, preventing deforestation, reducing carbon emissions, and protecting labor rights. In summary, VSS are increasing used in market access regulations to ensure sustainability and compliance with legal and ethical standards, but their integration into public policy requires a careful evaluation to address potential shortcomings. Market access regulations or the law acts legislations needs to be strengthened at the global and bilateral trade. More so, very recently, India and UK, India and New Zealand, India and Oman entered into a free trade agreement. It should be made mandatory for all these free trade agreements to see that this voluntary standards, sustainability standards in international trade shall be made as a part of this free trade agreement. And also, very shortly, India and European Union is going to sign a historic agreement on free trade agreement. So it is time for our Nicholas and other legal experts from Europe to see that these clauses are incorporated, to see that ecological balance is maintained in this free trade agreements provisions. Private and voluntary regimes are emerging at the global level to increase and overshadowed by law, not as a mandatory, not as per the rule, but there is some voluntary wisdom on the trade bodies and general public, environmentalists like Greenpeace, where private mechanisms still play a role in voluntary sustainability standards and certifications. For example, fair trade. Fair trade is a trademark certification given on those commodities for domestic trade and consumption, and also international trade and consumption, means starting from production till consumption, fair practices are followed, not damaging the environment and ecology, not exploiting the even laborers will entitled to get this fair trade tag. And another thing what we see is say shade grown coffee certificate, where without damaging the flora and fauna in Western Ghats of India. So this act aims to combat illegal deforestation and prevent the sale of illegally harvested timber from Republic of Korea. And this voluntary sustainable standards certificates from recognized VSS organizations like FSC and PEFC. Many such organizations needs to come forward to issue certificates voluntarily, which across the world, not only by regulation or act or as a mandate. The collective responsibility and wisdom also helps to maintain this sustainable standards in international trade. This market access regulations highlights their growing importance in ensuring sustainable and legal practices in global trade. As per some estimates, $28 trillion trade happens across the countries in the world every year. But we are interdependent. No doubt, cross-border trade is a must, without which no country is 100% self-sufficient. But in this process, to earn foreign exchange, to feed the affluent, we should not damage the ecology and environment, and making this globe unsafe to live. So multilateral framework has been signed in WTO. This World Trade Organization remains the primary global platform. Balancing trade openness with environment protection is need of the hour. So basically, for bilateral agreements, multilateral frameworks through WTO to address to these issues will go a long way in maintaining sustainable standards in exports. Regional trade agreements, that's what I told. Regional trade agreements like ASEAN agreement, ASEAN, SARC agreement, regional trade agreements increasingly include dedicated trade and sustainable development chapters. ASEAN agreement or European Union agreement or this many other such agreements, SARC agreement led by India, regional trade agreements also should look into these issues. Regional trade agreements, binding committees, recent agreements like CPTPP and EU Mercosur include enforceable provisions on biodiversity, marine pollution, and climate goals, even in Europe. So, regional trade agreements, sanction mechanism. Some regional trade agreements allow for the suspension of preferential trade access if environmental conditions are breached. No doubt they will sign. They say we don't do it, but they violate. In such cases, suspension of preferential treatment in this free trade agreement, regional trade agreement, should be made as a mandatory if they violate or breach the terms and conditions of free trade agreement or regional trade agreement, and sanctions should be imposed. So impact of this regional trade agreement, detailed environmental provisions in RTS have been shown to limit agriculture land expansion and promote regulatory cooperation. Impact is very, very severe. So basically, corporate due diligence. European Union is focusing on this corporate due diligence. If you look at the major multinational companies, corporate companies in FMCG and other major products, food products, they are the first culprits. So there is a need for corporate social responsibility, not only the corporate social responsibility, corporate environment responsibility. Corporate environment responsibility, not as a mandatory, at least a self-imposed regulation. The policies needs to be evolved, and legal experts should contribute to frame the guidelines in this area. European Union has emerged as a global norm setter through mandatory due diligence framework, in European Union, and that needs to be strengthened and extended to other parts of the country. The European Union Corporate Sustainability Due Diligence Directive is signed and they are at it, and this needs to be strengthened further for sustainable growth and development of trade between the countries, between the continents, and across the globe. So corporate sustainability due diligence directive, CSDDD, is also being adopted in different parts of the countries. So this EU member states must transpose this into national law by July 26. Already they have given some deadline. European Union, this particular agreement has given deadline to be adopt this national law by July 26. It mandates that large large companies identify and mitigate environment risks across their global value chains. Value chains and supply chain by the multinational companies is also biggest polluter of our ecology and environment. So this CSDDD mandates that large companies identify themselves and mitigate environment risk across their global value chains. So corporate national authorities will be empowered to conduct investigations, issue compliance orders, and impose fines up to 5% of net worldwide turnover, particularly to these multinational companies. Civil liability. Victims can bring lawsuits in European courts against companies for damages caused by failure to conduct proper due diligence of this EU initiative. So consumers can sue them if they don't adopt this guidelines, adversely influencing the health of negative impact on health of the common man or consumers. And WTO is another biggest organization without much teeth, where few countries cares least for WTO, impose to their whims and fancies of conditions, whether it is tariff or sanitary and phytosanitary or trade related intellectual property rights. WTO needs to become more assertive, and it should be in the interest of the all member countries to come out with a sustainable standards for all commodities, all trade across the globe, not only for the international trade, even for domestic trade. Sustainable development and environmental protection are goals of the WTO. They should think of and what their primary objective is. The WTO primary objective is to develop sustainable environment protection is the very primary objective of WTO, of world resources, sustainable development, protect and preserve environment is the fundamental objective of our WTO. And these goals are enshrined in the preamble of the Marrakesh Agreement in Morocco, which was held long back. There was an agreement, but it needs to be turned into a practicality. Otherwise, it remains on the paper, and the legal experts should contribute how to further simplify this without acting as impediment to the growth and development, food security, and addressing to the poverty issues. So WTO members aims of upholding and safeguarding an open and non-discriminatory multilateral trading system. At the same time, no country should use this environment as a sabotage to discourage some country to play a role in the international trade, to earn livelihoods. For example, Bangladesh, major source of income and its foreign exchange is from export of the garments, ready-made garments. Lot of issues are involved in Bangladesh, whether it is low payment and pollution of water, long working hours, labor welfare. All this needs to be addressed. Sustainable development and protection, environment and human beings. WTO should think of this. And in 2002 Johannesburg summit, lot of Doha meet, so many meets were held, and still there is a need for sustainable, long-term, acceptable procedures for protecting our environment, ecology, and make this globe safest place to living of human beings, animals, flora and fauna, and it is the responsibility of the WTO also. So Committee on Trade and Environment is there in WTO. Multilateral environment agreements have been done, and Doha Development Agenda and Environment is also there, but Doha Round is the first time environmental issues have featured explicitly in the context of a multilateral trade negotiations, where all countries are party to this agreement signing. So, and it is time to review to see how it is being implemented in practice, executed, is the need of the hour. Since environment problems often transacted on national, international borders, response must involve concentrated action on international level. WTO members have long recognized the need for cohesive amongst international institutions addressing global environmental challenges. So, legal mechanisms for enforcing sustainable standards in international trade have transited from voluntary soft law to mandatory hard law. So, if leave alone to the choice of the countries, they will have a soft view, soft law, not very regressive, not progressive also. So it should be made mandatory. Hard laws needs to be framed through several key regulatory layers. As of January 26, the primary mechanisms include multilateral WTO disciplines, uh, technical barriers to trade, sanitary and phytosanitary measures, and the different provisions of the old GATT provisions, free trade agreements, trade and sustainable development chapters, labor and environment panels, unilateral mandatory due diligence, where EU has already shown the way, carbon border adjustment mechanisms, EU CBAM fully entering force in phases requires importers of energy intensive goods like cement, iron, and steel to pay a carbon price equivalent to what domestic European Union producers pay. This needs to be addressed particularly from the point of view of developing or underdeveloped countries. Corporate reporting and transparency needs to be strengthened, and corporate sustainability reporting directive is already formed, particularly on environmental, social, and governance issues. Voluntary sustainability standards, often initiated by the private, needs to be made as public by the concerned countries and their governments. Drivers behind rise of this voluntary sustainable standards, several factors contributed to the proliferation of VSS between 19 and 2010, and Republic of Korea, compliance and mandatory. Act includes standards specifying recognized document and certifications including VSS, FSC, and PEFC. This needs to be addressed in other areas. This is my brief introduction of agriculture, food, and sustainable ecology and environment in the global trade. Hasmi, if any questions?
Thank you, sir. Thank you, sir. We would like to see from audience. Do you have any questions?
Sir, the forum is open for questions.
And interview, please.
Yeah. After the question and answer session.
No, you can put. You do.
Yeah.
Call behind as well as after. You have any questions? Is the time.
So if you're not able to unmute yourself, you can type your questions in the chat box. We see none, so you may continue the auditions. Please.
As we conclude this session, I extend my sincere gratitude to our distinguished speaker for a thought-provoking and insightful lecture. The discussion powerfully highlighted the interconnected challenges of global food security, ecological vulnerability, and sustainability in both developed and developing countries. By drawing attention to traditional and regional specific sustainable practices such as shade-grown plantations, alongside environmentally harmful activities like unsustainable tanning, extractive industries, and monoculture cultivation, the lecture underscored the need for context-sensitive regulatory frameworks. A particularly significant contribution was emphasized on corporate environmental responsibility, reminding us that sustainable trade requires accountability across global value chains, especially as industrial activity and energy consumption in global north continue to contribute disproportionately to environmental degradation. The call to strengthen sustainability at all levels of trade, bilateral, regional, and multilateral, resonated deeply, reinforcing the idea that trade must serve not only economic goals but also environmental protection and global equity. On behalf of the organizers, I thank you, our speaker, for these valuable insights and all participants for their engaged presence. Thank you.
Thank you very much for giving me opportunity to be part of this great initiative, and Hasmi and Nicholas and National Law University and University of Mysore and JSS. Thank you very much, madam.
This is the Irish is the main.
అదే మోహన్ ఫోన్ వచ్చింది నాడ ఆన్లైన్ లో ఉన్నప్పుడు చెప్పకూడదు.
క్లాస్ లో ఉన్నారు అదే చెప్పారు వీళ్ళు వచ్చింది అని స్టేషన్ ఉండాలంట
వాళ్ళకి ఎవరికైతే పంపించి వాళ్ళ దగ్గర రేట్
అదే అవుట్ ఆఫ్ స్టేషన్ ఉండాలి
ఓకే
వస్తారు.
Now, it's our pleasure to invite our second speaker, and I may request Ms. Parvati to introduce Dr. Vasan Kumar Thimakapura, and sir, we request you to take the stage and proceed with your today's presentation.
Our second speaker for the day is a person who beautifully bridges science, society, and service, and whose work speaks directly to the realities of Indian agriculture. Dr. Vasan Kumar Thimakapura is a distinguished agricultural scientist, plant pathologist, science communicator, and social innovator, widely known as the plant doctor among farming communities. With a PhD in plant pathology from the University of Mysore, his pioneering research on seed-borne fungal diseases of maize set new academic standards and laid the foundation for decades of impactful fieldwork. Dr. Thimakapura chose to step beyond conventional academia to work directly with the farmers, translating scientific knowledge into practical, farmer-centric solutions. Through agriculture consultancy, research and extension services, he has developed path-breaking organic plant health solutions and innovative microfinance models that have benefited thousands of farmers across India, often through interest-free, trust-based support systems. An author, researcher, teacher, and mentor, he has received numerous national and international awards, including the Karnataka Rajyotsava Award and the Karnataka State Agricultural Award of 2024, in recognition of his lifelong service to sustainable agriculture and farmer welfare. It's truly a privilege to learn from someone who combines scientific excellence with deep social commitment. May I now invite Dr. Vasant Kumar Timakapura to address the gathering.
Thank you very much for the nice introduction. Good morning to everyone. Professor Nicholas, Secretary, Professor Mini, and Dr. Syed Kudrat Shimi, and all the distinguished participants, Professor T.V. Reddy, and my dear students. It's a great pleasure today to be with you today to share some of my thoughts on agriculture and farmer. Before that, I also would like to convey my heartfelt condolences to the family and friends of the departed soul, the former Vice Chancellor of this great university. So we have prayed for his departed soul. So with this, I want to thank the organizers, especially Professor Mini for inviting me here. And also it's a great opportunity to personally meet Professor Nicholas from Belgium. So today's my topic is agricultural policy in India, from populism to pragmatism. So before I start, I want to ask a question to all of you. What do you feel when you see this picture? What do you feel?
Happiness.
Happy? Nice, isn't it? Very nice. Now, what do you feel?
Sad.
Sad, isn't it? It's not a welcome scene for any one of us. So, nearly 800 million people in the world, out of 8 billion people, go hungry every day. They don't have a bed. Normally, we say they go to bed hungry. No, they don't have bed even. So, they spend days without any food and they starve. Some of them will even die. Which is the biggest enemy of humanity? So people think it is war. The wars are the biggest enemy, and sometimes people say religion is the biggest enemy. But actually, it is hunger is the biggest enemy of the worst enemy of humanity. And without any weapons, the hunger has killed more people than the two world wars put together. So that is the power of hunger. So we all aim to end hunger. A society that tolerates hunger, despite having science, surplus, and solutions, is not poor. It is morally bankrupt. So COVID has taught us very recently that one is the importance of virus, the power of virus, and also the power of the food. So we all survived during COVID time to lockdowns, that we survived without anything, but not without food. And the farmers toiled more during the COVID time because we ate more during that time. Yeah. And when we were relaxing, eating, watching TVs, reading books, doing something, the farmer was toiling in the sunshine or rain to produce more food to us. And in India, the GDP, 17%, which was 17%, went up to 20% during the COVID time. So we all know now that food is the first and the most basic need. Sorry. So, but the food is not produced in the factories. No, it's not produced in the factories, but it is produced in the farms and it is produced by the farmers. And no farmer means no food and no future. It's not special only to India, but it is worldwide. Even in Europe, even in America, even in Japan, wherever you go, no farmer means there is no food and no future for any one of us. So, but we are in India, we are producing enough food, but still there is shortage or there is some problem in distribution. And in some countries, still there is shortage of food, even today. During 1960s or before Green Revolution, when we got our independence in India in 1947, it was not a real independence. It was just a political independence, but because we were still depending on other countries for food imports, there was so much of food shortage. And the situation, what I have personally experienced and seen is that only when the ship arrived from United States, we had the food. So we survived due to the kindness of people of United States of America who donated food free of cost to us. So our prime ministers were in US with their begging bowls. So that was that situation was called ship to mouth situation. Then the Green Revolution happened because one professor, Dr. Norman Borlaug from United States, developed high-yielding, disease-resistant, dwarf varieties of wheat. The technology transformed the food production system, and we could follow the same revolutionary technologies to make our other crops like rice or pulses, oil seeds, everything, fiber crops to produce more. So that is called Green Revolution. And our first Prime Minister, knowing the importance of agriculture, he said anything can stop, but not agriculture. Our second Prime Minister, Lal Bahadur Shastri, said Jai Jawan, Jai Kisan, because he knew that the food security is as important or more important than the border security. So we need both farmer and the soldier. So if you have eaten your food today, thank you, farmer. If you have slept peacefully last night or all these nights, thank you, soldier. So India is basically an agrarian country. It used to be, and it continues to be, and it will, even in future, it will be an agrarian country because we are today more than 145 crore people. And when we didn't have food for 50 crore people in 1960s, we are producing enough and more for 145 crore people. So when I was in high school, we were only 50 crore people and we were producing 50 million metric tons of food. And the contribution of GDP from agriculture was more than 50%. And now we are producing more than 330 million metric tons of grains and pulses and more than 350 million metric tons of horticultural crops like fruits and vegetables, including flowers. And now the GDP percentage is only between 17 to 20%. But now we have reached the self-sufficiency. So there has been a quantum leap in our grain production. That is a very welcome situation for all of us. If you go to supermarket, not you just see the green revolution. You see all the colors of the rainbow. All the 7 colors, even more, because of the horticultural crops, that is fruits and vegetables. These are the sources of our vitamins and minerals, and that is the strength of our health of our country. It's not only in the supermarkets, but even on the streets, we can see the same colors on the streets. It means we have been able to produce enough and more for more than 145 crore people today. So let us be thankful to our scientists who developed these technologies and the policymakers who introduced these technologies and made it available to the people, and the bureaucrats and the agricultural officers And even more than anyone, we should thank our farmers. Only if they produce using the technology, then we can have enough food here. So, but we are all happy because if you have money today, we can buy any kind of food today, any kind of fruits, any kind of vegetables, any quantity, any quality. That is the kind of situation. But when farmers didn't have any problem, when they themselves didn't have food in this country, now they are undergoing a serious stress. So we have reached from food scarcity to food security. Because of this sufficiency, the government had the courage to bring in the food security bill and the right to food. And nearly 50% of the people are involved in agriculture. But farmer suicides are increasing. Suppose this situation continues, who will produce food for us in the future? Our time is over. Now it is all your time, youngsters' time, and your children's time. So who would produce food for us? If we don't think of our farmer and if we don't support farmer through technologies and more than technology, the policies, we need to address the problems of the farmer. We need to make his profession more dignifying and profitable. Then only he will stay back in agriculture and will continue to produce food for all of us. So this is the situation. And when you think of the academic points, what are the reasons of this kind of dismal situation? We quote these 7 points like weather vagaries, pests and diseases, increased cost of cultivation, diversion of loan into non-productive reasons, volatile prices, middlemen, money lenders, and most importantly today I'll be talking about the agricultural policy in India. So even policies have created a lot of problems for the farmers. And in my own experience, I have found 2 more reasons why farmers are not able to sustain and lead a dignifiable life. One is lack of knowledge of scientific cultivation. So I'm an advocate of knowledge of scientific cultivation and financial literacy. Because modern farming, because the scientists in the universities, in the institutions, in the private sector have developed so many productive technologies, modern technologies. But this modern agriculture is very, very knowledge intensive and very, very investment intensive. Because he doesn't have the right knowledge about these technologies and he doesn't know how to save money, how to use money, how to invest money. Because of this, sometimes he will not have money to buy the critical inputs at the right time. So this is resulting in reduced productivity. So low productivity means diminished profitability. It leads to lowest repaying capacity to the banks, and he gets into the net of debts. So it's he gets into the vicious cycle of debt, and he ends up in suicides. What is the problem? Production wise, our country is very fine, very fine. We are producing, as I said, enough and more. But the productivity per unit area, per unit resources, unit time, unit effort is no way comparable to United States and China. And even it is much less than the world average. So I think this is where we need to identify the problem. We have identified the problem. And then instead of treating the symptoms, we need to treat the cause, root cause. And fortunately or unfortunately, India is number 1 in terms of population. I don't know, it is a thing to celebrate or thing to worry. But the challenge in front of us is to produce more from less. Because land is shrinking, we cannot increase any land under agriculture. So water is becoming more scarce and scarce. And labor is not available in villages because all the youths have moved to the cities because agriculture is no more profitable and no more respectable. So there is no girl is ready to marry a farmer today, and it has become a very big social problem. So they want to move to the cities, so they get hold of some job so that they can get a girl to marry. So labor is not available to do many of the agricultural operations. And we know that we are using chemicals, fertilizers and pesticides very indiscriminately. We need to reduce the use of these chemicals to possible extent. And we also should be able to produce more from less cost. Then only the profitability will come. So the agriculture remains the backbone of the Indian economy and society. It provides livelihood to more than 50% of the population and ensures food security for over 145 crore people. Yet, paradoxically, the average Indian farmer continues to struggle with low profitability, climate risks, market volatility, and policy uncertainties. While India has achieved remarkable success in food production since the Green Revolution, the focus of agricultural policy has largely remained on short-term welfare measures rather than long-term empowerment of farmers. So that is the point what I am going to focus on with my own experiments and results. The policies are often framed from urban or bureaucratic perspectives with limited grounding in the field realities. Most of the policymakers, they will not have even seen the villages. They will not even met a farmer and talk to the farmer. So they actually frame the policies, so they will not have any idea about the field realities. The central question therefore arises, are Indian agricultural policies designed to empower farmers or merely to manage natural distress, rural distress? That is the point. Indian agricultural policy has traditionally relied heavily on subsidies for fertilizers, electricity, irrigation, seeds, etc. So, while subsidies initially helped boost production, their indiscriminate continuation has resulted in soil nutrient imbalance, decline in soil organic carbon, overuse of urea and water, and stagnation of productivity. So subsidies without scientific guidance often lead to ecological and economic damage rather than sustainability. That is what Dr. Reddy was mentioning. Agriculture is also contributing the second largest or third largest polluter of the environment is agriculture. So how do we frame policies such a way that we contribute less to the pollution of the environment? What are the limitations of existing agricultural policies? The present crop insurance and disaster, I am coming to the insurance first, the relief mechanisms suffer from multiple shortcomings like delayed and inadequate compensation, low trust among farmers about the insurance and their companies, high premium burden, so they don't want to invest because they don't have money to invest in agriculture itself, so they don't want to invest in insurance, and administrative complexities. When there is a disaster, to claim the insurance, they have no idea how to approach, whom to approach, when to approach, and it takes its own sweet time, and so the farmers are not interested and they are not taking any insurance. As a result, farmers remain vulnerable to droughts, floods, pest outbreaks, and disease epidemics. Weak agricultural extension and knowledge transfer. This is the most important one. India doesn't suffer from lack of agricultural technologies, but from lack of effective translation of science to farmers' fields. As I mentioned, our scientists have worked hard and produced many technologies which would improve the agriculture and agricultural productivity, but we have utterly failed in transferring this technology or knowledge of technology to the farmers in an effective manner. India, yeah. And market inefficiency and value chain inequity. Farmers are the primary producers, but the beneficiaries in the agricultural value chain. Challenges include limited MSP coverage, price volatility, exploitation by intermediaries, and poor harvest infrastructure. This discourages diversification and innovation at the farm level. As I said, the limitations of existing agricultural policies, the weak agricultural extension and knowledge transfer. Public extension systems are overstretched, while farmers increasingly depend on unverified advice from input dealers or social media. They are heavily depending on the pesticide or seed dealers or fertilizer dealers for their knowledge, and also on social media, YouTube channels, and other sources. So here is a missing farmer's right, that is right to scientific agriculture knowledge. This is my own proposal. The farmers themselves don't know that what exactly they need. They ask for scientific pricing or a minimum support price, but they ask for loan waivers and subsidies and crop loss compensation, but they ignore the root cause, lack of scientific cultivation knowledge. So unless the crop is grown scientifically, there is no meaning for scientific pricing. Suppose for sugarcane, they have fixed 3,500 rupees per ton of sugarcane. If you grow 100 tons, it's a wonderful price. If you grow only 40 tons per acre, then 3,500, no, even 4,000 is not sufficient. So that is how only when you follow the scientific technology and properly, then only you will be able to produce more than 80 tons. And that 3,500 is a very good price. So recognize right to scientific agriculture as a farmer's right. They should have continuous access to scientific guidance, soil and nutrient literacy, diagnostic skills for diseases, pests and deficiencies. They themselves should be able to diagnose, and they should know what to spray, what not to spray, and how much to spray, when to spray, and which method to apply the chemical. And integrated pest management and eco-friendly protection methods. He should be given that knowledge firstly, and market awareness and post-harvest knowledge. So a pragmatic framework for agricultural policy is knowledge as the first subsidy. First, before giving any subsidy, you give first in knowledge. That is the first subsidy. The most effective support to farmers is knowledge. A pragmatic policy must prioritize free, unbiased, science-based advisory services, village-level crop diagnostics, crop-specific decision support systems. A knowledgeable farmer requires fewer subsidies and makes better production decisions. So the government can save a lot on subsidies. So it is the real empowerment of farmer in terms of knowledge. Soil and plant health must be treated as strategic national resources. Policy focus should include restoration of soil organic carbon. Even Dr. Reddy was mentioning about the carbon. The carbon should not be in the air. It should be more in the soil. Then it is beneficial to everyone on the earth. More the carbon in the air, it is problem to everyone. More the carbon in the soil, it is more. So that is what we should increase the soil carbon, organic carbon, balanced plant nutrition beyond NPK. We are only urea-minded people. In India, we have subsidized urea so much that farmers want to use urea heavily, and it has created so many other problems. It is like eating only rice without eating any protein. Okay, so protein is like potash, is like protein. So we eat less of, we give less of protein to the plants. We give more of rice. So it leads to diabetes and heart problems and kidney problems and so on. So that is what has happened to our soils. So emphasis on disease prevention rather than effective prevention. So it is said that prevention, even for human beings, it is said that prevention is better than cure. So by giving balanced nutrition to the plant by maintaining good organic carbon in the soil. The crop itself, the plant itself can resist some of these pests and diseases. So 50% of the chemical pesticide load can be reduced by giving balanced nutrition. So healthy soils and plants from the foundation form the foundation of sustainable product in India. Dr. Swaminathan says, the soil anemia leads to human anemia. We hardly realize that our health comes from plant health and plant health comes from soil health. So the soil health is very, very important. How to maintain the soil health? That itself is a big science and we can discuss some other time. So for extension, we are only looking at departments like agriculture, horticulture, sericulture, and sugar industries and things like that. Actually, the banks are the biggest losers because of loss to the farmer, because they are the ones who are financing the farmers. So if it doesn't have the repaying capacity, who loses the money? With interest, the banks. So the highest NPA, non-productive assets, are from farming. And next is MSME. So they are losing so many crores of rupees every year, thousands of crores every year. If they invest just 10% of that money for agricultural extension, then they can really improve the productivity of farmers, because farmers should not be treated as a borrower. He should be treated as a producer partner, because only when he produces a good crop, then he will be able to repay the loan with interest. So only when he pays the loan with interest, then bank survives. So the survival of the banks depends on the farmer's profitability. So it is though it is not mandatory for banks, they should really think about doing this agri extension service to the farmers in its own interest. So fertilizer subsidies, the policies on fertilizer subsidies has also caused so much of imbalance. India's subsidy structure has unintentionally, it's not intentional, but very unscientifically framed policies have created this unintentional, distorted farmers' behavior. Because urea is very cheap, just 6 to 7 rupees a kg, which gives 46% of nitrogen. So he uses heavily and leads to deficiencies in other fertilizers, nutrients like potassium and other micronutrients. So imbalance in fertilizer. You see, if you look at the share of fertilizer products in India, MOP, that is muriate of potash, is only 9%, whereas urea is 50%. And DAP also 19%, which has also got nitrogen. And the NPK fertilizers, they also have nitrogen. And this potash is only 9%. So there is a huge imbalance between nitrogen and potash. And look at the latest subsidy, this thing. Nitrogen gets 43 rupees per kg subsidy. That is DAP. Phosphorus gets 43.6%, whereas potash gets only 2.2 rupees 38 paisa per kg. Not percentage, it is rupees. So there is huge imbalance. So this has created excessive vegetative growth. More nitrogen means more vegetative growth. It becomes lush green and grows luxuriantly, but it is more sweeter and succulent, and it attracts all kinds of insects, bacteria, fungi, virus, everything. So it becomes more vulnerable to pest and disease attack. So crops look lush, but they are weak internally. Higher vulnerability to pests and diseases. It means more pesticide use. It means more cost of production and more pollution and more residue in what we eat. Yield instability, especially under stress, because it cannot have hard tissues in that, so it cannot sustain that drought or salinity in diseases. And it decreases the soil health, because you put more nitrogen, it reacts with the soil chemicals and it becomes unavailable to the plants. So soil organic carbon depletion happens because of this nutrient mining, and environmental damage due to nitrate leaching and water pollution. Economic loss due to farmers spend more later on disease and pest control. In short, India has moved from under-fertilization to mis-fertilization. The fertilizers, as such, they are not the problem. The imbalance is the problem. So nitrogen, phosphorus, and potassium have complementary roles. Nitrogen is for growth, phosphorus is energy and roots, potassium is for immunity, stress tolerance, and quality of produce. Ignoring one is like feeding a child only rice without vegetables or proteins. Growth happens, but immunity collapses. So why the policy must change? The current system rewards excess and penalizes balance. To correct this, subsidies must shift from products to nutrient-based equity, encourage site-specific nutrient management, promote soil testing and micronutrient inclusion, support organic carbon building practices like compost, cover crops, biostimulants, etc. And farmers should be empowered with knowledge, not just cheaper inputs. The larger impact is that this will fix and not only improve productivity, but also reduces chemical pesticide dependence, improves farmer profitability, enhances national food and nutritional security, restore degraded soils and ecosystems. This is one of the simplest reforms that can create largest ecological and economic impact. If we correct the policy, farmers will correct the soil. When soil is balanced, agriculture becomes sustainable. Fertilizers are not the enemy. Ignorance and policy distortion are. So, next one is plant disease management, a missing policy dimension. Plant diseases, especially viral diseases, root rots and wilts, cause enormous economic losses. We know that. Even in Kerala, the pepper, black pepper, the very crop for which the Portuguese came to Kerala, the French or Britishers came to Kerala, that is in the decline. So India used to be the number one in the world, and we lost that position to Vietnam. Dr. Reddy was telling the Vietnam is one of the largest coffee producers, but also pepper producers. Why did we lose this? The position, number one position. Karnataka became next. Karnataka is also losing, and India has lost in total because of one particular disease called wilt, that is quick wilt of black pepper. So that's what I am taking. So diseases and pests take a huge toll. That is more than 30 to 35% of the crops are being lost to these kinds of diseases. And there are cure for certain diseases, but there are no cure for certain diseases, and especially for viral diseases. Even in pepper, viral diseases were not heard of in Kerala. But nowadays, if you go to plantations, the farmers will be talking about, in addition to quick wilt, about the viral disease of black pepper. So, however, agricultural policy has largely ignored virus disease management, curative plant health solutions, and integrated pest and disease management. Soil health and plant health must be recognized as a critical component of national food security. Sorry that the agricultural insurance slide came first. So, to continue with that, so agriculture disease management fund, this is my proposal to the government. Instead of crop insurance, they should form a different exclusive fund only where disaster happens in the country. That fund, the money should be taken from there and it should be given to the affected farmers. A fair and dignified alternative to PM Kisan and crop insurance. Farmers are not beneficiaries. We are treating farmers as beneficiaries, or like we treat them like beggars. But they are producers. They are providers of our food. India survives because its farmers feed us. They feed 1.45 billion people. Any support to them is an investment in the national food security. We are not helping the farmer. We are helping ourselves. We are helping our own nation. It's not an act of generosity. Paying 6,000, now the central government is paying 6,000 rupees per annum in 3 installments to farmers and they call it as Kisan Samman. No, it is not Kisan. We are not giving any respect to him by giving 6,000. It's a paltry amount. So how does it help him? So feels contradictory when a farmer sustains multiple lives every single day. Because food is not just an economic commodity. It is not just a thing to eat. It is not just a fuel to our body. But for any nation, food can be used as a weapon. The enemy country, when you are running shortage of food in your country, the enemy country can use it as a weapon by not supplying the surplus food if they have. And food is strength to a country. Food is peace. Food is freedom. And food is sovereignty. Only when you have enough food supply to feed your fellow people, fellow citizens, then only the country is strong. Then only you have freedom. Then only you have sovereignty. So why current schemes pay farmers? Rupees 6,000 per year under PM Kisan is symbolic. It doesn't rescue farmers after crop loss. It asks farmers to pay premiums, but delays and rejections erode the trust. Funds are spread across all farmers, even those unaffected. You are giving that money irrespective of the loss to the farmer. So it results in no real security, no real justice. So government funded agriculture disaster management fund is a smarter, fairer model because it is government funded, no premium from farmers, compensation only to affected farmers, input aid in the form of seeds, nutrients, soil and crop health products can be given immediately to raise the next crop to him. And digital and satellite based loss assessment can be done because quickly it can be assessed and he can be compensated. And immediate relief and recovery support can be given. Compensation for crop loss is not a charity again. Don't think that we are doing a charity. The taxpayers should not feel that why our money is going to farmers. Imagine the situation without a farmer in this country. So it is the nation's responsibility. So crop losses are systemic risks. Government must shoulder them. Weather vagaries, droughts, floods, pandemics of pests or viruses, these are beyond the control of farmers. Yes or no? So just as the government provides insurance for banks, corporates, industrial infrastructure, we should also give it to, it must provide full crop risk coverage to farmers. Farmers should not be paying premiums for something they didn't cost. So universal crop insurance where government pays 100% of premium, claims are fast, transparent, technology enabled, compensation equals real production cost plus reasonable profit. This alone can prevent farmer suicides, restore confidence, and ensure continuity of food production. So policies should shift from subsidy mindset to productivity mindset. Instead of 6,000 rupees cash transfer, imagine about 10 to 15,000 per year per farmer on crop insurance, guaranteed cost plus price, free scientific crop management training, and reduce residue-free and export-oriented cultivation support. This transforms respect into real opportunity. So India today faces two parallel realities. Thousands of crores of rupees lie unclaimed and idle in banking vaults. There are many accounts which are dead in the banks. No claim, nobody to claim. They are dead. They are not aware of. They have forgotten their accounts. So thousands of crores are lying in the banks, and it is idling. Similarly in LIC, similarly in other investments. So that money idling, and farmer doesn't have any money to invest. This is the parallel realities, and millions of farmers face devastating losses during every natural disaster. It is both economically prudent and morally compelling to connect these two realities. So by creating a national farmer disaster protection fund from unclaimed deposits, India can pioneer a globally unique model of farmer security, one that converts forgotten wealth into a shield for those who feed the nation. As it is often said, food security is national security. Protecting farmer is not a charity. Again, I repeat, it is an investment in the survival and stability of the nation. So now, coming to the innovation, role of grassroots innovation and private participation. India has a wealth of grassroots innovators. Many of you must be good innovators. And I have seen many youngsters started many startups and doing excellent job in India. And policies must encourage non-exclusive technology dissemination, support field-proven innovations, reduce regulatory barriers for genuine innovators, and innovation must be nurtured where it emerges at the farmer's field. I am happy to mention to you that I have developed a first time in the world, I have developed a cure for virus diseases. As you all know, there is no cure for any viral disease, human virus or animal virus or plant virus. We have developed in Mysore, very much in India, we have developed. You can clearly see the difference between treated and untreated. So on your right is the untreated row, and this is treated. All were uniformly infected. After the treatment, the plants have recovered beyond recognition that once it had virus. And it is full of yield, and hardly there is zero. So this has become just not national news, it has become international news. You can see here, Indian scientist claims breakthrough research. India, breakthrough research to combat the dreaded papaya ring spot virus. So thank you very much. And I have got the patent. In a record time, I got the patent for this because first of its kind. And I applied for US patent now. So policy recommendations to establish now I have come to the end of this, not the end of talk. Establish a national farmer knowledge mission, create an agricultural disaster management fund, set up a soil and plant health authority of India, develop taluka level crop diagnostic laboratories, reform power and water delivery systems, recognize and scale successful grassroots extension models. So now, having talked so much theoretically, it looks nice, isn't it? It looks nice. So that's what is happening. People in the air-conditioned rooms in the ivory towers frame the policies, recommendations. I am not such a guy. I am a guy who walks with the farmers, who talks with the farmers, who toils with the farmers, and who shares their anxieties and successes. So I am a practical guy. I am a practitioner. Okay, let me show you what I am doing. I will show you one just example. I have done many experiments and I have been successful in all the experiments. I'm happy to say that. And I have selected one village. In the first picture, our service area. That village. See, all the fields are empty here. And there is one famous book called Empty Fields, Hungry People. That was the situation just a few years back, not even 10 years. 7, 8 years back, this was a very poor village. And they were all empty. So they were farming using the age-old methods. They didn't have even cattle to plow their land. Imagine. Very, very resource-poor farmers. Now, they had absolutely no knowledge of modern technologies. And of course, they were growing only one crop called chrysanthemum flower, you know.
Yeah.
Last night, our bus carried a lot of chrysanthemum from Mysore to Ernakulam. So you don't grow flowers. You don't grow vegetables. Most of these vegetables and flowers come from Mysore and Bangalore. So, see, because of monocropping, the soil-borne diseases, I said root rots and root weeds. Root is an invisible organ of a plant, but the most important organ, like our farmers. Farmers are like roots of the national economy. The rural economy is the root of the national economy. So here see how ununiform the crop is. From any ununiform crop, you cannot expect good yield and good quality. So this was the situation. And see, very low yield. Hardly you can count. Can you count the number of flowers, average number of flowers? Can you please tell me? 100 flowers. 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 100 Average. 10 flowers, 15 flowers, 20 flowers. How much? How many? See, water is there. The backwater of Kaveri River is there. Here also drip irrigation is there. Even then, the yield is very minimum. From that kind of situation, we have brought this kind of situation. So it means the technology is there. Your soil has got the potential. The variety has got the potential. Your fertilizers have got the potential. Your water has got the potential. See, there is so much of smile on the face. I have been able to bring smiles on the face of these resource poor farmers. They are all very rich today. See how the village looked at 2011. All old houses, all the fields are empty, and the houses are old houses. Now in 2025 or 26, how the village has grown, how the greenery has changed around the village, how many modern buildings have come. I have cut down the slides here anyway. So this has become a national news. It has come in various languages including Telugu, Marathi, English and so on. So by filling three gaps, one is that information gap, they didn't have the knowledge, and input gap, that is they didn't have the inputs like pesticides or fertilizers or biostimulants, and also they didn't have money to buy that. We filled all the three gaps and we achieved 5 E's, that is economic benefit, employment benefit, environmental benefit and emotional benefit. And empowerment. Oh, I think this is repeating. Okay. Oh, sorry for that. So they were facing a lot of disease problems like this, insect problems, disease problems like this. And we studied all the problems, bringing them specimen to our laboratory and virus disease. And they were spraying indiscriminately all kinds of pesticides. And this used to be the weekly harvest for them. And then we went there and we introduced all non-chemical methods, integrated methods. We supplied our virus product to control virus diseases and our product to control root rot diseases. We trained the farmers and we brought these changes. Yeah. So employment for women especially. Women empowerment has happened in a very big way in these villages. And look at the happiness on their face. While working also, they are all very happy. And it is a very nice thing to work with the flowers. And you can imagine, and we caused the reverse migration of youths. So that village has changed now. So how the houses, what is the proof of that economic change? Social change. See how the houses are being changed. The old houses are being replaced by new buildings. And very modern houses, very expensive houses they are building. See? And the best education to their children. So as I said, media coverage, 5 E's, empowerment. And we also brought another concept called LCD, local crop doctor, because farmers could not come every day to our laboratory for knowledge, nor we could go to farm village every day. So we identified an unemployed youth from that village who knew English, who was a BA graduate. We trained him in keeping him in our laboratory. We paid him salary, trained him as a doctor, plant doctor. So we sent him back to his village to help the farmers on a daily basis. So he learned all the technologies and transferred that to the farmers. And we also helped him to borrow money from bank and put up a input shop, fertilizers and pesticide shop. So now he is not just a successful local crop doctor, but he is also a very successful entrepreneur. See, he is visiting Singapore, Malaysia, and Philippines. Every year, one new country he visits. He has become such a successful entrepreneur. So this is possible. So every village or a bunch of village needs LCDs, local crop doctor. This is another concept of ours, which is a very successful concept. And recently we have taken one more village called Jinalli, where farmers grow vegetables and supply vegetables to Mysore. As you know, most of our vegetables are loaded with pesticides. So our project here is to reduce the pesticide load and make more profitable to the farmer. So we use these kind of insect traps, which are non-chemical, and reduce the pest load by 20 to 30%. And see, there are different kinds of sticky traps, pheromone traps. And also, I am an expert in all crops. I am not just a specialist in one particular crop. You give me any crop, even for pepper, we can give the solution. So rice, so when we are ready to help the farmers when they are in distress, we wait every day, we watch the newspapers. If there are any report of farmers having any problem, we rush to this rice crop had problem. So we went there. So you see this on your left, this crop had the problem. This was healthy because it was a local variety. See, we treated this free of cost to the farmer, and see after 15 days what happened. See, it became normal. And look at it means it is heavy, loaded with grains. And even which looked earlier healthy is not having any yield. So we solve the problems like this. We go to the rescue of the farmers, and we have averted many suicides in the villages. Not only in Karnataka. I am invited by Kerala people also. You can see in Malayalam. So I have appeared in Malayalam papers also. So I am invited by my neighboring states also to educate farmers. So this is in Andhra Pradesh. Again, the ginger is used to be a very big crop of this thing, and now Kerala government doesn't allow farmers to grow ginger because they all have migrated to Karnataka. So we are expert in ginger cultivation also. So we have saved a ginger crop which was sprayed by herbicide to kill the crop by some miscreants. We read the news, we rushed to the farmer, we saved the crop. So while looking at the working like this, many people used to visit. I'm happy to say that Professor Nicholas is visiting Mysore tomorrow to our laboratory. So sometime back, even Professor Muhammad Yunus, unfortunately, who is a controversial person today, a few years back, he visited my laboratory. He is an economist, not a scientist, not to look at my science, but he came to see my microfinance model because it's unique. We don't give money to the farmers, but we give critical inputs, most important critical inputs on credit without any interest, without any collateral. That's a unique microfinance system developed by me, and it works excellent. So he came to our lab. So what I want to say is I met Dr. Norman Borlaug in one of the international conferences while I was working for a multinational company as a research scientist. But after listening to his talk, I was inspired to quit my job, come back to my roots, my village, and help farmers. So, inspired by one Nobel laureate, I did a work so that another Nobel laureate could visit and see my work. So that is my success story. And I go to even all villages. I don't invite people only to my lab. I normally go to villages and train the farmers. Indian farmers, again, I want to emphasize that they don't seek charity, they seek dignity, knowledge, and fair opportunity. Agricultural policy must evolve from short-term welfare to long-term empowerment. So a pragmatic agricultural policy must therefore be science-driven, farmer-validated, nation-centric, and outcome-oriented. Only then can Indian agriculture achieve true sustainability and prosperity. So agricultural policy in India should change from populism to pragmatism. So I want to read this poem for you. The title is Unseen Farmer. So when you sit to eat your meal, pause and ask yourself to feel that every grain upon your plate was once a farmer's fragile fate. Remember him in all you do, for India's strength begins with you. And if our hearts grow just and fair, the farmer will rise from despair. Thank you very much.
Forum is open for questions.
Sir, do you have a question? Yes.
Yes, Nicolas Saller. Listening to you, I'm of the view that the fate of European farmers are somewhat similar, although the circumstances are
Different.
Economic circumstances are extremely different. In many countries, European countries, farmers are heavily indebted on the account that they've been enticed to invest in expensive tractors. Fertilizers price on the increase for the fact that oil energy prices have increased. So that's leading to some disastrous situation. So the suicide rate, particularly in France, is on the rise, and that's linked to indebtedness. But there might also be a cultural factor, a social factor that you mentioned, is the devalorization of the profession. So in rural areas from Portugal to Romania, younger farmers have difficulties to find wives. Girls are more successful in school, high schools, and they are succeeding in a higher education, and therefore leaving the countryside. And that's particularly the case in Northern Europe, in Sweden, in Norway, where the man staying and keeping the agricultural traditions will marry Thai women or Ukrainian women. So I think it's important also to stress the cultural factors because profession might fade away if it's not supported by the rest of the society. The different ecological stresses that you highlighted are, of course, different in Europe, but we have been facing a situation of soil erosion. But you didn't mention soil erosion, but you mentioned soil deterioration. Soil erosion goes
soil degradation.
Degradation. The poisoning of the soil by the use of neonicotinoids, these systemic pesticides. So according to the latest studies I looked at, the neonicotinoids which are levered on grain are staying in the soil, so they don't only 17% of the pesticides get into the growing plants, and the rest is waste.
Yes.
And that leads to a long-term pollution. Water deterioration is a main issue, and with rising temperatures, we see in particular in Spain, Italy, and France a struggle competition to access water. So intensive farming production is water consuming. And so the approach endorsed by the public authorities is to move into heavy infrastructure, which comforts the most intensive and richer farmers to the detriment of poor farmers. So we are facing a great extent of competition between big farmers getting more state subsidies and small farmers who are deprived of the technology, who are deprived of the knowledge. And I remember you began your speech on stressing the knowledge. And in a digital age, one is facing the issue of computer data literacy, which will be more common among farmers farming in remote areas such as mountain areas. And so I'm a bit afraid by the gap. The gap is widening between the farmers able to invest and to be economically successful and the other farmers that are fading away. And that's giving rise to social issues, because at the beginning of 1962, the Common Agricultural Policies aimed at affording, at enhancing an economic situation where the revenues of the farmers won't be belittled. And so actually, we see really a distortion as a matter of income. And so that's leading to social inequality, but also the disappearance of smaller farming practices is compounding the ecological stress. The more smaller farming plots you have, the greater the biodiversity is. And with great farming exploitation, the rationalization of the farming practice is leading to the disappearance of small wetlands, of edges, of walls, and leading to a more landscapes without any varieties. So although the situations are different, I feel that from a social point of view, from an economic point of view, from the ecological point of view, the situation is worrying on both continents. And then the object of the symposium is to discuss how to integrate sustainability in a forthcoming trade deal that will be discussed in 2 days in New Delhi between the Indian Prime Minister and the President of the European Council and President of the European Commission. So, and agriculture has been somewhat excluded from the deal, from what I know, at the request of the Indian diplomacy, for the sake of protecting Indian farmers from cheap European dairy products. And it's a bit amazing, because similarly with this EU-Mercosur deal, where our farmers federations wants to exclude imports of beef because the Argentinians and the Brazilians produce beef at a much cheaper price than our beef producers in Europe. But we'll stop here.
Okay, thank you. It was complementary observation.
Yes.
Yeah, it is added as a form of observation.
Yeah.
So I will request Ms. Gauri to.
On behalf of the organizers, I extend our heartfelt thanks to our esteemed speaker for a deeply insightful lecture on agricultural policy in India from populism to pragmatism. Your address powerfully reminded us that hunger remains one of the gravest challenges confronting humanity, and food security is not merely an economic concern, but a moral and constitutional imperative. Your analysis of the condition of Indian farmers, the paradoxes within our agricultural policy framework, and the limitation of short term populist interventions, particularly indiscriminate fertilizer subsidies, etc., offered much needed clarity. And by drawing attention to the often ignored dimension of the scientific cultivation practices and financial literacy, you highlighted that sustainability in agriculture demands knowledge and context specific solution rather than blanket support mechanisms. Coming from a rural area in Kerala, I personally resonated with your observations, sir. While local governments and cooperating societies provide extensive assistance, low productivity and weak profit margins often leave farmers unable to repay the advanced loans, gradually reducing the agriculture to a secondary occupation. You emphasize that the issue lies not in subsidies per se, but in how and where they are targeted based on soil health, crop sustainability, and the scientific assessment was both timely and compelling. Like the microcredit system that you have developed that aims the transition from a subsidy based system to one that focuses on productivity. The policy measures that you recommended are both relevant and deeply practical as they aim to fill the critical gaps in information and inputs while simultaneously adding real long term value to farmers' livelihood rather than offering only a short term relief. And your initiatives and projects as a are a source of inspiration, demonstrating how thoughtful policy decision and grounded implementation can translate vision into meaningful impact on lives of farmers. We are grateful for your thoughtful intervention, which urges a shift towards evidence based, sustainable, and farmer centric agriculture policy making. Thank you for enriching our understanding and inspiring more pragmatic approaches to secure India's agricultural future. Thank you, sir.
Yeah, thank you so much. Thank you for the opportunity. I thank Professor Mini Madam and Professor Nicholas sir for adding so much that I am surprised to know that the situation is almost same even in Europe and the US. That is, I think it is time to sit together and brainstorm about this and find real life solutions to the farmers and make our own food secure. Thank you very much. Thank you.
Happening. In relation to many sectors, even in the agriculture sector, the changes in the land use can have a dramatic impact on the ability of carbon sinks, carbon sequestration, and the carbon mitigation measures to function. So think for a situation where the forests are getting depleted or degraded in a country, the ability of that particular geographic location in order to absorb the greenhouse gases will also be impacted. So in a way, I think all these measures contributed, or in a way were targeted to achieve the carbon neutrality goal of the European Union. So in this regard, I would like to specifically mention 4 or 5 regulations which the EU has recently brought into effect. Some of these regulations have been discussed for a fairly long period of time because these regulations created a bit of a concern not only within the EU but also among the trading partners of the European Union. And one regulation which I want to touch upon is the Carbon Border Adjustment Mechanism, which is actually called the CBAM, and that acronym is fairly popular these days. The second is the European Union Deforestation Regulation, or the UDR. Again, the objective of the regulation is to deal with or to prevent forest degradation, forest disappearance in many countries because of trade purposes and other related activities. Another regulation which I want to touch upon is the European Union Corporate Supply Chain Due Diligence Directive. It is again a regulation, it is actually not a regulation in that sense, it's a directive. So there is a difference in the case of a regulation. A regulation is actually a community-wide application of a law. In the context of a directive, that measure will have to be implemented by the member state within the EU. So there is a bit of legal difference, although both these things can have apparently the same effect so far as the exporters are concerned. So what I actually did at the moment was to highlight the ambitious goal of the European Union in order to meet the objectives of the United Nations Sustainable Development Goals, which were adopted in 2015, and they have got a fairly short period of time. They have to be achieved by 2030. So Sustainable Development Goals, or the SDGs, are time-bound goals, and they have to be met. Every country that is party to the UNSDG has got their obligation. In addition to that, we have got the 2015 Paris Agreement. And the Paris Agreement is a one of a kind of an agreement, highly ambitious agreement. It brought in certain, I think, aspirational goals in the field of climate change mitigation and adaptation. So the European Union in the Green Deal is trying to have its own domestic agenda, but at the same time, they are doing these kind of actions purportedly in order to meet the international obligations enshrined in international instruments like the Paris Agreement, the United Nations Climate Change Accords, etc. And some of you are familiar with the UNFCCC, the Framework Convention on Climate Change, that has been there for the last 30 years plus. So these are important goals, and when they're doing it, the impact on trade, the impact on economic relationship is very much evident. And some countries have taken up the issues at the bilateral level, in bilateral engagements, and also in the international fora, including the World Trade Organization. So some of you may have heard about the advisory opinion of the International Court of Justice, etc. Again, that is actually related to the Paris Agreement. And in recent times, we also have disputes. The Russian Federation filed a case on the European Carbon Border Adjustment Mechanism. And these measures are routinely taken up in committee levels in fora, including the TBT committee in the WTO, the Committee for Trade in Goods, and many other fora as well. So what I'm trying to say here is that the objectives are benign. They seem to be benign, they seem to be good, but at the same time, many countries may get impacted, maybe severely impacted by these measures. So let me come to the first question, actually, that's dealing with the CBAM regulations. So what is actually the CBAM, the Carbon Border Adjustment Measures? So we know that, the emission, the carbon emissions, or the greenhouse gas emissions, which actually includes other elements like nitrous oxide, sulfur dioxide, etc., bigger than pure carbon dioxide, carbon monoxide, many other things. These kind of gases will have an immediate direct impact on climate change or on increase in the global temperature. So the Paris Agreement has a very ambitious goal. What is the goal? In order to hold the temperature rise when compared to the pre-industrial levels, no more than 2 degrees centigrade. So that is actually a broader goal. But at the same time, there is also an aspirational goal to make sure that the increase in temperature when compared to the pre-industrial levels is no more than 1.5 degrees centigrades. And according to some studies, I actually read a report in Economist magazine. It said that that particular goal cannot be met because we breached the goal already in 2024. what it means is that in 2024, the global temperature averages were higher than the pre-industrial level temperature by more than 1.5 degrees centigrade. But it doesn't, it doesn't actually say that it is on a consistent basis. So if you can say that, okay, for a certain consistent years, the temperature is more than 1.5 degrees centigrade, then the aspirational element of the Paris Agreement is gone. But all of us are acutely aware. I mean, at least most of the people are acutely aware of the implications of the temperature rise. You know, the change in weather patterns, uncommon rains, flash floods, sometimes a drought in certain countries, unseasonal rains. They can all be, in a way, scientifically correlated to the rise in temperature. So when the European Union came up with the CBAM regulation, I mentioned that it came out of the Green Deal. The Green Deal was actually passed in 2019. They had two important goals. One is actually meeting the Paris climate change goals. The other is introducing an element called the competitive neutrality. I also mentioned about what happened in EU in 2005. They introduced the emission trading system. That means it is a voluntary mechanism. There is actually an obligation, but at the same time, the Commission gave free allowances for the affected countries, the affected companies for that matter. So what happens is that when EU alone is coming up with carbon neutrality related goals and targets, the European companies will have to necessarily fall in line. They have to meet these targets. And the feeling within the EU is that many of the countries actually use fossil fuel. They use bad forms of energy. They don't take climate mitigation measures. They don't do anything actually. They engage in the bad way of production. And what happens is that, first of all, it defeats the goals of the Paris Agreement because one country alone or a group of countries alone doing measures in order to reduce the temperature rise is actually going to be futile exercise. And secondly, there is also a problem of carbon leakage. Because what we are dealing with here is a problem of externality. The point is that in economics literature, if someone is actually causing an unintended harm, then there has to be a price for that externality cost. So a carbon tax can actually be a kind of a Pigouvian tax. In fact, I wrote an article for the Environment Journal published by NUALS way back in 2019, long before this CBAM was thought about or came into practice. So I actually highlighted the importance of the polluter pays principle and how these mechanisms can actually be used in certain manner in order to discourage the industry in continuing to use the same kind of production practices and methods. So I highlighted in an article which was actually published in 2018 by the NUALS Journal. But the problem here is that, there are so many problems with respect to the CBAM I will highlight in the time which I have. So one major problem is, according to the Europeans, it actually leads to carbon leakage. The European industry will go to another country where the environment regulations and carbon norms are actually much lax. This is what you call as the race to the bottom. And this particular argument has been raised in economic literature for a fairly long period of time. So therefore, I think what you're trying to do is to bring in some kind of a level playing field. So the operators and the producers in some of the energy intensive sectors in the European Union and in other countries will have to follow the same kind of standards, the same kind of approaches, the same kind of production methods, or the same kind of, you can say climate neutrality goals in their own respective industries. So the European Union actually thought about this mechanism. They came up with the CBAM in 2023 May. They also provided for a transition period. So that means the industries will get some certain kind of a time in order to adjust. But the European Union also thought that that is actually a good period for collecting the data. How some of the energy intensive sectors like iron and steel, aluminum, fertilizer, electricity, these kind of sectors will actually comply with this thing. One sector which I missed out is cement. So how these sectors are producing, how much amount of carbon emission is happening in these countries, etc. So this is basically part of the data collection process as well. But in many ways, it also put the industries in other countries on alert. So they understood that if they have to, keep selling the product in the European Union, they also have to follow this kind of practices. And practice in the sense that, earlier people used to emit, they used to have production facilities, nobody cared about the carbon emission. Ultimately, what happened? Of course, your environment was bad. I think the pollution was high, and not many countries actually regulated it very strictly. So now you have to have mechanisms in order to detect, trace the amount of production, the amount of carbon or other greenhouse gases in the production of your product concerned. So that means you need to have the data collection methods, you need to have traceability mechanisms, and you need to have reporting mechanisms, right? So all these things were required pursuant to the European regulation. One advantage I think the European industry enjoyed is that most of the sectors covered by the CBAM were also under the emission trading system for a fairly long period within the European Union. So in a way, they had that kind of a long. They were, they got that time in order to get adjusted or acclimatized for that matter. But the foreign exporters didn't have that kind of an opportunity. Now, I think the CBAM regulation was in, as I mentioned earlier, was in a provisional period. Now it has actually become a definitive regulation. That means the definitive period of the implementation of the regulation has already kicked in. One important point is who is actually, bearing the responsibility. The responsibility is always on the domestic party. So there are persons within the EU. So the domestic parties will have the responsibility. So there has to be a CBAM declarant, and the declarant will have to report the embedded emissions. The emissions can actually be direct, or sometimes it can be indirect emissions. But both things will have to be reported. And sometimes, there is actually an annual reporting also, and they have to surrender the CBAM certificates. So the party that is going to submit all this information will be the importer on record. The importer will have to collect all this information about the embedded emission in some of the identified or covered products that particular party might have sold in the European Union. So if I'm an importer, I may also have got domestic sales. I'm a trader, so I buy products from outside. I buy products internally or domestically. I sell it to parties, but I have got an obligation for that matter. But in relation to the domestic sector, as I mentioned earlier, it is now covered by the ETS. So the CBAM technically applies only to the foreign parties, the foreign exporters, not to the domestic. Although the domestic producers are also subject to the same kind of obligations or liability by virtue of the emission trading system. And over a period of time, the emission trading system will be phased out. Then I think the domestic and the foreign will come on par. So that is the idea. So now there are so many challenges actually. According to the European Union, it is an origin neutral measure. origin neutral in the sense that we are not actually putting any kind of, egregious standard, high standards, only on the foreign traders or exporters. We have the same kind of a system which is run through the ETS within our own domestic jurisdiction. So we are by no means discriminating between the domestic and the foreign. And it is an internal regulation for that matter. The other side of the argument is that, according to many of the exporting countries, when you trade, the maximum kind of, levy that you can put on the border is actually there in your schedule of concessions. Since you are a member of the WTO, the European Union cannot actually put any tax over and above what they have committed to in their schedule of concessions. So every country has got a schedule of concession under Article 2 of the GATT. And that includes basically the basic customs duties. In trade terms, you actually call it ordinary customs duties, OCDs. Then there is another category called other duties and charges as well. So these are the only two permissible categories of import levies which an importing member of the WTO can legitimately put on a product coming into their country. And the European Union, by inventing something new, called the carbon border adjustment, is basically putting a tax on the imports. And there's another important issue as well here. What is that issue? You know that the carbon border adjustment is a tax on the embedded emission. So if I'm producing steel or aluminum ingots in my production facility, in my smelting facility, the carbon is not getting part of the product. In the production process, the industry will basically spew carbon in their domestic territory, within the plant and other facilities. How is the carbon? Is the carbon actually coming to the European Union? No. The carbon has been emitted back in the country. It is there. Why should or how can an importing country put a tax on a product which is not there, which is not actually crossing the border? So this is again a very important issue. The European Union says that this is a tax on an externality. Whether it is legal or illegal is not absolutely clear. And some of you, students of international trade law, might have read about a case called the GATT panel on border adjustment. It is a 1970 GATT working party on border adjustment. So there is one category called the occult taxes. See, the occult taxes, like energy taxes, they are not embedded within the product. They are consumed. So in the consumption products, these things might have been actually involved. And you're putting a tax on the production process, on a product which is not physically coming to your country. Do you have that jurisdiction? Which country has got the tax sovereignty or the taxing power in order to put a tax on it? Ideally, only the exporting country. The European Union, in a way, is aware of this fact. So in Article 9 of the European Carbon Border Adjustment Regulation, there is a provision which says that any kind of a carbon price effectively paid in the exporting country as part of an emission reduction scheme needs to be accommodated and provided for. So what it says is that in the case of a country like India, if India has got a CCTS or a PAT or some other scheme, and where the carbon, the carbon that is emitted is actually put a cost or a price, the price paid in the country can be adjusted or offset when the product is imported into the European Union. But again, there is a major challenge here. The challenge is that we do not have a universal or a global carbon price. In the European Union, the carbon price is actually calculated based upon the weekly price, the weekly auction price, which can change. But if you look at the data over a period of time, it hovers in the range of 80 to 100 or 80 to 90 euros per metric ton. And if you look at many developing countries, including China, India, in certain countries like India, we do not have a proper carbon emission reduction scheme so far. We are building our CCTS. Even in China, the price is only around 10 euros per metric ton. So what it says is that, what it implies is that if the emission price, if the carbon price in the European Union is 90 euros per metric ton, which is around 8,000 rupees per metric ton, you can perhaps get a rebate or an offset for 1,000 rupees. Still, you have to pay the 7,000, or you can say the 7,000 euros. The 70 euros. I'm sorry, the 70 euros in that country. That is a substantial amount of money. Will the money be plowed back to the exporting country? Those things are still to be worked out as part of the implementing regulation of the European Union. So these are some of the the genuine issues which all exporters, including Indian exporters, are now facing within the European Union market. So now, I'm going to talk a bit about the international trade related issues. So we know that, sovereignty is a very important term in international law. Most of us have heard about the SS Lotus case and other things. Does the European Union have the power to tax the carbon emitted in a foreign country? This is actually a contested point. According to many scholars, in fact, a country may have the power even to subject certain extraterritorial measures as a subject matter of their internal regulation. Some of you might have heard about cases like the reformulated gasoline case, the shrimp turtle case, etc. So in those cases, an importing country is conditioning the access of a foreign product into their domestic jurisdiction based on the conformity with the domestic law. So in the case of shrimp turtle, if the shrimp has to come from a warm water country like India, then the shrimp should be caught in a manner without hurting the sea turtles. So a kind of a PPM, process and production. Can you hear me now? Hello? Can you hear me?
Yes, sir. Sorry.
Okay. There was an issue. I'm sorry.
Who is not responding?
Can you hear, sir? Am I audible?
I think there was some technical issue in between. Sorry about it.
Yes.
Right. So I was talking about the process method, and I was talking about the shrimp turtle case, where the US subjected Indian shrimp exports into their market based on the conformity with the turtle excluded device law, which was actually part of the public law. So what happened here is that the WTO appellate body very clearly mentioned that a country can sometimes take measures which may have an extraterritorial impact, but when you come up with these kind of regulations, or when you implement these kind of regulations, you also have got an obligation to take into account the conditions, maybe the disparate conditions prevailing in the exporting countries as well. Because the objective is to make sure that these kind of laws and regulations do not actually pose disguised barriers on international trade. So here again, in the case of CBAM, it is a domestic regulation, a European regulation which applies to European industry. Now this regulation through the CBAM mechanism has been extended to anyone who exports the covered products into the European Union. And the industries in the exporting country will have to collect the data. They will have to report the data. The data has to be verified. And the CBAM declarant in the importing country will have to surrender the certificate based upon the amount of embedded carbon emission as well. So this is again, I think I mentioned there are multiple debates within the debate. One is actually the tax sovereignty issue. The second is the extraterritorial reach of the European regulation on third countries. And if there is an extraterritorial reach, then what should the regulating country do in order to minimize the impact? The last issue is again an equity issue. So we know that every country is not at the same level of development. And the argument here is that if you really look at the energy, the carbon footprint of a country, most of the developed countries have consumed significant amount of energy, or they have actually led to this flare up in greenhouse gas emissions, not in 1 year or in a decade, but over centuries. The industrialist countries nearly gone 200 years in order to reach where they are. And many developing countries are in an early stage of development. Sometimes some countries have progressed to middle levels, and certain countries like China have now become fully developed to an extent. So is it possible to put the same kind of a standard on all countries irrespective of their development status and also their own contribution to this particular emission issue? That is a long-standing debate, and people believe that it is also a violation of Article 6 of the Paris Agreement, which speaks about the principle of common but differentiated responsibilities and respective capabilities. And we know that the special and differential treatment is a very important principle in the WTO. And the CBDR-RC principle is now actually part of the Paris Agreement, and to an extent getting the, it is still not a customary principle of international, but it's almost becoming a customary principle of international. So in this kind of a situation, whether the European regulation is an apt regulation, whether it is discriminatory, whether it is iniquitous, these arguments are up there in the air. So since I do not have too much of time, I will also touch upon other regulations for that matter. The other regulation is the deforestation regulation. So in a way, the deforestation regulation is fairly significant. It is similar to the CBAM in terms of the nature, the design, the architecture, and the operation of the measure. The objective of the deforestation regulation is to identify the products, and the European Union has already identified those products that contribute to forest deforestation and forest degradation. And if some of these products actually pose the risk of deforestation or forest degradation, then they cannot be placed within the European Union market. So the covered products include, one is palm oil, second is cattle, third is wood, fourth is coffee, fifth is cocoa, then you have got seventh, rubber, and the last one is soy. So these are the identified products, and the major concern here is that these are agriculture products, and in many countries, according to EU, some of these agriculture products are being planted by deforesting. So sometimes, if you look at It may not be happening that much in India, but if you go to some of the East Asian countries like Indonesia, Malaysia, these kind of countries, or even Thailand, there is a significant amount of land use change happening in these countries. So they may deforest, virgin forest, and then they may plant palm oil trees. This may also happen with respect to cattle in certain countries like Argentina. What they're doing is basically destroying the forest and then basically, ramping up agriculture production. Sometimes happens in the wood sector. For making furniture items, you are cutting trees. The same thing happens with coffee also, but in many countries, I think this might have happened a long time ago. So European Union is not trying to identify those kind of changes which happened decades and centuries ago. Their cutoff period is 2020. So if any new forest is being degraded or cut or destroyed in order to promote agriculture production in some of these covered products, then I think it will be subject to very close monitoring, and depending upon the amount of risk, they can also put certain categories of penalties. So in certain cases, it depends upon the amount of turnover that is stated to be from the European Union sales. So 4 times the turnover of their activity in the European Union can be subject matter of a fine. Or in certain cases, it is also possible to put a ban on the importation of the product concerned. So again, this is a very interesting, and many countries actually argue that this is not purely with respect to deforestation. It also requires conformity with certain kind of a labor regulation or human rights law for that matter. So think about a situation, if a country, under the UDR, if a country doesn't respect the human rights law, or in certain cases disrespects the labor law, it can also be subject matter of reporting. So it is not purely limited to deforestation. There are other externalities and other areas covered under the deforestation regulation as well. This regulation has now got 4 categories, 3 categories. Initially, I thought it had 4 categories, but I think only 3 categories. One is a low risk, second is a standard risk, and the third is a high risk. So India is now actually in a low risk category. Most of the European countries are in a low risk category. Some of the African countries are in a high risk category, like Nigeria for that matter. So it is based upon certain evidence, but it is also possible to argue that if you are in a high risk category, then there is a risk. There is a physical and monitoring of all the products being sent to the European Union market. But there will be physical monitoring of 9%. So there will be physical inspection of 9%. If you are in the high category, if you are in the low risk category, then there is inspection only with respect to 1% of the products concerned. Obviously, this particular regulation was hotly debated. It was not contested or objected to by the developing countries or the global south, even within the European countries, especially Switzerland, Belgium. Many countries had concerns. The fact is that cocoa is actually a covered product. So if cocoa in the cocoa production, if certain kind of deforestation might have happened, or there's a threat of deforestation, or if there is certain kind of human rights violation in the value chain, then this particular product may be subject to the deforestation regulation, and even some of the richer countries might come within its coverage. So Switzerland had a major issue with respect to this regulation. It is not part of the European Union, but it had a major issue with respect to this regulation. The challenge here is that, again, I think I should point out one important point. Most of the European countries actually fall within the low risk because they do not have forest. the countries that have forest, like Indonesia, Malaysia, the Mercosur region, in particular Brazil, these countries have got huge amount of tropical forests, and of course, I think deforestation happened in the past. So you can say that it is a nice benign regulation for that matter, but they also felt that many of the agriculture produce, even industrial items, they send to the European Union will be subject to this deforestation regulation. So when the European Union Mercosur Free Trade Agreement was negotiated, this became a big issue. The last year it was concluded. This agreement was supposed to be signed around this time, but now the European Parliament and Council have referred the matter to the European Court of Justice on some of the competence-related issues. So that means the agreement will not come into effect for the next 2 years. It is a significant issue. India, as I mentioned earlier, in India, of course, we have got very tight domestic laws on forest regulations. It is not easy to actually use forest land in order to promote agriculture production or to cut down the trees and use it for furniture and related activities. So we have got even our tea, our coffee plantations, came into being long time ago, and I don't think that we are actually converting the forest area for coffee production in our country anymore. So on that side, India is fairly safe and secure. But I should also tell you that in certain areas like cattle. So think about cattle. I think India is an exporter of some of the cattle-related products. For example, certain footwear items, leather items, etc. So when you export these kind of products as well, the exporter will have to provide complete tracing of the product concerned. So in which particular area the cattle was grazing. So all this kind of information will have to be collected. Sometimes the geolocational information will have to be provided by the exporter or the trader concerned to the European Union, and then it will be subject to verification, monitoring, and inspection by the Commission based upon the risk category. So you understood, I think what I'm trying to say here is that earlier international trade was based upon, a product is a product, it doesn't matter how it is actually produced, it cannot be differentially treated based upon, the principle in the tuna dolphin case. So in the tuna dolphin case, it was said it doesn't matter how tuna is harvested, so long as it is a tuna, it shouldn't be differentiated. They are actually like products. And therefore the treatment under the national treatment will have to be provided for. So now that concept has been changed, at least by virtue of the European regulation. No WTO panel has commented on it. No WTO panel has commented on it. That's a very important point. So let us see what will happen in the CBAM case filed by Russia. And many other countries. So sometimes countries may not file a dispute to make sure that if they lose a case, a dramatic change in jurisprudence could come out of that decision. So sometimes there is a risk in going ahead with a panel request as well. This regulation, as I mentioned earlier, has faced significant amount of domestic backlash. Within Europe, it was supposed to come into effect last year. They extended it. They have extended further. So now this has been postponed to 30th of December 2026 for large operators and traders. And for micro, small and medium enterprises, this has been deferred to 30th of June 2027. So that means this regulation is not going to come into effect immediately. But at the moment, as I mentioned earlier, the CBAM has come into effect this 1st of June 2026. The European Union is a factory of regulation. So if I keep doing all this, summary of all these regulations, it will take a bit of time. But I can't help mentioning a few. So one is the Renewable Energy Directive, the RED Directive. So what happened, as I mentioned earlier, so as part of the Green Deal, the Union wanted to clean up supply chains in many important sectors. The European Union had one important regulation on aviation. So they wanted to tax the aviation sector based upon the emission footprint of the airlines. That was a very controversial area. I think it was postponed, deferred for its implementation. The maritime sector is going to come up very soon. Now, with respect to land use changes, the European Union came up with multiple measures under the category called Renewable Energy Directive, or the RED category. So there was RED 1, RED 2, etc. So the argument is here. They want to say that the transport sector has to use more of biofuel to make sure that the carbon footprint within the sector is reduced over a period of time. And when we think about the biofuel, we know that biofuel can come from various sources. So one is basically ethanol, which is taken from sugar and molasses. The second is palm oil. So palm oil is again an important mix for renewable energy. Then we have got soybean oil, rapeseed oil. There are various categories of oil. So the European Union came up with the RED 2 measure, and what it did was to limit the amount of certain categories of biofuel, or certain categories of biofuel, in the sense that if the biofuel contains, or the biofuel is made of certain kind of feedstock, then there has to be a certain limit on that particular feedstock. To explain it even more, they can have unlimited amount of soybean or rapeseed based biofuel, but if you're actually having a biofuel made from, say, palm oil, then there has to be a 7% cap. So what is actually the rationale behind it? The rationale is basically the indirect land use change. So we know that the biofuel, like the palm oil, is grown mainly in certain countries, and now they have if there is a growing requirement for this kind of biofuel, what will actually happen? Because we know that it is an edible oil, it is a vegetable oil. It is used in the cooking industry, for cooking, and in the food industry, or even for domestic activities. So if there's a greater demand for palm oil for blending in biofuel, it can also lead to indirect land use change, in the sense that the growers and producers may cut down the tropical forest and plant more oil palm for industrial purposes. So that is why they still need this kind of oil for food purposes. And if you're actually going to make the industrial use even more attractive, then there could be an indirect land use change. So the Renewable Energy Directive was a very important initiative. Malaysia and Indonesia filed 2 cases at the WTO. So one case is at DS 590, I think 593 or 92, and DS 600. In these 2 cases, Indonesia and Malaysia filed a dispute against the European Union, and it was actually determined that some provisions of the Renewable Energy Directive were violative of the principles of the GATT 1994 and also of the TBT agreement, especially in relation to standards and other things. But if you really look at the overall decision, the WTO panels were in a way approving the European regulation. So saying that if the objective of the regulation is to limit indirect land use change, to ensure that the forest in these kind of areas are actually preserved, it cannot be bad objective. So these measures were addressed under Article 20B and 20G of the GATT. They said that they could have done a better job by looking at the shopper provisions, but on the whole, the principle and the objective of the measure were basically upheld. So that is one measure, the Renewable Energy Directive. There are a couple of WTO disputes for all students of international law, international economic law, international trade law. I would encourage them to take a look at the matter. Fairly long report, detailed cases, but very, very informative as well. I have another 5 minutes, I think, so I will try to have a couple of more regulations quickly. The another regulation is Corporate Supply Chain Due Diligence Directive. So as I mentioned earlier, the European objective is not purely with respect to climate change. So when they talk about the Green Deal, it is not purely with respect to climate goals or environment goals. It is also related to sustainable practices. So that means how do you ensure sustainable practices? The labor rights are protected at the workplace. Labor rights violations do not happen. If they happen, then proper remedial measures are taken. When it comes to human rights, those kind of human rights principles are protected. People are not supposed to work beyond a certain period of time. The minimum wages are ensured. The human rights and the labor rights can be enforced. These kind of measures are not, derogated. That means no country, in a way dilutes these measures, that dilutes the environment or the labor regulations in order to attract investment or in order to encourage trade. So this is basically the objective of most of these regulations. It is not purely limited to environment or climate change alone. So in the Corporate Supply Chain Due Diligence Directive, the companies will have to identify, prevent, and mitigate, or in certain cases, address human rights and environmental related impacts in the operation of the supply chain. So what it, in a way, if you really look at the impact of the European regulations, most of the traders and companies will have to spend a huge amount of capital and labor and effort in collecting this information and passing it on to the European Union, not in terms of, not directly to the European Union, but to the importers for that matter, for verification, monitoring, and reporting. So that means you have to hire people. You need to have a sustainability officer in your company. So recently, I did a training program at ITC in Calcutta, and I was pretty amazed to see the kind of sustainability due diligence they have implemented within their system. And they said that they are a leader in the country, but many companies are also engaging people specialized in sustainability practices to implement these kind of regulations within their ecosystem. And that becomes very important. I think the European mantra is that trade is not actually trade. We had to trade with the values. So human rights is a value, environment is a value, labor is a value, gender is a value, gender rights are values. I think freedom at workplaces is a value. Your right of speech is a value. So all these kind of values will have to be part of the overarching structure of sustainability. In a way, I think, on the face of it looks good, but for developing countries, it actually takes a significant amount of effort, commitment of resources to make sure that these things are reported properly. I wanted to touch upon a few other regulations as well. One important regulation is the European Union Digital Passport Regulation. So it is again, it is part of the Eco Design for Sustainable Product Regulation. It is also going to come into effect very soon. So what is, during these times, we can actually get all this information through blockchain technologies. Sometimes you can get all this information on a QR code. So the point is that you go to a marketplace, you go to a retail shop, you have got the QR code, you use your mobile phone, get all this information about how this product is made, from where it is actually made, whether there is a labor right violation in that country, whether these people were paid proper wages, etc. All this information is actually in your fingertips. So sustainability is something which I think now has become quite important. I won't say it is just fashionable. It has become very important in trade. And I think the moment the consumer becomes aware of all these practices, then companies will be compelled to do it. So the very objective of the European Union product passport regulation is to get the life cycle analysis. So the life cycle data. So from the cradle to the grave, you have to collect information. Important point, I think, as students of law, I would also, I think, require most of you to think about the recyclability aspect of it. So when you buy certain things from the market, Of course, you look at the quality of the product, but what happens once what happens to the wrapper, how it is actually disposed? Plastic pollution is a major concern, and there is another international treaty which is happening at the UN level on plastic pollution. So there are so many efforts happening in modern times in order to ensure that international trade and sustainability are not different universes; they are a part of the same domain. Now I will come to two very small elements, and then I will end my lecture. The one is essential elements. So some of you might have seen certain free trade agreements. The European Union has negotiated an agreement with Indonesia very recently. They concluded an agreement with Mercosur. They concluded another agreement with New Zealand a couple of years later, and tomorrow they will announce an agreement with India. So most of these agreements have got something very unique called essential elements. That means the preservation, the upholding of human rights, environment practices, your commitment to the Paris Agreement, etc., are vital to the trade agreement. So now, last month or this month, I think President Trump withdrew from the Paris Agreement, and he's going for, his motto, "Drill, baby, drill." That means huge amount of, I think, a use of fossil fuel, natural gases, petroleum products in their energy, in their value chain. This will have an impact on the global climate goals and also on the Paris Agreement. So, according to the European version, unless you are wedded to the values, especially climate goals, Paris Agreement, human rights, etc., the trading relationship is not feasible. And that is why this said trading with values. Sometimes it is, it is not conceptually problematic, but also at the same time, this can pose a kind of a problem for many countries, because this is also based upon perception, how countries are implementing their rights. It's a matter of perception. And in many of the trade agreements, there is another chapter called the trade in sustainability, or the TSD. In the UK agreement, if you take a look at it, you have got an environment chapter and a labor chapter, then a trade in gender chapter, anti-corruption chapter, etc. But in the TSD in the UK is a much more holistic, and it is actually a much more comprehensive chapter. It talks about various values, various areas like labor, environment. So there are obligations on countries not to derogate from this kind of international agreements, to implement the domestic laws strictly, not to dilute them, or sometimes provide domestic advisory groups for resolution of issues, etc. So in a way, I think international trade will be substantially different, especially if you're going to deal with the European Union. And it is nice to take a look at this kind of domestic regulations and some of the international disputes as well, which interpret the application and the compatibility of the domestic law with international agreements. So given the procedure time, I will stop here, and I hope that some of you will have some questions. Thank you.
Just
I can't see any question, but I encourage you to have any question. If no one has any question, I'll be happy to sign off.
Yes, you may.
Hello. Hello.
Off that one, make on this.
So if anyone has any question, you can type. You can actually type in your chat box. I'll be happy to take a look.
Unmute one. So speaker. Which one? Yeah, the voice is recorded. I think it's that. No, one. Nice. Okay, can you write in the chat box?
I haven't seen any questions, so I'm made to assume that no one has any questions or comments. In that case, I think I will be happy to.
Okay. Can you hear us?
Yes, I can hear you. Please.
Okay, right. Now it's fine. Professor Nicholas, you may go with your question. Yeah, give it.
Yes,
Yeah.
can you hear me?
Yeah, turn the phone.
Hello? Hello? Can you hear
Yeah,
me?
I can hear you, but not so audible. But please go ahead.
Yes, we faced a number of technical issues. I just, in short, want to know, if we come back to different developments you made. After at the end of your speech, you stressed that the difficulties the European lawyers are facing with the values. So in short, given that we face technical issues, the values are enshrined in Article 2 of the Treaty of the European Union. The 5 key values that have been enshrined after a fairly long constitutional process. So these values encompass human dignity, democracy, rule of law, freedom, and human rights. Some of these values are reflected in the Charter of Fundamental Rights, such as the human dignity. Other values are fleshed out into key provisions of the treaties. That would be the notion of democracy. The value of democracy is actually underpinning the whole institutional structure. So these values are not considered as a general principle of evil. The Court of Justice and the General Court have been developing nearly 250 principles. The values are actually really at the apex of the EU legal order, but as well as the legal order of the 57 other states. You stress that trade is not a value. As a matter of law, trade, internal trade as well as external trade, regarding the commercial common policy, are considered to be policies that are implemented according to the different rules and procedures laid out by the treaties, by the EU institutions. Each policy is subject to the set of values I just mentioned, on the grounds that the values are at the apex of the EU constitutional legal order. And so, consequently, there are difficulties to reconcile in a free trade agreement with Vietnam the value of freedom or the value of democracy, given that the Popular Republic of Vietnam has a division when many Europeans of democracy and freedom. With respect to India, I imagine that there will be less difficulties because India is a democracy. India is based upon the rule of law, and India affords warrants importance to the respect of fundamental rights. Nonetheless, the trade objectives, the objectives of the trade policy, the external policy, is also embedded into a more global agenda that's going on in Article 21. And this is the fight against poverty, management of sustainability of developing countries, also the equality between the men and the women. And so there is somewhat a gap between many chapters of these free trade agreements that are really technical and the vagueness of these values. So it's somewhat, but I think non-European lawyers have to take into account that the EU founding treaties are part of a constitutional order, although they don't bear the name of a constitution. And so in constitution of a democratic organization, it makes sense to lay down as not only the objectives pursued by the nation or by the union, but also the values upon which the union is founded. And it seems to me, regarding the different debates lately with the CETA treaty, the Mercosur treaty, and perhaps tomorrow about the forthcoming EU-India treaty, because there will be reactions regarding different arrangements. This is really related to perhaps another vision of what's important to afford to values. And these values pertain to a legal order. And so, of course, this is constraining somewhat the EU institutions on what they are doing so far. So that's a remark. I don't have a clear answer, but it seems to me that I was listening 3 days ago before traveling to India to the debate in the European Parliament regarding the forthcoming the negotiations between with India and the EU. And so many MPs were stressing the sustainability issues. So the symposium is really ideal because I don't think that's really the reductions of custom duties that will be at the fore of the debates in Brussels or in Paris. It will be sustainable issues. Agricultural issues that have been a stumbling block with respect to EU Mercosur will be not at the fore in the forthcoming debates. Another issue that will be pretty much related to human rights is the labor protection issues. And so there might be some reluctance from different members of parliament regarding the forthcoming provision of charter on labor protection. Just a last remark, the Mercosur intermediary trade agreement is not concluded, is not into force. It has been signed only by the 27 ambassadors composing the Coreper 2. So far there is no signature that has been granted to the European Commission to sign the treaty. So the signature in Asunción a few days ago is not a signature in accordance with the requirements laid down by the treaty makers. Having already published in the press about that. So there is a procedural issue in this respect. Thank you.
It is observation, sir, or contribution?
So it's an observation, but I will. It will be interesting that you react to my speech because I will come back to several issues that you comment upon. And as a matter of fact, I will have opposing views on several matters. But maybe we can continue the debate after I deliver my speech.
Okay. So, Professor Nicolas de Sadlier, Professor of St. Louis, Brazil, has given observation. If you want to come into his speech, and sir is going to start his lecture. After his lecture, you want to discuss. Sir, can you hear us?
Oh, wait.
Sir, can you hear us?
Yeah, you can hear us.
Sir, can you hear us? Am I audible? Okay, yes. Yes, yeah, he will. I'm number 6, sir. Message. Thank you. Can you make an hold for one person? Please.
Do you want me to?
I got it. What's the problem? Can you? Yeah, good. Just a minute. Wait just a minute. You go with it. You increase this.
So we can.
Sir, can you hear us? No, this is.
Sir, can you hear us?
Are you asking me?
Yes, yes.
Okay, please go ahead.
Okay,
Yeah.
if you have heard, the comment was given by, that was observation by Professor Nicolas de Sadlier, full professor St. Louis, Brazil, Belgium. So he wanted that you comment on his talk, if you would like to. Otherwise, sir is going to present his speech. He has a presentation. After that, he want to discuss with you if you have any comment upon his point of views.
In fact, I couldn't hear him that well, but what I understood is that he highlighted the importance of human rights, other democratic values, as
Yes.
built into the European legal system, and also the treaty of the formation of the European Union. I actually heard him referring to Article 2. So absolutely understood. I think So the only comment is that trade itself is actually a value, but the European Union says that whenever they want to have a trade agreement, then the other values will have to be enforced as well. Sometimes the problem here is that this is also about perception. I'll just give an example to you. So, in relation to the European Union Japan agreement, one particular issue was there was capital punishment in Japan. So sometimes even in the democratic world, even in India, we have got capital punishments. Even in the United States, in some states within the US, there is capital punishment. So in certain areas, I think there could be some divergences, within the meaning of what is actual democratic principles, what is human rights. But on the broad concept, I completely agree with him that trade has to be done with full enforcement of values. But in certain areas, countries will also have to understand the difference in difference in understanding, the difference in civilization, and it shouldn't be allowed to actually become major issues in the future. So I understand that EU has negotiated an agreement with Vietnam, and Vietnam is not, according to our understanding, a full democratic country. So there are challenges, but at the moment, the major challenge is that the open trading system that is actually a result of the Bretton Woods system is now fearing or maybe facing a kind of terminal decline. That is a matter, huge concern for us. So if you really want to keep the trading system going forward, then some compromises will have to be made. Otherwise, the rule of jungle will come in, and that is a bigger danger. So I will stop here. I'll be happy to listen to the lecture of Professor. Thank you so much.
Right. Thank you, sir.
onto this.
Hello. We extend our sincere gratitude to Professor James J. Nadumpara for an insightful and nuanced lecture on sustainable development in the context of international trade governance. The discussion on sustainable development goals, the European Union regulations, and the role of institutions such as the WTO and the European Union offered a valuable global perspective. The speaker's reflection on the aptness of European sustainability regulations, along with the principles of common but differentiated responsibilities, highlighted the equity concerns faced by developing an ecologically vulnerable country. The analysis of sustainable standards, viewed through the lens of human rights principles, added a critical normative dimension to the discourse. We thank Sir for a stimulating and enriching session that has greatly contributed to the academic depth of the symposium and our collective understanding of sustainability and trade. Thank you so much, sir. It is indeed a privilege to welcome back Professor Dr. Nicholas de Sadelier, who needs no introduction to this audience after his insightful engagement with us earlier. Professor de Sadelier is a G. Monnet shareholder at UC Louvain, St. Louis, Brussels, and one of the foremost scholars in European Union environmental law, risk regulation, and sustainability governance. His work has profoundly shaped the legal understanding of how environmental principles transition from policy aspirations to enforceable legal norms. As we continue our discussion on trade, sustainability, and regulatory design, we are honored to once again benefit from his comparative and institutional insights, particularly from the European Union's experience. May I invite Professor Dr. Nicolas de Sadelier to continue guiding us with his address.
Yes,
Wow, do it. Yes. Look, given it's close to 4 o'clock, I will cut a long story short. And I only shall quickly address the manner in which the EU institutions try to making an attempt in addressing the global footprints of the Europeans, and this global footprint is not related to the home consumptions of gas, petroleum products, chemicals, but it's also related to the consumptions of commodities and products imported from other continents. Firstly, the issue of the global footprints, the European Union the European Union has a global footprint, given that the consumers are among the richest on the planet. And although the EU succeeded in achieving fairly good results as a matter of pollution abatement and waste management and even greenhouse gas emissions reductions, part of the environmental harm caused by European consumers are caused through various value chains outside the European Union. And so, if one looks at the climate footprint of Europe, one realizes that although the footprint diminishes with respect to the home emissions from plants, from factories, they are actually increasing in relation to the products imported within the regional market and consumed by the European consumer. So the improvement of the various environmental policies from Portugal to Romania does not translate into an improvement regarding our consumption patterns. And so, given that the EU is one of the largest international players in trade and foreign investment, the EU is actually crossing different planetary boundaries because just take the cases of bananas or pineapples. European consumers import and consume, they contain a very high level of water. When it comes to import of beef, the level of water is much more significant than with respect to an orange or to a pineapple. And the EU, as a matter of fact, also depends heavily not only on tropical fruits, but mostly on critical raw material. And it is heavily reliant on imports of scarce and economically important critical materials such as rare earths, most of which are produced be it Congo, in Brazil, in Chile, or in China. And so this dependency upon minerals or raw materials produced outside of Europe is raising actually an issue of strategic autonomy. So that being said, sustainability is not enshrined among the five values I just quoted. So human dignity, human rights, freedom, democracy, and the rule of law. Sustainability is considered to be an objective, and sustainable development is based is defined according to three pillars structures. On the one hand, economic growth; on the other, the full employment and a highly social market economy; and finally, a high level of environmental protection. In addition, the European Union, and that's perhaps important with our relationship with India, is called to strive for social justice and protection, equality between men and women, which is also an important issue both in Europe and in India, solidarity between generations, as a matter of fact, climate change, and the protection of the rights of the child. So this picture explains this three pillar structure. In addition, the external policy under which is unfolding is aimed at achieving different specific objectives, among which sustainability, sustainable economic, social, and environmental development of developing countries. So, which is of importance in to me it's of importance in negotiating a free trade deal with India, with the primary aim of eradicating poverty. And so President Kumar began his speech in showing perhaps 1950, 1960 pictures of starting children. In addition, the cooperation with third countries should aim at developing measures to preserve and improve the quality of the environment and the sustainable management of global natural resources. So these two issues do to a great extent overlap today. Just look at recent floodings that have been harming Pakistan. The objective number G makes also sense with respect to the subcontinent is to assist population, countries and regions confronting natural or man-made disasters. And according to a number of scientific studies, among which the IPCC analysis, the Indian subcontinent is likely to face great difficulties for the rising of seas, for flash floods, and so forth. And so, by the way, the EU as the most important foreign aid actor, and several of its member states, in addition, a close allied country, Norway, are among the most generous countries on the planet when it comes to development aid. One has to, I think that's the advantage to be an academic. It's just you can depart from a negotiation of Article 45 bis of Chapter 3 of Title 3, and you can have an eaglery on the subject matter. And again, from a constitutional perspective, it makes sense to stress the importance of the foundations of our democratic system, be it the Indian system, be it the EU system, and that would further the debates. Furthermore, there is a specific environmental policy. Of course, the internal market and the common commercial policy have been dwarfing the environmental policy because on the one hand you have a dwarf and on the other hand you have giants. And so, and this is not a matter of law, this is a matter of policy. In every government, some ministers are more powerful than the others. Perhaps you will explain me later tonight who is the most powerful in the Modi government or in the Kerala government. And so this environmental policy is underpinned by the values I just quoted, but it's also pursuing different objectives, among which are high level of environmental protection, protection of human health, and the conservation of natural resources to fight against climate change. And so these issues have been coming time and again in the parliament discussions in Vienna, in Paris, in Brussels, in Namur, about the negotiations of the EU-Mercosur deals, because many national MPs and European MPs in Brussels and Strasbourg were not convinced about the science of different chapters, different clauses of their treaties. And there's been so much resentment, so much demonstrations from Madrid to Berlin against this trade treaty. And there is an obvious reason. The voice of the farmers has not been listened to, and the voice of the civil society has not been listened by the technocrats. And so that's a bit dangerous in democracy. So democracy must be somewhat inclusive, and the sectors that are likely to be affected by a trade treaty must be considered. And so, of course, one could say that this objective and these principles are restricted to the environmental policy. The answer is in the negative, because if I look at Article 11 of the same treaty, the environmental protection requirement must be integrated into the definition and implementation of all the other policies. That means that the common commercial policy must integrate the environmental concerns. So the previous commentators have been stressing time and again Paris Agreement. Concretely, strictly speaking, that means that the objectives to be pursued under the Paris Agreement, and these objectives have been fleshed out in EU law by the climate neutrality objective to be reached by 2050, these objectives must be taken into consideration in the treaty, treaties. So the question, of course, how to reconcile trade, goods and services with the objectives as enhancing the conservation of biodiversity or protecting, saving our planet. And there is obviously a contradiction that was already commented upon this morning by the professor of Bengaluru Agricultural University, is that in trading goods, so the fact, as far as I'm concerned, to eat bananas from Costa Rica, pineapples from Western Africa, wine from California, from Argentina, it just increased my global footprint. But I'm not the only consumer to taste Argentinian wine. So if you have 5 million Europeans eating Argentinian beef and eating and drinking Argentinian wine, it just will compound the climate and environmental footprints of Europe. And so how to strike the balance? And personally, I don't have any answer. And perhaps I will be very happy to have the answers of the students, because the generation who are going to have to solve all these problems. Only my turn. And I'm taking seriously this. So are these provisions of importance? Politicians will discard, technocrats will discard, say, okay, let's focus on personal duties. I'm giving you this, you're giving me this, and it's a trade-off. It's constant trade-off with respect to every chapter of 15. But again, from a constitutional point of view, Indian constitutions prevails. Imagine there is consistent case law from the Supreme Court in New Delhi, prevails over every state Indian legislation, prevails over every federal legislation. And so similarly, primary law provisions are applicable both internally and externally. And so I will comment upon the external action as well as upon the internal action. So, somewhat 15 years ago, the European Commission realized that to boost common commercial policy with trade partners, not sharing exactly the same values, was likely to be heavily criticized by the European civil societies. And this civil society, like in India, is thriving in different countries. I'm coming from a country where the average Fleming person can be member of 20, 25 cultural, environmental, economic associations. So in my country, associations, NGOs do play a big role in the social life. And so many associations in my country have been somewhat against, not the idea of cooperating with Mercosur or with Canada, but against a vision that trade will have to prevail over all the other interests. So in order to assuage the fears of the European civil society, the Commission, by a stroke of genius, came with the idea, okay, we are going to do a bit of greenwashing. We will flesh out a bit everywhere sustainable development in the trade agenda. So again, as you're aware, the devil lies in the details. So if one looks at all the treaties I quoted yesterday, each of them contain Sustainable Development chapter, but more interestingly, they contain also a chapter on labor protection, on consumer protection, on environmental protection. And often these chapters are much more interesting from a legal point of view than the chapter on sustainable development. And so the idea underlying these chapters is that the trade partners are likely to reduce their production cost for the fact that the level of social security, the level of taxation, the level of consumer protection requirements, the level of environmental protection requirements is lower. And that was commented upon time and again today, is that the common playing field is somewhat disturbed in the global economy by the mere fact that some nations have not been achieved the same social or environmental standards or labor standards in Europe. But my remark is that even within the internal market, we are somewhat imbalanced. So it's much cheaper for Belgian companies to hire for 6 months workers from Bulgaria because they will be paid by the Bulgarian social security, and the Belgian social security wanted to be paid. And so it means that just the fact of importing for a short period Bulgarian workers will decrease the cost of the Belgian companies. But in so doing, the Belgian company doesn't hire Belgian workers. And that might compound the issue of workless persons because the Bulgarian labor force is cheaper. Why is it cheaper? Because the social security does not afford the same level of services and amenities than in Belgium. Belgium has some of the best clinics and hospitals in the world, some of the best doctors. But that has a price. And the price translates also in the cost of the services and the products exported from Belgium to Germany, to France, but also to the rest of the world. And so that's why the Belgian undertakings have always to achieve the highest level of productivity and the highest level of innovation. And the same with Switzerland. Switzerland has very high level of standards of living, excellent social security, excellent clinics, but this has a cost. And so it means that our economies have to be always at the cutting edge. And so the question is clear, how to reconcile extremely developed economies in concluding trade deals with nations that are doing their very best, such as India, to develop a smart way. And so these sustainable chapters are trying to address this imbalance regarding the common playing field that could be exacerbated by different labor standards, different standards and environments. And with Mercosur and the treaty with New Zealand, there were attempts to address the climate change, challenge in inserting some provisions stressing that climate change is the Paris Agreement is an essential element of these treaties. Okay, and so what? So the issue is whether it's possible to include sustainable development in the free trade treaties. The answer is yes, because the Court of Justice of the European Union, in one of its opinions regarding the incompatibility of EU treaty with Singapore, had to address the question whether sustainability could be part of trade or whether it should be excluded from trade. So if the court was answering in the negative, there could not be any sustainable chapters in these treaties. And so the rationale, the argument goes as follows. The fact that there is a breach of an obligation laid on in the sustainable chapter, that breach could constitute a material breach of the whole treaty, and the dispute settlement mechanism that was mentioned this morning with the case EU-South Korea regarding the absence of ratification of 2 ILO conventions by the South Korean legislature. That breach would actually lead to a dispute, and that dispute had to be solved in accordance with the standards, the procedural standards of the dispute settlement mechanism. And so the fact of breaching provision concerning social protection of workers or environmental protection could lead to the termination and suspension of the liberalization process. Well, as we have seen with the South Korean case, that has not been leading, as a matter of course, to the termination of the treaty. So it sounds to be a bit somewhat borderline. And so I come to the to what's going on because I think Mrs. von der Leyen, who is president of the European Commission, and Mr. Costa, presiding the European Council, have been arriving in New Delhi today, and the meetings with the Indian authorities will take place in the 2 coming days. So it's really this symposium is extremely timely. And what's really amazing, it's a trade in goods and trade in service between the EU and India. They've been increasing these last 15 years in spite of any treaty. So the question, what would be the added value of a treaty? Because the trade in goods and in services is increasing. And so among the arguments against the free trade treaty with Mercosur was that actually it won't increase so much the level of trading in goods and trading in services with Brazil, Argentina, Paraguay, and Uruguay. So there are many, I read many analyses, many reports stressing that they should not expect a very significant growth from this treaty. However, French Walloon farmers, Spanish farmers might pay a hefty price for the reductions of custom duties on South American products imported in the EU. So there are plenty of statistics I won't comment upon, but there lies the difference with Mercosur. The relationship with Mercosur, it's importing raw materials and agricultural products from the 4 Latin Americas, and then, on the other hand, to increase the export of German cars, German machine tools, Flemish Belgian chemicals to South America. So it could be seen as a win from an economic point of view, as a win-win situation. With India, the situation is different because if one looks at this picture, services, the trade in services is as important as the trade in goods. So we are facing different economic reality. And in particular, the Indian authorities succeed in not including in the negotiation food commodities with a view to protecting poor farmers. And these issues has been stressed time and again by Vasim Kumar this morning. That the level of despair among Indian farmers is somewhat significant. And I fully understand that the national authorities have concerns regarding this issue. And so, and that's a bit the complexity. The objectives of the forthcoming treaty is to remove technical barriers, is to diminish the custom duties, is to open up public procurement markets to foreign companies. So you can imagine that given the skills of several European companies, the opening of the Indian markets to French companies, to Spanish companies, might be a significant opportunity. At lunch or at dinner last night, we already talked about GI and basmati. So I don't know which concessions were given there and there, but there is also the idea to pursue a sustainable development. Again, the paradox, how to enhance sustainability when trade in goods and services is just rising the consumption of electricity, is rising the extractions of natural resources, is actually creating more pollution. And that there is no shortage of analysis, life cycle analysis, highlighting that in Europe, it's from an economic, an environmental point of view, it makes more sense to eat the apple or to eat the potato cultivated next door than to import the beans from Kenya or from Ethiopia. So it makes more sense, as far as I'm concerned, to drink Belgian wine or to drink French wine than to consume Californian wine, because also analysis highlight that the further you go, the more greenhouse gas being emitted, the more SO2 and other pollutants are emitted. And so if I looked at the different trade and sustainable development chapters, so you have this underlying creed to enhance a level playing field, to avoid that one of the parties on the losing side because the other parties is reducing the level of protection of regarding social security, regarding the working force. It's also about promoting the existing internal obligations. So it's not to prompt new negotiations for the forthcoming treaty or plastic, for instance, but also it's to promote higher standards, or at least to give some room for maneuver, some discretion to the parties to achieve higher standards. Of course, this is highly complicated, and that explains why all these provisions are so vague. So the doctrine has been distinguished three categories of obligation. Firstly, perhaps the most enforceable obligations, and that's the one that we discussed this morning with respect to the case South Carolina labor force protection case, is the minimum protection regarding mostly the labor force. And that makes sense because the ILO, International Labour Organization, based in Geneva, has succeeded in enticing its parties to conclude significant numbers of conventions aiming at protecting the labor force. When it comes, so the provisions of these treaties, it seems to me, are fairly clear. It's either black or white. But when FTA refer to environmental treaties, the pictures is not black and white. The picture is 500 shades of gray, because with the exceptions of the Stockholm Convention on COPs, the Rotterdam Convention on IPC for chemicals, the majority of the environmental commissions are rather vague. So the state parties should make an endeavor to improve the conservation of wildlife or to improve the quality of the seawater. And so what? Again, lawyers expect to have very clear definition, a very clear obligation to argue in court that the other party, the opponent, is not abiding by these obligations. That's one thing. Then, second category is non-regression clause, or un principe de non-régression. And finally, aspirational clauses that are apparently of no interest to lawyers. So let's take the minimal level of labor protection. I can send you a reference that I wrote from an Australian colleague on the matter, where we've been analyzing different provisions of different treaties. Big treaties concluded by the USA and by the It's freedom of association, elimination of all forms of forced and compulsory labor, effective abolition of child labor, and elimination of discrimination in respect to employment and labor population. So there are somewhat 20 conventions that are ILO conventions. I mentioned that for India, there is full prohibition of forced labor, of compulsory labor. That will be a case of the majority of the countries with which the EU is trading. Elimination of the discrimination is something much more complicated because the basic question is it de jure or de facto discrimination, or is it direct discrimination or indirect discrimination? And whenever it comes to indirect discrimination, it's much more complicated for the victim to demonstrate that it's subject to discrimination. But if one looks at the statistics, even in my country, women are not occupying the positions in the highest level of the undertakings. There are fewer women who are CEOs than men. It's even worse when it comes to law firms. About 80% of the partners of the main, the biggest law firms, they are males and women. So women occupy a much better position in kind of average law firm or kind of small 3-4 persons law firms dealing with family law, dealing with criminal law. So is this indirect discrimination or what? So the European authorities try to work a bit on the affirmative actions to avoid such a disequilibrium, but it's a complicated task. But the ILO convention, it seems to me, does not resolve all these problems. These problems are being resolved before the US courts, before British courts, before German courts, regarding the principle of non-discrimination that's usually enshrined in national constitution. But when it comes to the issue of effective abolition of child labor, cocoa has been mentioned by the previous speaker. The main producer for cocoa are two Western African countries, or even three, Cameroon, Ghana, and Ivory Coast. So I have programs over there, so I went for field missions. As a matter of fact, in the remote villages, maybe 10% of the children succeed to achieve primary school. Very few of them succeed to go to high school, but even if they succeed to go to high school, they don't go to the proper private institutions, so the education level won't succeed. They won't succeed to obtain a good result to enter university, so they are somewhat trapped. And the working force in the cocoa fields, they are children helping their neighborhoods. But it was the same just 120 years ago in Europe. If I look at 19th century paintings, I see everywhere teenagers and kids in the fields. And so how to implement such a prohibition, such an abolition in a trade treaty with the developing countries. So there is no intent on concluding an FTA or negotiating an FTA with Ghana or with Ivory Coast, but the question needs to be asked. So the second category is non-regression clauses. So they are aiming to ensure this playing field. And so the idea is to avoid that parties to the treaty will derogate from domestic laws in order to boost foreign investments. So for an American company to invest in Belgium, it's costly, it's more costly. So the American company will assess the quality of the services proposed by the Belgian authorities, the tax abatements, the quality of the workforce, the connection with the other countries. So Belgium is getting really a lot of internal investment, not for taxation issues, not for social security issues, but for the location and the clear connections with the other European markets. But the Belgian authorities could be enticed to decrease the level of taxation for companies, the level of social security, in order to bring more investment. But as a result, means that the level of protection of the Belgian population will diminish, and that raises significant constitutional issues. And so the idea of this non-reparation clause is to avoid that for a matter of competitiveness, the parties will reduce their labor protection level or the environmental protection level. And last but not least, there are other clauses that are aspirational in nature, where the parties commit themselves to seek a high level of protection, but this is completely undefined. And again, so one understands basic compliance with the minimum standards, and the ones of ILOs make sense. The environmental emission standards, except a few ones related to chemicals, they don't make sense. And then the idea to avoid the reduction of the level of protection, this is really difficult to enforce. After I'm coming and working in a country where this principle of non-regression is really taken very seriously by the Constitutional Court, so we have the highest level of implementation of that principle in the Belgian constitutional law, much more than in France or than in Germany. But it's difficult to assess whether the modification brought to labor law or to social security law is giving rise to a reduction of the level, because there are plenty of trade-offs. So what you're losing on one side, you're gaining it on the other side. And then the aspirational clause, this is vague aspiration that cannot be enforced in any dispute settlement mechanism. So that's one thing. And so one can imagine that there are many reports expressing the weakness of these sustainability chapters. So the further step is to assess the specific provision in the chapter on environmental protection, in the chapter on labor protection, in the chapter on consumer protection. But it's a very tedious exercise, and I don't have the time to do it. So quickly, given that these issues have already been dealt with by the previous speaker, these are the different unilateral trade measures touching upon value chains that were enacted these last 5-6 years by the European Union legislature. As a matter of fact, these measures are giving rise controversies in Europe, but also outside. So just to mention cocoa, that's falling within the scope of this EUDR regulations on deforestation. The Ghanaians and the Iberians whom I met are not very happy because the value chains must be controlled from upstreams to downstreams. And so it means that the complexity of the value chains when it comes to coffee or to cocoa, you might have 20 up to 25 different economic partners in the chain. And so the due diligence must be exercised throughout the chains upstream. And so this is a short list of different regulations that are impinging upon the control, placing obligation upon importers, upon European importers, and obliging them to carry out assessments of the impacts of their value chains. So firstly, the deforestation regulations that applies to different commodities and products, coffee, cocoa, palm oil, timber, and rubber. The biofuels energy directive that encompasses oil, palm oil, the batteries and waste batteries regulation from 2024 that covers lithium, cobalt, natural graphites, lithium, among others. The conflict mineral regulation that concerns mostly tin, tungsten, tantalum, gold. The corporate sustainability due diligence that has just been notified last December by the legislature, and CBAM. So most of these directives and regulations have already been mentioned by several commentators, so I'm not going to fully explain you the rationale of each regulation. But it seems to me that there is a red thread, and the red thread is that European consumers, European companies importing goods should become more responsible in assessing that throughout the value chains, the undertakings of the suppliers are not giving rise to forced labor or to child exploitation or to the violations of fundamental rights or to the deteriorations of tropical forests or to the or to giving money to militia waging civil war, like the case in Eastern Congo in Kiev. But the situation of CBAM is completely different. It's not about value chain. It's about maintaining the playing field in order to entice foreign companies exporting to the EU cement, kiln, to integrate into the price of their products the negative externalities. So this is somewhat a broad picture. Most of these directives and regulations are fairly recent. So there is no litigation before World Trade Organization so far, although a number of countries have been mentioning the idea to litigate, to take compensation for the restrictions that we face regarding these new legal arrangements. So controversies, but so far no litigation, and much hesitations in Brussels. The CSDD, the Swedish Corporate Sustainable Due Diligence Directive, entry into force has been postponed by a year, so from 2026 to 2027. EU DR on deforestation has been postponed twice. It was supposed to enter into force in this year, the 1st January. It was postponed last November, and it will enter into force only in 2027. So this really translates a source of malaise among decision makers, because for technical reasons, it will be a burden for national administration to control whether the importers carry out diligently their due diligence. It's also a burden for the companies because they will have to hire consultants to assess whether there is no child or discrimination among workers, no child exploitation in the middle of Ghana or in the middle of Ivory Coast. And to travel in these countries, I can tell you it can be sometimes challenging. I'm not driving at night in Africa, and I'm not driving to the drive. So sustainability is actually underpinning every legal arrangement. And then it obliges the EU to deal, or at least the undertakings in the EU to deal with complex supply chains. I come back to the issue of coffee produced in Ethiopia. It's 4 million Ethiopian workers working in coffee fields, And so it's a number of micro enterprise at the basis of the parent. And then the coffee is moving from one economic operator to an economic operator. And at the end of the day, when the coffee is sold in a supermarket in Germany, you get to number 25 or 26. With respect to the importation of coffee from Brazil, it's easier. It might be an average of 5 or 6 economic operators. And so it makes the export of coffee from Ethiopia much more complicated than the export of coffee from Brazil. So, and this globalized economies has been bringing us in an extremely complex world where so many chains, value chains do interact, and complex products are actually not the result of one single value chain. So the example of cocoa and coffee, it's an easy example, but if you take the case of electronic goods, then you have different substances. You might have 100 different chemical substances and 200 different minerals in a computer. And so that entails the control of different value chains. But the key question, and I think in law, at least the reaction of Belgian lawyers just take the problem at the root. What's the issue? What's the rationale of the legal arrangement? And so what's due diligence? I think, and that's the core of the problem. And the rest is just technicalities, just procedure, and that can be mastered. And so due diligence is complex from a legal perspective because it's an ongoing, proactive, reactive process through which undertakings will ensure that they respect human rights or the environment, the avoidance of contributing to a civil war throughout their value chains. And of course, this is a very broad definition encompassing thousands of different scenarios. And so it refers to the various steps companies will take to identify, to prevent, to mitigate, to address the adverse impact. So there is no a priori specification about what to do. So in case the risk is non-negligible, the companies must do something. It must somewhat prevent the risk, it must take action, it must mitigate the risk. Whenever the risk cannot be mitigated, then there might be more significant commercial consequences, and the import of the products in the EU might be called into question. And so, how to assess risk? The issue is impossible to provide for in the EU regulation assessment in accordance to EU legislation, because that will be European imperialism. That will be extraterritorial action. And for this reason, the chapters of the CSDD directives, they don't relate to EU legal acts, they relate to the implementation of ILO conventions or the different environmental conventions to avoid any litigation before the WTO. So I disagree when I am listening to arguments to say that the EU or these EU regulations have an extraterritorial impact. Economically speaking, might have some extraterritorial impact, but legally speaking, the obligations are placed upon European companies importing products and commodities from abroad, and the assessment must be made in accordance with insurance standards. And several of these insurance standards are already part of customer international law. So, it's fairly easy to criticize legal arrangements contrary to WTO obligation. There is some leeway, and so the European institutions have been somewhat cautious. I'll just take the example of timber. and I will conclude quickly. Everybody is talking about the new 2023 EUDR regulation, but this regulation is actually abrogating or will abrogate, because it will enter into force only on the 1st January 2027, the 2005 timber regulation. And so the rationale of timber regulation is that foreign wood can be imported in the internal market, provided that they've been legally exploited abroad. So the rationale is to avoid fraud, to avoid corruption, to reinforce custom controls, everything is based upon legality. Whenever the wood, the timber has been legally produced in the middle of Congo or in the middle of Cameroon, it can be exported to European countries, and it can be placed there in the market. And so it means that timber or timber products imported in the EU are subject to a certification. It's not an FSC certificate, it's a certification stressing that the timber has been legally produced. But now there's this new 2023 deforestation regulation that at the center of all controversies in Brussels and abroad. And why? Because it does not only encompass timber, it encompasses other commodities such as cotton, cocoa, coffee, oil palm, soya beans, and wood products. So it's the scope is much more. And in addition, the key difference is that the 2005 regulation focused upon legality, legal requirements, whether the importers comply with legal requirements. That has been quite effective, because most of the tropical wood import today in Europe is coming from exploitation that are managed under the control of the national authorities. And here it's a new standard. In addition to the locality, to legality, the exploitation of the timber or the exploitation of the cocoa or the coffee in tropical areas should not lead to deforestation. So agriculture is encroaching upon forests. The idea is that agriculture must be practiced in agricultural lands and must not expand in forest habitats. So of course, this is a significant change of paradigm. So that gives rise to resemblance. So if I come to the Renewable Energy Directive, that's placed obligation upon the imports of palm oil in Europe. So palm oil imported from countries where, or from places where a number of standards are not correctly applied, are subject to restrictions. And so as it was stressed earlier, Malaysia and Indonesia have been feeling complaint before WTO dispute settlement panel. So we should see the result. Conflict mineral regulations really plays an important role regarding the conflicts in the Sahel region, but also with respect to the conflicts in the Eastern Congo. And so again, this is a due diligence obligation. What's really new is the European Green Deals that led to the adoption of 160 legislation, among which a new regulation on battery and waste batteries. And given that Europe will achieve climate neutrality by 2050, there is a need to abandon fuel-powered cars in favor of electric cars. There's a need to shift the production process from gas-powered installation to electric power, and so batteries do play a key role. The issue is that the cobalt, the lithium, the nickel is not found in Europe, it's imported from the rest of the world. And so in order to avoid that the strive for climate neutrality finally ends up in serious deterioration of the environment in the high plateau at 4,000 meters, in the Altiplano in Chile, or in northwest Argentina or in Bolivia, the idea of the lawmaker is to place a due diligence obligation on the importance upon the producers of these batteries, upon the importers, the American importers of a battery in Europe, it will be subject to a due diligence application. And again, here is the issue is how to conduct such a due diligence, and the regulations is actually mentioning a number of guiding principles from the United Nations, from the OECD, and from other international organizations. But just this list reflects the difficulties to carry out due diligence. I won't comment upon the CSDDD. It has been modified last December. The entry into force is modified, and last but not least, CBAM, which was explained well enough by the previous speaker. It's a complicated mechanism, but frankly speaking, it seems to me that when it comes to a common playing field, it makes sense for the European companies not to produce the steel at the price that's completely unbearable, because in addition to the labor cost, in addition to the social security cost, in addition to the energy cost, in addition to the surveillance of the industrial operation, there is a carbon price. And so the carbon market is being tightened, it's increasing, it's covering more installation, and it's becoming more and more rigid. So it means that the price for the carbon emitted by a cement kiln or steel kiln will increase and increase. And so there is an issue of an absence of playing field, because the third countries does not apply any CO2 taxation, or does not set up any carbon markets. And so the aim of the CBAM is to install a playing field in order to oblige the importer of foreign cement or foreign steel or foreign electricity to integrate the carbon price in the price of the product, and this carbon price is related to the production process in China, in Japan, in South Korea, or in India. So it's really in order to adjust and to avoid unfair competition that will lead to the disappearance of killing things. So what one cannot criticize us for trying to be the best pupils in the class in achieving by 2050 the climate neutrality, because that's going to help the rest of the planet. The sacrifice we are doing in Europe will have a positive impact for India, for Bangladesh, for the Maldives. And then it's a bit easy to say this is a kind of unfair protection of the European companies. So the idea is really to place up an equal footing the price of the Chinese steel, or China doesn't export much Japanese steel, so Japan exports more steel than China to Europe so far. And so at least with carbon to place upon equal footing the price. But there will still be a difference of price, because energy costs are much cheaper in China. Labor costs are much cheaper in China than in France or than in Italy. So there will still be competition, but the competition won't be exacerbated by the absence of a carbon market in China or the absence of a taxation scheme in China. And so that's why, in order to avoid any discrimination between the two categories of products, homemade products and imported products, is that the price of the carbon market of the European ETS will determine the price of the certificates the importers of cement of Japanese cement will have to pay. This is complicated because we are part of a globalized economy, but it's a bit difficult to ask us our companies to commit our rate because we are the first. We want to be the first in the class when it comes to climate change. So that's my view. A number of foreign scholars do not agree, won't agree with me. That's the position that has been defended by the European Commission and its legal service. But it's easy to cry wolf and to say that everything we are doing is runs against World Trade Organization. So there are still, and that was discussed time and again during these last 2 days, World Trade Organization is also providing some leeways to the state parties in as much as there is no unfair discrimination of disguise discrimination. So. But to conclude the long session, thank you, and particularly we should thank Mr. Sayed Hashimi and Mrs. Mimi, you professor, for organizing in a very short time span this conference. And this conference is very timely because the leaders of the two blocks will start to meet in New Delhi for the 2 coming days. There will be announcement. And according to Indian journalists whom I read yesterday, or European journalists, the treaty won't be concluded. There's still many gray areas. There's still conflict zones such as CBAM. But it seems to me that the Indian authorities cannot expect that CBAM will be repeated because that won't be the farmers demonstrating in streets, in the Brussels streets next to my home. It will be the competitive because the competitiveness might be seriously jeopardized. Thank you very much indeed.
Now we extend our sincere thanks to Nicola de Serleser for the 3rd day for the lecture on European Union's approach to sustainability and its global environmental footprint. The session clearly explained how the EU seeks to address environmental harm arising not only from domestic consumption but also from global value chains beyond its borders. The discussion on the EU dependency on global resources, planetary boundaries, and strategic autonomy highlighted why sustainable development is a core objective of EU, firmly embedded in its primary law and reflected across different EU regulations and external policies. The explanation of sustainability chapters in the EU free trade agreements was particularly valuable in addressing concerns over unequal environmental and labor standards affecting fair competition. We especially appreciated to focus on the labor obligations under trade and sustainable development chapters, non-regression clauses to prevent competitiveness competitiveness-driven dilution of standards, and risk-based due diligence mechanisms aimed at ensuring corporate, environmental, and human rights responsibility across global value chains. The comparative perspective on sustainable development in trade relations, along with reflections on the growth and relevance of India-EU cooperation, is offered timely and meaningful insights. The thought-provoking policy questions raised during this session have opened important avenues for further discussions and reflections. It encourages the academic value of the symposium. Finally, the reminder that it is now the turn of the students to engage critically with this evolving framework is both motivating and inspiring. We sincerely thank the speaker for deeply engaging and enriching session. Thank you, sir. Thank you so much.
Our next speaker is an academic.
Yeah, I'll try. Existence awesome. After that, you join Sudarshan? Yeah. ഓക്കെ 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 എത്ര സമയം സാർ എടുത്തോളൂ സാറില്ല സാർ ഞാൻ വെയിറ്റ് ചെയ്യാം കുഴപ്പമില്ല ഓക്കെ 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 one second, sir. One second, sir. Once again, sir.
It's mute, no?
Hello.
ലാപ്ടോപ്പ് കേൾക്കുന്നുണ്ടോ? You speak?
Sir, Giri sir, can you hear me?
It got unmuted. But please allow the video also. Video also.
Video also. Allow video also. Okay, sir.
Okay.
Done. Okay. Okay. Just start. You just.
Our next
Hello.
speaker is an academic whose
Hello.
work
Hope everyone can hear me.
constitutional law, human rights, cyber law, and environmental governance, with a strong commitment to socially responsive legal education. Dr. Girish Kumar Jain is an associate professor in the Department of Law at the Central University of Kerala, Tiruvalla campus. With over 2 decades of teaching and research experience, he has earlier served at the Faculty of Law, University of Delhi, and continues to teach core areas such as constitutional law, human rights law,
Hello,
judicial
ma'am.
process, administrative law,
Hello.
and law and society at the postgraduate level. Dr. Girish Kumar's scholarship spans critically contemporary issues including cybercrimes, data privacy, environmental protection, federalism, judicial accountability, and the right to development. His research has been published in reputed journals such as The Hindu, Agenda, Kerala University Journal of Legal Studies, and internationally indexed peer-reviewed journals. He has also authored several book chapters on human rights, constitutional governance, human rights, and state civil society relations. Beyond academics, he is deeply engaged in legal aid, community outreach, and social justice initiatives, working closely with students through legal aid clinics and NSS programs, particularly among tribal and marginalized communities across Kerala. His pedagogical approach strongly emphasized learning by doing, case-based teaching, and practical exposure for LLM and PhD scholars. We are delighted to have with us a scholar who combines rigorous legal research with grassroots engagement and inclusive education. May I now invite Dr. Girish Kumar Ji to deliver his address.
Yes. Very warm good evening to one and all. I request the organizers to please project my PPT, which I had emailed
Sir, I hope you
yesterday to
can
the
access the
organizers.
audio and as well as the video.
Hope everyone can hear me and see
Sir,
me.
your PPT is being displayed here.
Please.
Is there any technical issues?
No, I cannot see that. I think it has not come.
അതിൽ മൊത്തത്തിൽ പോയി ആണോ ആണോ ആ ഓക്കെ വേറൊരു ഡിവൈസിനെന്താ പറഞ്ഞു നോ ഡിവൈസ് ഇസ് ഗോൺ any of the varieties of evaluation ഫോർട്ട് മാത്രമായിട്ട് എന്താ വേണ്ടിയത് ഫോട്ടോ വേണമെങ്കിൽ അതുകൊണ്ട് കാര്യമില്ല GP waiting shows.
Hello.
This meeting
Hello.
Sir, you may please start. Sir, could you please unmute? So could you please unmute yourself?
Gauri,
Sir, please unmute yourself.
Hello? Hello?
Sir, you may please start.
Can everyone see the slides? Hope everyone could see the slides. Hello? Hello?
Yes, sir, we can see
Hello?
it.
Okay, sorry for the delay from the side of both me as well as the organizers. And thanking the organizers for making me part of this August event. Myself, Dr. Girish Kumar, Associate Professor of Law from Central University of Kerala. The theme of the program running for the last 3 days had been very much attractive as it touches human life more than any other topic. So this is very important to have start our discussion from the great quote by Mahatma Gandhi. Everyone is familiar with the statement that the world, the earth has enough for everyone's need, but not enough for everyone's greed. The meaning of sustainability is imbibed within this statement that if we use the resources around us in a rational and truthful manner, the resources in abundance provided by the nature will be available for the future generation too. So starting the discussion with the sustainable development goals, the 17 goals in the 3 days program, I had seen many scholars had been discussing about the sustainable development goals at length. And we know every sphere of human life or every area or a field of human life directly or indirectly touching one or the other goals mentioned in this 17 sustainable development goals developed by the UN to achieve the goals by 2030. It was a kind of initiative which had not only to be supported but taken up and fulfilled by all the nations, whether powerful, resourceful, or economically wealthy or not. So, our discussion is focusing around how the concept of sustainability is applicable to trade relations. And in the 3 days program, many perspectives revolving around the trade, international trade, national trade, interrelationship between nations in terms of trade relations, etc., had been side is a humble attempt to see the roadmap or what we are going to encounter in the future of sustainable trade relations. I invite the attention of the audience to certain small points raised when we go to discuss the sustainability of future trade relations. It is governance models combining public regulation, voluntary sustainability standards, and corporate due diligence obligations. The scholarly professor before me had been discussing about the concept of due diligence obligations. It means it cannot be achieved. The goal of sustainability in trade relations cannot be achieved by governmental or state actions only. It can be achieved only by the cooperation of public regulation, voluntary sustainability standards obeyed by the people or whoever is engaged in trade relations, and corporate due diligence obligations. Due diligence obligations, we can see European unions, for example, corporate sustainable due diligence, sustainability due diligence directive increasingly release on internationally recognized standards. Such standards one can see, which is the part of ILA norms, still allowing corporate companies to demonstrate compliance through certified supply chains. So the trade domain is not a public playground for anyone can come and play by his own whims and fancies. There are certain standards, certain due diligence standards to be obligated, to achieve sustainability and workability in trade relations of future. This blending of law and voluntary standards reflects how sustainable trade governance is evolving in practice. We can just have a glance into such models or shift from the earlier models to the new models of sustainability in trade relations. We can see a supplier-centric compliance had been in place in trade relations earlier. This is being gradually shifted to a value chain-wide responsibility. It can be explained. This model moves beyond traditional auditing, because this is not about government comes and stopping you from doing business. Government is giving you that deadline. Government is giving you that regulation, etc., only. It is your own voluntary acceptance of the globally accepted standards of sustainability when you engage in trade actions. Means if you are there to engage in trade related business, you are giving the impression that you are ready to oblige the globally accepted standards of sustainability. That sustainability failures often arise from a varied set of novel practices. These actually to be in a very much careful manner by every player, not only the entrepreneur or corporate companies, the people who are engaged in the trade, like the workers, the public, and the governmental agencies, the people, the officials who work the governmental machinery regulating trade, etc. Such practices including purchasing practices, pricing pressures, and delivery timelines imposed by lead firms. So there are many such standards to be followed, and it should not be followed by a certain set of corporate or other companies only. It should be practiced in a greater or lesser or a required extent by every player who is engaging in trade practices. Then we can move to the concept of equivalence and mutual recognition. This is the principle of equivalence and mutual recognition, which is supposed to play a lead role in future trade relations. How can we see that? In an example, in the way some importing countries recognize national organic standards from developing countries as equivalent to their own, rather than demanding duplicate certifications. For following or going by an accepted standard, organic standard, practiced by some leading nation, by all other nations, can be a right model. This is a model of equivalence and mutual recognition. For example, India's national program for organic production has gained international recognition. Many countries do not go for separate or particular standards for their own. They just follow the standards followed by India as an international trade player. Such equivalence-based approaches preserve regulatory sovereignty while maintaining sustainability outcomes. You will not only produce profit and your presence in international trade, but you will also produce the respect for global sustainability standards. That is the result in equivalence, result if you go by the equivalence and mutual recognition model. Okay. We are moving a bit faster because of the time constraints. This is about future role players. I hope all can see the slides. Digital infrastructure, very important point. Now it is the era of AI technology. How this can be used for developing workable models to be followed by all trade practitioners for sustainability in future trade. We can see in agricultural value chains, digital traceability systems are increasingly being used to track products from farm to market. A very important advancement in technology, how technology can contribute to the growth of agriculture. And farm to market, it is tracked with the help of digital infrastructure. Blockchain-based traceability pilots in coffee and cocoa supply chains in Africa, for example, and Latin America have helped reduce audit duplication and increase transparency. So transparency is very important. Nobody can fake auditing or certification in this digitally advanced and supported model. This is enabling small farmers to demonstrate compliance without repeated physical inspections. Very good and very important for a faster moving of the market, be it agricultural market or industrial or textile or IT or whoever, whatever is the field. If digital infrastructure is used properly for certification and maintenance of sustainable contribute to the growth and development of for sustainability standards. When designed inclusively, these technologies, it is a very important area. Then environmental goals. We know we start from the sustainable development goals. So can we ask a question whether the trade players are duty bound to follow any environmental goal? Because they are not environmentalists. An entrepreneur or a corporate company cannot be compelled or forced to be become a protector of environment. But it should be ensured that their engagement with the trade relations in international or national level should not hamper the environmental goals fixed by the state or the civil society or the society public as a whole. So it should go in consonance. The trade practices should go in consonance with the environmental goals in place in a given system. It cannot be pursued in isolation from development outcomes. Development outcomes also we require. So one cannot reject development and embrace these environmental goals, or one cannot reject the former and embrace the latter. So there should be a balance. There should be a harmony between both the principles. Fair trade certification, for example, links environmental requirements with minimum price guarantees and community development premiums, and contributing to the environment, like through their CSR initiatives or any other. There is something called polluter pay principle we speak in environmental jurisprudence. If at all a corporate trade action results in a harm to the environment, there should be a compensation to be paid by entity which is responsible for that harm, and it should result in the repairing of that harm to the society. In several producing regions, this model has supported investments in education, healthcare, climate resilient farming, etc. Even if a corporate player is not doing any harm to the environment, it is the duty of the player to support the fields like healthcare, education, climate resilient farming, etc. out of the profit generated by the. Hope I can hear, you all can hear me. This process shows how sustainable trade can contribute directly to social and economic sustainability. Sustainability is not only a word related to environment only. It is like touching the economy. Economic sustainability is very important. It is touching the society. Social sustainability is very important. It is touching the polity of the country. The political sustainability is very important. So sustainability in our discussion is a sum total of all these aspects. Please come forward. Then public policy, how the governmental policy interacts with trade relations. Public policy too will play a decisive and enabling role in establishing a truly sustainable trade order. Effective trade models increasingly combine sustainability requirements with public finance and technical assistance. So corruption, we all know, had been a very, very, very weakening factor in terms of the development of a society. Maybe the corporate players might be making profit out of corruption, but it doesn't eventually contribute to the overall development of the society. So the digitally supported and transparent as well as truly or properly audited sustainability practices, sustainability models practiced by all players in international trade will ultimately result in the overall development of the society. A clear example is the European Union support programs for sustainable fisheries and capacity building initiatives. The EU model is linked to its deforestation-free supply chain regulation. Very important to note down. When we discuss about development, many people argue that if you want to have development, you want to bear with some harm to the environment, like deforestation, air pollution, water pollution, noise pollution. This all are incidental results of development. But in the discussion over sustainability, we should not allow it to happen, development to happen at the cost of the society's sustainability or at the cost of the environmental protection or at the cost of the society's overall development. Without such public intervention, sustainability standards risk excluding small producers rather than transforming trade practices. So, an ideal sustainability model should carry forward the interests of both large scale as well as small scale players. The small farmers, small producers, small scale industries are also to be protected and nurtured for the overall development of the national as well as international trade practices based on sustainability. Future of sustainable trade dynamics. We had focused in this presentation on how we can achieve or how we can at least enter into the roadmap, into the pathway for a sustainable future trade. The future of sustainable trade will not be shaped exclusively by North-South dynamics. One point, there is always a discussion surrounding or focusing on North-South dynamics on international trade. South-South trade also is generating its own sustainability framework. We should look into every nook and corner of the world. For example, regional initiatives within ASEAN and African continental trade discussions increasingly incorporate sustainability and labor considerations that reflect shared developmental realities. Very important to note down. Whether it is a big organization or a small organization, whether it is touching the bigger part of the international community or a small part only, these are irrelevant questions. Every small player is contributing to the growth of international trade. And the most important point is how this trade practice can be in consonance with the sustainability standards. These emerging models suggest a gradual rebalancing of norm setting power in global trade governance. Even small players can influence the large scale world trade order at some or the other way. We can see, in essence, the future of sustainable trade will not be defined by labels alone. Very important point. It will be defined by models that distribute responsibility fairly and recognize diverse regulatory systems. And it should align environmental ambition with social justice and economic development. We should always revolve this discussion around the concept of human rights. When we speak about development, how can we confine it to physical development of the infrastructure or the economic wealth of the nation only? We have to focus on the development of the human capital of the society as well. It aims, we can see sustainable development aims to meet present needs without compromising the ability of future generations to meet theirs. Very important point. Today's trade practices should not result in harm to the possibility of continuing the process in future properly. It underscores the necessity of balancing resource use with environmental conservation. So use and conserve, use and protect, don't misuse, and using, reusing, and realizing are the very important points. It highlights the disparities in resource distribution and the negative impacts of greed on development. For instance, overexploitation of natural resources such as deforestation and water depletion threatens both environment and future. Very important point. So, how the word sustainability is not a simple word which can easily be discussed in conferences and seminars like this. It is very difficult to observe and practice, and both by governmental as well as non-governmental players. There should be proper education and awareness building on how to be sustainable, how to practice sustainability. The development should be based on our concept about the importance of human capital too. So we have a moral and ethical duty to protect the earth for future generations, no doubt. This responsibility is rooted in various international agreements and declarations, emphasizing the need for sustainable practices and environmental stewardship. So finally, I want to remind my kind listeners that development should not be urban centric, should not be economically directed, should not be politically deviated. Development should always be mindful of the future of the society with proper position, proper situation, proper facilities for the survival of the mankind in the society. Development should have always, it should always have a human face. So, thanking for listening to my brief presentation, and I request for the audience for having comments rather than questions. I welcome more and more informations so that I can also enrich my limited understanding over the sustainable trade models for the future generations. Thank you.
Dr. Girish Kumar Jain is an associate professor in the Department of Law at the Central University of Kerala, Tiruvalla campus. With over 2 decades of teaching and research experience, he has earlier served as the faculty of law, University of Delhi, and continues to lead core areas such as constitutional law, human rights law, judicial process, administrative law, and law and society. Dr. Girish Kumar's scholarship spans critical contemporary issues including cybercrimes, data privacy, environmental protection, federalism, judicial accountability, and the right to development. Beyond academics, he is deeply engaged in legal aid, community outreach, and social justice initiatives, working closely with students through legal aid clinics and NSS programs, particularly among tribal and marginalized communities across Kerala. His pedagogical approach strongly emphasizes learning by doing, case-based research, and practical exposure for LLM and PhD scholars. We are delighted to have with us a scholar who combines rigorous research with grassroots engagement and inclusive education. And now, from the organizers, I would like to thank Sir for an intellectually enriching lecture. In his lecture on sustainability of trade relations, Dr. Girish Kumar offered a forward-looking and practically grounded framework for understanding how global trade governance is evolving. His emphasis on hybrid governance models, combining public regulation, voluntary sustainability standards, and corporate due diligence obligations, captured the reality of contemporary trade regulation. By drawing attention to the instruments such as the EU Corporate Sustainability Due Diligence Directive, OECD guidelines, and ILO norms, he demonstrated how international standards increasingly shape trade relations while still allowing flexibility through certified supply chains. Particularly insightful was his discussion on the shift from supplier-centric compliance to value chain-wide responsibility, reminding us that sustainability failures often originate in pricing pressures, procurement practices, and timelines imposed by the lead firms. His reflections on equivalence and mutual recognition, illustrated through India's National Program for Organic Production, highlighted how sustainability objectives can be achieved without compromising regulatory sovereignty. Most importantly, Dr. Girish reminded us that environmental goals cannot be pursued in isolation of developmental outcomes. His reference to fair trade models demonstrated how sustainable trade, when structured equitably, can contribute to education, healthcare, and climate resilient livelihood. On behalf of the organizers and participants, I extend our sincere gratitude to Dr. Girish Kumar for the lecture that was not only intellectually enriching but also deeply relevant to the realities of developing economics. His insights have added clarity, balance, and a strong human dimension to our discussions on sustainable trade. Thank you, sir, for your valuable time, thoughtful scholarship, and meaningful contribution to this symposium. Thank you so much.
I do express my overwhelming happiness for making me part of this. And I thank everyone, my patient listeners who had been here in the online as well as offline forum, in spite of the technical